Morning, everyone. If you please rise and join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. With that, I'm going to open the public hearing on House Bill 1050 and invite the sponsor to introduce the bill.
Thank you, Mr. Chair. Sorry for the delay. Over the summer, I met a New Hampshire mom who lost her only son to gun suicide. She's here today, and you're going to have the opportunity to meet her, and you'll have the opportunity to hear her story too. What I learned from our conversations over the last few months are three things. Devastating impact that a tragedy like this can have on the people who are left behind. The finality of an attempted suicide by firearm, which has a 90% success rate. And the fact that there are small but significant changes we can make to our laws to help people who are at risk for suicide, as well as their families. There are many people who experience suicidal thoughts. For some, the idea that they can buy a firearm is troubling, but at times the temptation to do so can be overwhelming. They may have no history of violence or self-harm, or they may have already tried to. They may be prone to severe depression. They may suffer from severe bipolar disorder. Many of them may have never been treated for mental illness. They may be fine now, but they know the ups, the downs, the mood swings, and the overwhelming urge to do themselves harm will probably be back. They also know that having a firearm in their lives will put them at risk for taking their own life. In most parts of the country, including New Hampshire, there's no ability to voluntarily add yourself to the federal background check system, so you can't purchase a firearm. What this bill would do is change that by establishing a voluntary firearms do not sell list for people who voluntarily wish to waive their right to buy firearms. The bill authorizes the Department of Safety to create administrative processes needed to establish and manage this list. It also establishes ground rules for handling these applications. For example, once an application is submitted, the Department of Safety will have 1 business day to transmit this information to the National Instant Background Check systems used by law enforcement agencies to identify people who purchase firearms. Once the person is on the list and in the system, they won't be able to pass a background check for any type of firearm. In effect, they become a prohibited person. Should a firearms dealer sell a weapon to one of them anyway, they would risk the same penalty they would for selling a gun to any other type of prohibited person. Meanwhile, a listed person who attempts to buy a firearm would also be subject to a penalty, but in this particular bill, we've written that as a violation level penalty rather than a misdemeanor to Class B felony penalty that provide to other people who provide false information. While my preference as a prime sponsor would have been to have no penalty and to avoid the risk of further harming a person who may already be in crisis, One of the first states to pass a law like this learned the hard way that unless the offense actually carries a penalty, it can't be entered into the next system. The state of Washington actually had to amend their bill later on so they could actually add people into the system. So for this reason, the bill has the lowest penalty available to us under our law. Also part of the bill is a provision that allows a listed person to apply for removal from the list at any time after having been on it for 60 days. Once the application for removal is received, the Department of Safety would have a maximum of 21 days to remove them from any federal or state firearms background check database or file. There are also safeguards in the bill that protect the privacy of anyone who appears on the list, who applies for the list, and who is removed from the list. What this legislation also attempts to do is to strike a balance between authorizing the Department of Safety to manage the list and having us in the legislature micromanage them. However, if you believe that there are key parts of the process that need to be changed or that need to be spelled out more clearly, I would ask for your help in doing that. To date, 3 other states, Utah, Virginia, and Washington State, have passed legislation like this. In Utah, the bill had the full support of the gun community. In Washington State, after some glitches with the initial sign-up process, they found it was helpful to amend the law to authorize healthcare providers to submit the necessary paperwork with the patient's authorization. Now, this is not part of the bill that's before us today, but I do want to make you aware that the sponsors of the bill told me that this change did result in a substantial uptick in sign-ups, so it's something we could consider. One piece of information I'll leave you with is a survey conducted of people at risk for suicide. When asked if they would sign up for a list like this, 46% of them said they would. The bottom line is, with this bill, nobody's guns are taken away. If a person decides to voluntarily give up their right to purchase a firearm, there is a process for them to get that right back if they decide that's what they want. You may ask, why do we need a bill like this when people can simply decide not to buy a gun? Let me read you part of an email I got from a doctor who supports the bill and survived a suicide attempt that didn't involve a firearm a few years ago. He writes, "By limiting access to high lethality means of suicide, we can provide people like me who struggle with suicidal thoughts with a tool to protect themselves in the event of foreseeable mental health crisis. As a person who has previously attempted suicide, I know that I am dramatically at increased lifetime risk for another suicide attempt." So what we have here is people in this situation, they know themselves and they know their vulnerabilities, and they know them far better than we do. They know there are times when they may not have total control over their emotions and their actions when it comes to doing themselves harm. By taking this simple step, we can take the quickest, the deadliest in our state, the most common form of suicide off the table for people who simply go the extra step of asking us to take it off the table. And with that, I'll take any questions the committee has on the bill.
Thank you, Representative. I see that other states have done it. What I'm curious about is the interaction with the federal laws. The federal laws allow this, that the FBI has allowed these states to put these names in and withdraw them with no problems?
They do.
And have you tracked the success as far as the number of people who have signed up for this in those various states?
Yeah, I think one of the issues, I believe, in Washington, D.C. was that initially, as anytime there's a change in the law, it can be difficult getting the word out to the right people. So one of the things that they did to actually make more people aware of it was a campaign to actually make more physicians in the state aware of it. And one of the things that they did to supplement that was they actually created a process that allows a physician to have that conversation with a patient, get their authorization. So we're talking about a wet signature type of an authorization, and then transmit the paperwork to the people in the state who in Washington State, who then send it on to the federal government. So that is not in this bill. It's something that could be in the bill if we thought it was a good idea. But I think the most important thing right now is just to get this process underway and to get something started. And if we decide perhaps there are better ways to do it, or there are ways we can supplement it to make it more effective, those are things that we can consider down the road.
Thank you. I noticed that there's a significant fiscal note. What are your thoughts on that as far as what's been given to us?
I saw that too, and you know, having been a member on this committee and having seen fiscal notes several times, I think one of the reasons why I wanted to make sure we gave the Department of Safety wide latitude is because I know that they're not awash in cash. No New Hampshire department is. Given the number of people who might be on a list like this, it might be something that could be managed. It could be managed with a database that needs to be set up. It could be managed with an existing database. It could be managed with a spreadsheet. There are a bunch of different ways to manage it. I'm a little puzzled at the need to add 2 employees to manage the process. I think part of the reason for giving them the flexibility is so we don't have to design something that's overly elaborate. We can design something that meets the need, hopefully with the personnel that the Department of Safety already has, but I'm sure we'll hear from them on that too.
Thank you. Questions from the committee? Representative, Reed.
Thank you, Mr. Chairman. A couple, 2 questions, if I may.
I'm sorry, could you speak into your mic?
So, once somebody puts themselves on the list, how difficult is it to get your name off of after the 60 days or whatever? And do people actually go back and take their names off? How, you know?
That's 3.
Okay, then that's it. Thank you.
Very, from what I've heard, and I actually have had conversations with the Washington sponsor, and from what I understand, very few people take themselves off the list once they're on it. But I think it's very important that we have a process in place for people who want to do that. So the way that the bill envisions that process working is there would be a separate application that would be available from the Department of Safety to remove yourself from the list. And the Department of Safety would have 21 days once that's submitted to make that happen. The thing I think that we try to avoid is in a lot of situations, you know, in these situations, we're talking about people who know they're prone to severe depression. They know they're prone to bipolar episodes. So these are people who, a lot of the time, I mean, they're just as functional as we are. I mean, there's no issue. But then they can hit one of those points. And the issue is when they hit one of those points, one of the things that they want in participating in, you know, in on a list like this is they want to be able to take their access to purchasing a firearm off the table. You know, their ability to do themselves harm by basically the most lethal means available. So there are processes that are, you know, that are in the bill that speak to that. There are also things in the bill that speak to the privacy rights of the people who are actually on the list. And one of the things I just wanted to make clear to everybody too is that if you're actually get on the list for this reason, nobody at a gun store would actually know why you're a prohibited person. They wouldn't know that you voluntarily, they wouldn't know the difference between somebody who's on this list and, let's say, somebody who is a convicted felon. You're both prohibited people, and that's the way it works. And because this is a federal list, this would pertain to other states as well, not just New Hampshire. So once you are listed, you would not only be listed in New Hampshire, you would be listed federally.
Follow-up question? Okay. Representative Pratt.
There's a lot of questions I have. I'm just going to ask a couple. The cost of $354,000 for 3 years. You talked about a simple spreadsheet. This is an awesome responsibility that the government and the gun owners are taking over. A responsibility that the person is not responsible for themselves. So, what is the liability if an error is made in this simple spreadsheet, if a person buys a gun that's not supposed to buy a gun?
the liability of a person who buys a gun.
That wasn't on the list because of an error.
Oh, who's on the list? So there is for the person who's listed who tries to buy a gun, it's a violation level penalty. So there is a penalty. We have to have that, or NICS won't actually let us list it in the system. For the dealer who would actually, so for instance, if a dealer sees that this is a prohibited person and sells the gun anyway, the same penalties would apply to the firearms dealer as if they would have sold a felon a firearm. So there's, and again, the dealer has no way of knowing. So that, and I think that's the way we want our law to work anyway.
Follow-up, Jay. Just one quick follow-up. That's not exactly what I meant. So say an error is made on creating this list. Somehow the person isn't on the list, the gun owner sells them the gun, and the person uses the gun in the wrong way. Now, who is responsible for that? There's got to be a liability if you're going to keep a list.
So you're
keeping
saying
people
if
from
a
buying
person
guns.
applies to be on the list and then somehow they're not put on the
Right.
list?
I mean, we're talking simple spreadsheets to the extreme of 354,000 for 3 years. So you're talking two different ranges of list here. If this list isn't done correctly, who is liable if somebody buys a gun and they thought they were on a list?
It's a good question. I mean, I think one of the things that you try to do when you establish a process like this is to, you try to create, and I think this is one of the things where it'll be important to actually get some feedback on realistically how quickly we can make some of these things happen. But once we actually agree to that, those are parameters that we really do need to stick with, because these are people, who are prone to incidents like this. So, I mean, it's a little bit of a kind of a what if question. Is this a possibility, that there could be some liability if the list somehow is mismanaged? I guess possibly, but that's really all I can say.
Okay, thank you.
Representative Prue.
So, not quite a question, but maybe a clarification for the bill. And I know this is going to sound cold and hard, but I just dealt with this in another bill that a relative of mine was put on a list that's on a website. And I asked, she actually passed, and I asked for them to be removed from the list, and there was no way for them to remove her from the list.
Which list?
So this is for the EMS board disciplinary list that comes up on a website, and her name is going to stay there forever. But I have a bill coming back to this committee that will allow the director to remove deceased people from a list, right? She can't come back for a job. So I would think that you might want to put a provision in here so the family could go remove them if they so desired. But right now it's on indefinitely, right? So even if that person passes away from old age, they can't remove that name from the list. It has to stay in the spreadsheet forever. And I wouldn't think that would be the way, but I just experienced it. It doesn't say they can take them off. They can't take them off.
And I think what you're saying is that it's important to have a process for removing people from a
Right.
list like this. I would agree.
Even not the person themselves, the family member or something else that wants that name removed out of documentation for whatever reason. there
You
should
mean
be a
if the
way.
person is no longer with us?
Right.
Yeah.
Okay, I guess I can understand that.
For clarification, Representative, if this is to be handled the way that normally people who are submitted for prohibited persons, the state should not be maintaining any list. It should be uploaded to the NICS system and then wiped from the state would be the optimal way, because I think we don't want the state maintaining lists of people. They submit it to NICS, it's in there. Once it's in there, it's not the state's responsibility anymore. Is that the way you understand it? Or do you understand it to be that DOS would keep a list of people?
I think for the purpose of making sure that people, I mean, part of it is the request to get off the list needs to be managed at the state level, and to do that, the state actually probably needs to know who's on the list, and maybe they can do that once actually, kind of thinking it through. They would probably be able to just get that information from NICS, just do a download. Who are all the people who are currently listed for this particular reason? So I don't think we really have an issue.
Representative Stone.
Thank you, Chairman Roy, and thank you for taking my question. Can you tell me under what current federal law guarantees they'd have to honor a state's request to remove somebody upon request from the NICS database?
Under what federal law? I can't tell you. I don't have my federal register in front of me.
Are you aware that NICS is solely the responsibility of the federal government?
Yes.
And you're also aware that the state basically has to make a request. They can't employ
I
their
am
desire.
also aware that there are people who are listed and delisted. We do that for protective orders and things of that nature. This is something that we have experience with as a state. It's something that the folks who run the NICS system have experience with as well. And I don't think it's a showstopper in this case.
Seeing no further questions, thank you for your test. Who? Representative Bolden.
I'm aware of short-term conditions such as being institutionalized for mental health issue that, while short-term, affect someone's ability to purchase a firearm forever. I think I understand the law correctly. So would this, if someone is listed and then delisted, that's short-term, does that play a role in their ability to buy a gun in the future? If they're, do you have any sense of whether it would be a consideration?
A completely voluntary process. So one of the things that's really important to understand about this is you cannot be put on this list by a relative, by a police officer, by a judge. Nobody can put this you can put you on a list like this except yourself. It's totally voluntary.
Thank you.
Yep.
Chair calls Kimberly Moran.
Hello. This bill allows a person to surrender their Second Amendment rights for whatever reason and be kept on a list. So if they attempt to purchase a firearm after voluntarily being put on this list, they will be unable to. We've established that. If a person is suicidal, they are most likely not in any mental health condition to make sound choices such as giving up their fundamental human right to self-defense. If a person attempts to practice their Second Amendment right while being on the list, they will be in violation. This bill is so poorly written, it doesn't even explain what the penalty actually is. But they'll become a felon if they, according to federal law, if they try to purchase a firearm while still remaining on this list. And New Hampshire currently doesn't have any way for a person to get off that list. It would cost them thousands of dollars to go the federal route to try to get off that NICS list. The gun control crowd is, once again, using suicide as an excuse to push more gun control. This bill is a self-induced red flag bill that doesn't provide mental health help for anyone. It's discriminatory in that it only applies to gun owners or potential gun owners, and if passed, could open a Pandora's box for Bloomberg's red flag bill to be implemented by simply changing legislation, a language in the legislation. Please vote inexpedient to legislate on this poorly written and poorly thought out bill that claims to be about stopping suicides when it will do no such thing.
Any questions?
Nope.
Seeing none, thank you. Chair calls, I believe it's Dr. Leonard Karn.
Yes, my name is Leonard Korn. I'm a psychiatrist who's practiced in Portsmouth since 1974. I represent both the New Hampshire Medical Society and the New Hampshire Psychiatric Societies in my testimony today. I serve also as chair of the New Hampshire Medical Society Subcommittee on Violence as a Public Health Issue. I want to begin by thanking all of you for your service and specifically for the time today to consider many bills related to firearm safety in New Hampshire. I'm sure you're all aware of the epidemic of gun violence in our country, both homicides and suicides. Our rate of gun violence is simply tragic and far surpasses the rates of other similar Western societies. I've testified here in the House for years on this issue, but unfortunately, the will to pass common sense gun violence laws still eludes us in New Hampshire. Although it is certainly true that laws cannot remove the risk of violence by firearms completely, many studies have shown that common sense gun violence laws can reduce the risk of gun violence substantially. In New Hampshire, suicide by firearms is tragically far too prevalent. As a psychiatrist, I've had 2 men who've shot themselves in their heads and died just in the last 2 years. HB 1050 is a relatively simple and straightforward statute allowing persons who self-identify voluntarily as at risk of harming themselves to be listed, again, voluntarily on the do not sell list. And that would prevent them from purchasing a firearm. The statute also, as described by Representative Muse, has a mechanism for being removed from this do not sell list. Please consider supporting HB 1050 so we can reduce somewhat the high rate of suicide in New Hampshire. Thank you.
Representative Reed.
Thank you, Mr. Chairman. In your opinion, who is more likely to use a gun in a suicide situation? Somebody who has a pre-existing mental health condition like bipolar or, you know, schizophrenia or whatever, or somebody in a crisis situation. So if somebody's in a crisis situation, are they more likely to use a gun as opposed to somebody with my point of the question is how effective a list would be if people who commit suicide are most likely in a situational crisis episode.
Well, some people who
Thank you.
have a mental health disorder recognize that at certain points they may be suicidal. And those people, and it might just be a small number of people, we don't really know, might agree to voluntarily give up their right to purchase a gun so that when the emergency episode occurs, they would be prevented, and they would know that they would be prevented from purchasing a firearm. So that would provide a level of safety.
Follow up.
So this offers minimal protection to the people that are really most vulnerable, the ones that are having a sudden crisis incident, correct? Do you see it that way?
That's probably true. In other words, this bill might save some people, but it's certainly not going to save everyone from suicide by guns.
Representative Selig.
Thank you, and thank you for taking my question. For people who, for whatever is going on in their lives, have suicidal ideation, does that tend to be a one-time occurrence for the majority of them, or is it something that, unless they're successful at committing suicide, tends to recur with, over time?
It tends to reoccur during crises when faced with a variety of stressors.
May I ask a follow-up? Thank you. And so for people who may have had a suicidal episode and survived it, who seek treatment and recognize that they're likely, is a bill like this in your opinion, more or less likely to save even one life?
It might, because if we have this bill available, let's say that I have a patient who has tried to kill themselves, maybe not with a gun, because most likely with a gun it would be successful, but if they've tried to kill themselves and then in therapy or treatment they recognize that this kind of crisis might occur again, then the mental health provider might recommend to them that they might get on such a list if we had one. And if they do, then when the next crisis, if it does occurs, they would be protected from purchasing a gun.
Representative Stone.
Thank you, Chairman Roy, and thank you for taking my question. In your professional experience, what are the other forms of suicide you've dealt with your patients?
All kinds of. I've been a psychiatrist for 50 years. All kinds of
Follow-up.
attempts. Drugs, overdoses.
Is there a percentage you could clarify of what relates to firearms versus drugs for suicide?
Well, suicide by firearms is, as has been mentioned, is about 90% effective in killing a person. Overdose is much less successful. People also can kill themselves by hanging. That's relatively successful. There are other means of suicide that are sometimes successful, but there's no mechanism of suicide that's more successful in succeeding to kill a person than with a firearm.
Thank you.
Representative Bolden.
Thanks for taking my question. I have an old friend who several years ago was in a car accident. When I went to visit him in the hospital, he's actually a former rep. I noticed a bruise on his neck and I asked him about it, and he said that I was the first person to notice, and that was from when he had tried to hang himself. And that's when I learned that he spent the prior 2 weeks quietly going through different methods of attempted suicide. First pills, then hanging. He woke up from the pills, the noose broke from the ceiling, and then he survived the car accident. He's pretty displeased with the results. So if someone like that was in your care and they admitted to you that they had been making an effort to end their lives but kept surviving, and you knew about this, the efficacy of suicide by gun, would you be recommending, like if this were law, would you recommend to such a patient that they voluntarily enroll before another episode?
I think I would certainly suggest that they consider putting themselves on the list.
Thank you for your testimony.
I have some copies of my testimony.
Representative Ars.
Good morning and thank you. I'm Representative Cyril Orrs, and I'm here to testify in favor of not going forward with this bill. You know, people forget history lessons, and it's a shame because gun control started in America against the black population. The Woodrow Wilson administration did not want blacks to have firearms. They wanted the Ku Klux Klan to have firearms. They wanted other groups to have firearms, but not the blacks. And historically speaking, we've seen this in Europe. And it wasn't that many years ago when the Jews were denied firearms. And then the Christians were denied firearms. And then the Lutherans were denied firearms. And we know what the result of that was. 20 million people that could not defend themselves, whether it was the ghettos in Warsaw or whatever it might be. We seem to keep forgetting history. And to have people put their name on a list like this, I can see where they would get coerced into this. I've had my mental health issues after living through 9/11, and then my post office was under the anthrax terrorist attack in New Jersey, when I'd get a bag of mail and it was burnt. And then I was working in London when the terrorists bombed the buses and subways. And then I don't believe in lucky rabbit's foots, but then I was in Binghamton, New York, when some guy from Thailand blocked the back exit door of the Civic Center where I was supposed to be volunteering and killed 13 people that day. So I've had my experiences, and I'll tell you what, anybody that is healthy and well and doesn't have a weapon at their disposal is really taking a chance, especially if you're Black and Jewish and Christian in this country as well as Europe. You know, we heard testimony that in Europe, you know, we are the most, we have the most mass, no, we don't. The mass shootings in Europe are just, they're about the same. What we have is suppression from the media. So a couple things I like to say in addition to that is, there's no such thing as gun violence. There are weapons and people use weapons, but people can use hammers, blunt instruments. When I worked for the Department of Defense, a buddy of mine who I worked with, he worked in London for about 6-7 years. Him and his wife were there. And he said, when they took away the weapons, they used bats, or they used hammers, or they used the 2x4. So we could do these things, but to put people on a list like this, you know, I can see where they'd be coerced in some cases, maybe not. But the thing you got to remember is, what if they forget to take their name off the list? Now you've made an innocent person into a felon if they forget. Thank you. I'll take questions if you have any.
Thank you for your testimony.
Thank you.
Chair calls Kathleen Slover.
Hello, I'm Kathleen Slover. I'm from Portsmouth, New Hampshire, and I'm representing myself today. My son is a proud member of the National Guard. He just went through boot camp this summer, and we are not a military family, so this was all new to us. I got a phone. I usually get phone calls from him on Sunday, and I got one on Thursday, and my stomach dropped. He said, "Mom, I'm fine. Somebody in our barracks died by suicide," because he had access to firearms. We've talked a lot about suicide rates among military personnel and veterans. And you would think, as a mother, I would be looking at what's happening in the Middle East, what's happening in the South China Sea. After that phone call, I went down the rabbit hole because I'm worried about my son. He has access to firearms, and he's in a profession, or he wants to go into the profession full time, which I am supportive of once he finishes his guard duties. But he's in a profession that any given year, it's 40 to 60% higher rate of suicide than the average population. So I went down the rabbit hole, and according to the U.S. Department of Veteran Affairs, veterans are more likely to die by suicide than non-veterans, 70% by firearms. 90% of those cases are not issued firearms. They are from personally purchased firearms. Researchers surveyed VA patients who had already received mental health treatment to assess their attitudes towards voluntary interventions to reduce access to firearms. They were surprised that 93% of the respondents were open to a low-intensity technique, such as talking about their gun ownership with their doctor. That's not coercion. They wanted to talk about their mental health issues and as they related to their gun ownership. About 75% of veterans in this survey also endorsed at least one of the more intensive options to substantially limit access to firearms, like the disposal of the firearm that they have or a VA program to store firearms on their behalfs. Voluntary waivers of firearms are one tool, like the options given in the researcher's study, to give power to those who know they are at risk so they can take a potentially life-saving action. When utilized in conjunction with other gun violence prevention measures, a voluntary waiver can help reduce suicide by firearm. As I went down the rabbit hole, I realized the Veterans Affairs Association, the military, the Army, they have extensive research and programs that military personnel and veterans can access, and I'm really happy that they do. My son said that when he came home from boot camp, he said the number one problem the military has is mental health issues, and they are working on it. As a mother, I have talked and canvassed from gun violence prevention measures, and I have talked to psychiatrists, gun owners across the state, and they believe in voluntary measures to help people. Just give them a tool. So I'll end my testimony with this. I feel like the military is doing their part. They really are. We're doing our part by educating people. I'm educating myself as a mother of a son who really wants to go full-time Army, and I'm proud of him and I want him to do that. I need you to do your part and help the community stay safe. And if this is one small measure, I think we should take it. So please support HB 1050. Thank you.
Thank you for your testimony.
I have the study here, so I'll just leave it.
Sure. The chair calls Jay Simkin.
Good morning, Mr. Chairman and members of the committee. Thank you for giving me an opportunity to testify. I usually have prepared testimony. I do not on this bill. And I've attended many such hearings over the years. I'm a federally licensed firearms dealer and have been so for a shade over 4 decades, 3 of them in New Hampshire. So I understand the law, both federal and state. And I have another competence that's relevant here. I'm an international economic consultant, and I've been that for about 20 years and a corporate international economist for about 20 years before that. So numbers have a certain meaning to me, and they should to you. I suspect that no matter what duras were applied to each of you, you could not come within 50 million of the number of firearms in the United States. The number as at end 2022, and normally you would have written testimony from me with specific data sources, was 474 million. That data point omits imports from 2021 through 2022. Those data have not yet been published. So that data point, 474 million, is a low-end data point. If I put in my guesstimate for imports for each of those 2 years, the number of firearms in the United States is certainly over 480 million. Thus, the concept that anyone can control something so numerous, many of which are highly concealable, is absurd. Gun control is foredoomed to fail. It doesn't matter unless, there's a qualifier, unless you are willing to enforce police state measures. So in Japan, there is no private ownership of firearms. There's an exception in Japan's laws for Olympic competitors, but they can't keep their firearms in their homes. So, obviously, the incidence of crime involving firearms in Japan is far lower than it is here. But I also point out that in Japan, police officers can enter any private place without a warrant. And further, that the conviction rate for prosecutors in Japan is about 99%. They don't bring cases unless they are going to get a conviction, and the rights that we have here, for example, under Miranda, Japanese don't have. So gun control can be made to work, but not here, unless you're willing to countenance police state measures. I've been to Japan several times. It is a very, quote, safe place. However, it's safe in a narrow sense. Globally, the downside to gun control isn't injustice, it is genocide. The proposition is very simple. It is not possible to murder hundreds of thousands or millions unless and until the targeted group and its sympathizers have been disarmed. That makes it easier for a genocidal politician, Vladimir Putin, president of Russia, is potentially one such. He is not yet. But he admires the Soviet regime, which was genocidal. So that when anyone votes for gun control, they're making a statement, either one, I don't care about genocide, or two, yes, I care about genocide, but it couldn't happen here. And a witness who preceded me talked about Jews in Germany. It wasn't the disarming of the Jews that mattered. Jews were 0.7% of Germany's population in 1933. It was the disarming of other Germans who, on 5 March 1933, when an election was held, 5 weeks after the Nazis lawfully took office, did not support the Nazis. They did not get a majority in that election, despite stormtroopers being able to attack other parties' candidates and other parties' campaign events. So the Nazis had to form a coalition to get a majority in
Mr.
Parliament.
Simkin, we have a lot of people to testify today. I appreciate the history lesson. It's all very interesting. But this bill relates to people putting their names
Okay.
on a list. Could you just narrow it down?
I will conclude there with the following. I'm a licensee. I've had 2 persons denied in the roughly 26 years we have had background checks. Both were denied for things that were fixable. I didn't know what the things were, but the screeners at the gun line here in Concord told me, have your customer call us. We will tell them what they need to do to get cleared. One did. The other I never heard from again. My point is that as a dealer, I don't want people coming to me who are going to be denied, and usually people contact me and I pre-screen them. What folks do not know is that once you are in the NICS system, good luck getting out. The federal authorities do not, and when I testify later, I will set forth the basis for what I'm about to say. The federal authorities do not have to respect any state's attempt to remove someone's name from the NICS system. We have no way to compel them. And anyone who knows differently, I'll be happy to be educated. Thank you, Mr. Chairman and members of the committee. I'll be happy to take any questions.
Thank you for your testimony.
Thank you. Stay well.
The chair calls UC Wang Terrell.
Good morning, Representative Roy and the committee. This is my first time testifying. I'll try to be quick and forgive me if I break any rules of decorum. My name is UC Terrell. I work at the University of New Hampshire's Carsey School of Public Policy, but I'm testifying on my own behalf today. I have some remarks, a request, and an image that's being passed around. It is a lot of folks have talked about this as a gun control bill. And this is never, I've followed this for a number of years as it's passed in other states, as it's been introduced federally last year, co-sponsored by two very conservative Republicans. And this is a bill about self-control. It's about the ability on good days to make choices that protect yourself on bad days. When you struggle with mental health, you struggle, in my experience, the worst part is not being able to trust your own mind. When the bad times come, there is total certainty that your loved ones will be better off without you. Your husband and your children will thrive after you're gone. You realize you're a burden to the world. It's hard to explain how clear that realization is and what a relief it is to know that you figured out what's really going on. Suicide feels like a way to regain control. So those are the bad periods. But even in the good periods, there's this niggling terror in the back of your mind because you know the disorientation is going to hit you again without warning, followed by that awful clarity of the abomination of your existence. The idea of voluntarily, temporarily, confidentially suspending your ability to buy a firearm would be a tremendous relief. As I mentioned, I've been following this model for many years as it passed in Utah, Washington, Virginia. It was introduced federally. It will be introduced in 12 more states this year, as I understand it. Nationally, it's called Donna's Law. And to be honest, many of the questions and concerns that have been raised have already been addressed. For example, in a peer-reviewed medical journal, a survey of inpatients and outpatients of an Alabama psychiatric institution, 46% said that they would sign up. Rather than speculation, we can learn from other states' experiences. And I am not an expert by it. If I'm both the person who knows the most about this in the room about other efforts, I'm happy to try and answer any questions you have. As I understand it, this committee has had recent experience with bipartisanship, with bail reform, with firearms reporting. HB 1050 is squarely in what New Hampshire stands for. We don't require that individuals wear seatbelts or motorcycle helmets, but we support individuals' choices with that government infrastructure, like the safety standards in those other examples that give individuals the power to choose to protect themselves. Again, it's about self-control, not about gun control. So I mentioned in the other states that have implemented a voluntary do not sell list to date, Utah was absolutely a bipartisan effort with public health officials, gun owners, and others on a coalition to move this forward. Washington wasn't initially, but in the most recent amendment, it passed with unanimously in the committee. So as a bipartisan effort, my fervent request is that Chair Roy, that others lend full-throated support to this once this hits the floor. Not only is it a good idea that saves lives in itself, but it also shows that we can come together around some of these issues. There's an image, an analogy from Greek and Roman mythology that captures what this bill means to me. I'm not sure it will mean as much to you as it to me, but I wanted to offer it to you in case it resonated with some of you. After the Trojan War, the hero Ulysses embarked on a 10-year journey by sea to get home. One of the monsters he faced were the sirens, beautiful creatures whose voices were so alluring that anyone who heard their song would jump overboard to swim to them and get dashed on the rocks. Ulysses knew this madness was coming. He asked his team to help him prepare, to tie him to the mast in the image that has been passed around. I ask you to look at this painting, really look at it, see the madness and the temptation that is so compelling, and imagine if his friends had said no, had told him that he simply needed to resist the compulsion or to talk to them first after the madness had already hit him. Our government, our society needs to help its people make their own choices to protect themselves. I urge you to advance HB 1050 with bipartisan support. And I'm here to answer any questions.
Thank you for your testimony. The chair calls Catherine Giddens.
Good morning, Mr. Chairman, and good morning, committee. My name's Catherine Giddens. I'm a lawful permanent resident. I'm also a local resident. I'm a responsibly trained gun owner, and I'm also the state representative for a women's national group called Women for Gun Rights, formerly known as the DC Project. And I just wanted to offer a couple of views here today. That to me, there is something deeply troubling about legislating an invitation for someone to abandon their inalienable right. I don't believe it makes any sense or it's possible to legislate love or care or community spirit. Someone who is in deep mental distress, such as, you know, if they're suffering from bipolar or schizophrenia. I'm not a medical professional, but I do know people who have suffered from that. And one of the common threads is an intense vulnerability to suggestion and also an intense paranoia. And I don't believe that this kind of bill would in any way be encouraging for someone to put their name on a list that a government controls. Someone who's in mental distress like that. I just don't see it happening at all. But on the plus side, there is a group already, and I want to tell you about them just briefly. They're called Hold My Guns. They're an amazing organization and one that needs a lot more attention. You can find out about them on holdmyguns.org. They have firearm storage. They do community outreach, crisis awareness training, they are huge mental health advocates. And if you will permit me just to read their vision statement, which I think is brilliant. Hold My Guns is working together within the firearms community, combined with appropriate community partner alliances, to raise awareness and promote a self-governance, non-legislative approach to addressing the prevention of suicide, theft, and accidental shootings. We will encourage educational and enrichment opportunities that approach stresses contributing to suicide risk, such as financial wellness, conflict resolution, and reacclimation after deployment, in a way that is a matter-of-fact, helpful, and in the stigma-free environment of partnering gun shops. Isolation and lack of connectedness, which are risk factors for suicide, are holistically addressed as gun shop customers volunteer shoulder to shoulder through community service opportunities available through Hold My Guns partnering gun shops. It is inevitable that those taking the time to serve others will in turn feel a sense of pride and camaraderie, knowing that they are working together to make a difference in their neighborhood. It's a beautiful group. There is not, so far as I know, a partnership here in New Hampshire with them. But I just want to say to the committee, and I want to let everyone here know that as the state rep for Women for Gun Rights, I will do everything now that I know about them to get as many firearms businesses and as many gun supporters, as many veterans to support this movement so that there are places for people to go, maybe to their local gun shop, maybe to the local shooting range. If they own multiple guns, they know people. They have a favorite spot that they go to seek advice, to look at guns. If they're interested in guns, if you've ever bought one, you know what it's like. You establish a place that you have a connection with. And the more places like these gun shops that are connected to Hold My Guns, there will be safe places. There will be anonymous places where you're not on a government list that you can safely place yourself if you have the mental capacity to, or if you have close connections with family who can support you through that as well, without fear of any doctor coercing you, without fear of any family member coercing you, or without fear of being tracked. I love this group, and I urge you to reconsider any approval of a legislation that would as I said, invite someone to give up a right that they have when there are other options. And I'm happy to take questions.
Thank you very much for your testimony.
Thank you.
The chair calls Donna Moran. You filled out 2 cards. Did you want to do 2 different bills or did?
No, Representative Muse did a card for me, and then he
okay.
thought it was gone, so I did another one. So
Okay.
just one. Thank you. Thank you for taking my testimony. This bill is named after another bill called Donna's Law. And Donna's Law is ironically named after a woman whose name was Donna Nathan. That was her name. I think it's ironic because I'm here today speaking in support of this bill, and my name is Donna, and my son, his name is Nathan. And on January 5th, 2022, Nathan drove to our local gun shop and he purchased a gun. And 30 minutes later, he was back at our home and he took that gun and he put it to his temple and he shot himself. Donna's Law, it probably wouldn't have saved Nathan's life. I'll be honest with you. However, this bill would save the life of someone like my daughter or myself. So January 5th, 2022 was the beginning of the worst days of my life. Rushing to the hospital, seeing so much of my son's blood on the floor of the emergency room, and then hearing the doctor say that my beautiful 21-year-old son, with this bright future as an engineer, was going to live his last hours in extreme pain. This is a trauma that no parent should have to go through. Nobody should. So you might say, well, I bet that was the worst day of her life. But it wasn't. As horrific as that day was when Nate took his life, was for me, it pales in comparison to the pain I feel every single day, knowing that I have to live the rest of my life without him. I would relive that day 100 times if I could have him back for just 5 minutes. I really would. And the pain that I feel every single day, it has brought me to thoughts of suicide. And I stay here for my husband, for my daughters, for my parents, because I could not make them live through another suicide. But the pain and the thoughts are there all the time. I don't want to end up putting a gun to my head and pulling the trigger. I don't want my family to find my body. I also know that if I was going to end my life, I would make sure it worked, because I don't want to end up worse off than I am now. And I certainly don't want my family having to have to spend the rest of their life taking care of me and depleting our entire savings, dealing with any medical bills I might have. So the quickest and most effective way to take my life would be with a gun. So I just want to tell you that I have not shared this very personal part of myself with literally anybody except my therapist. Nobody knows this except now, apparently, a movie thing that's going, and you guys and all these people here. I'm speaking publicly about this, even though it's terrifying, because I really feel that this bill is that important. The goal of this bill is to allow a person like myself to make a decision when they are in a calm mind and not in emotional distress. We already have a precedent for this when people create living wills to decide how long they choose to live before they become physically incapacitated. Donna's Law has a similar goal in that people can make an advance directive indicating they don't want to end their life with a firearm when they are emotionally incapacitated. So to protect my family and myself, I would put my name on a do not sell list. You're asking what kind of person would do it? It would be me. Just because I want to make sure that I wouldn't be tempted to go down to that same firearm dealer when I'm not thinking clearly. I don't want to have a moment of weakness where I can't see that life's not worth living, because it is. And this bill could literally save my life. There are so many people out there that simply are having a hard time living, and we don't know how to cope. And we sometimes feel that an escape is really just the best answer. And that's how my son Nathan felt. But when we get to that place, we need to be able to just take a breath and get through the moment. I know that there are other lethal means of suicide. I realize that you can take your life in a bunch of other ways, including, like someone else said, hammers and bats and all kinds of things. But why not allow people who want to make sure that they're safe from their own hand the freedom to make that decision for themselves? They can make that decision when they're in a safe state of mind. When somebody kills themselves, they're not only destroying their own life, but they destroy the lives of everybody around them. And we all know this. There's this ripple effect within the community. Nate's suicide was not in isolation. There were 4 previous suicides that year at the college he attended. His friend had taken his life a year and a half earlier. Passing this law would allow people to protect those that they love by giving them a chance to stay alive and get help. I hope I never need this law. I anticipate that I'm going to be strong enough, and with therapy, I'll get to a point where the pain just might not be that intense. But why not give someone like me the option to protect my children and my husband from losing me? Now, I teach American government, so I'm going to end with that. We all know that the Second Amendment gives us the right to bear arms. The Ninth Amendment is given less attention, but it gives citizens rights that are not specified within the text of the Bill of Rights. The Supreme Court Justice Goldberg, he wrote in 1965, he said, "The language and history of the Ninth Amendment reveal that the framers of the Constitution believed that there are additional fundamental rights protected from governmental infringement, which exist alongside those fundamental rights specifically mentioned in the first 8 constitutional amendments." This is just one of those additional rights. A right that a citizen should have is to be allowed to choose to not have a firearm as a source of temptation for a mental illness that they are trying to control. So often legislators are asking, what can we do to help people with their mental health? Something has to be done. Well, this bill is just one step in helping reduce suicides. So I'll take any questions if you have them.
Thank you very much for your testimony.
And I do have this. Do you want this?
Sure. Whatever you want to give us.
Okay, thank you.
Thank you for your testimony and sharing with us today. Chair calls William Riggins. Rogers. You could be, yeah.
I'll try to write better. I really will.
Yeah, I encourage block printing.
Thank you for your opportunity to speak today. I'm kind of nervous about it, but this sounds like a good bill. I mean, who could be opposed to doing something that might prevent a suicide? But it seems to me when I hear another bill, another law, I know it's redundant. We know that psychiatrists have ways to prevent people from going out and doing things. They can lock them up. We've got laws to prevent this. We don't need another law. And every time there's another law, there's administration for that law. And that administration costs money. If it's at the state level or the federal level, it's going to cost us some money. And we've already got the laws. Sure, I'm sure it's easy to get on the NICS list for prohibited persons, but I know it's, as others have testified, it's hard to get off that list. And you may trust, well, maybe nobody trusts a giant federal bureaucracy to be able to handle stuff like this. They're already overwhelmed with laws and things like that. So my concern would be, if you got on that NICS list, would be getting it off. And second of all, like I said, there already are laws that psychiatrists can use to lock people up and what they need to do. And they just don't do it. So before we pass new laws, why don't we find a way to enforce the laws that are already on the books, that are already there? We don't need more. The last thing we need is more laws and more government, and especially more federal government to administrate those laws. So I think other people have alluded to the same concerns about that. And it seems to me also, liability, it seems like an easy way for medical professions to put the liability back on the patient so that they can say, well, they chose to do this, rather than them having to decide to, have a backbone and say, okay, we're taking away your rights, because they can already take away their rights. Because every time I fill out a form for a background check, it says, have you ever been adjudicated nuts? I'm sorry, mentally defective or in a hospital or anything like that. So it's already there. And I know that you would not be able to get off the NICS list easily. I think that's all.
Thank you for your testimony. Chair calls Sam Hawkins.
Good morning, Chairman Roy, members of the committee. Thank you for the opportunity to testify today. I'll venture to be brief, as much has already been said. My name is Sam Hawkins. I'm the Public Policy Assistant at NAMI New Hampshire, the National Alliance on Mental Illness. NAMI New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted by mental illness and suicide through support, education, and advocacy. On behalf of NAMI New Hampshire, I'm here today to speak in strong support of HB 1050. When an individual is experiencing a mental health crisis, limiting their access to lethal means is a crucial step in preventing suicide and saving lives. I want to further emphasize the lethality of firearms in suicide attempts, and that firearms are the most common method used in suicide attempts, and suicides deaths make up the majority of all firearm deaths. HB 1050 offers a straightforward policy to help prevent suicide by putting agency in the hands of an individual. When folks who live with a mental health condition or regularly experience suicidal ideation are doing well, they may recognize their potential to be a danger to themselves in the future. Echoing the comments of a previous speaker, similar to an advance directive for healthcare decisions, this policy is a mechanism by which individuals can formally communicate their wishes for when their decision-making may be later impaired. In many instances, individuals already take similar steps to protect themselves in instances of suicide risk, such as asking their loved ones to take possession of their firearms or other lethal means when they feel their mental health declining. This bill is just one more tool in that crucial toolbox. HB 1050 is thoughtful and balanced policy that respects the agency, rights, and privacy of those who choose to utilize it, and it could save lives. For these reasons, NAMI New Hampshire urges the committee to recommend OTP for HB 1050. I can take any questions.
Thank you for your testimony.
Thank you. And I'll hand in my written testimony.
Thank you. Attorney Dean, did you want to testify on this bill? Chair calls Attorney Penny Dean.
Thank you for hearing my testimony, members of the committee. Good morning. And I would ask that this bill be ITL'd for several reasons. And just as an aside, those of you who might consider Hold My Guns or recommending them, I don't recommend them. All I can say is run, Forrest, run. I've had FFLs of mine say, have you heard about this Hold My Guns? I go, yep. probably shouldn't be interested. It's not what you think it is. Fear of being tracked and stuff, right up there. I have a Jewish friend who told me the tractate on divorce was written before the tractate on marriage. And I'm not Jewish, but I've been told tractates are these written guidelines for Jewish people. And so his point is there's never a problem put in the world from their perspective that the solution hasn't already been provided. And I think it's relevant to this bill because if the sponsors were truly concerned about allowing people out of the Hotel California, where you can check out anytime you like, but you can never leave, they would have written the process and procedure for getting off the list. Oh, we can write all that later. Let's pass this bill, and we can take care of all those things later. And the other thing that I would note is, with the exception of one testifier, there are all these studies that say 70 and 80 and 90% of gun owners support this or support that. I haven't seen the data brought forth to the committee, and I believe they don't exist, or if they did, they're not academically rigorous or not peer-reviewed. So I would just talk about the actual language of the bill. And just think about it from a dumb country girl's practical point of view, of which I consider myself, despite the fact I'm a lawyer. If you look at the first page of the bill and you look at line 10, any person enrolled on the list shall be ineligible to purchase or otherwise receive ownership of a firearm from a dealer as long as the person's name remains on the list. So what about, I'm a shooting instructor, and I sometimes say, you know, people who have lived in New Hampshire all their life, go to the New Hampshire State Police and run a New Hampshire criminal background check, comprehensive, for annulment purposes on yourself, and bring it to me before you enter the class, and that's as good as I can get that you're not a prohibited person. So what if, as in introductory classes, I supply firearms to all the students? Have I committed a criminal act here? But more importantly, what's going to appear on the New Hampshire State Police criminal record check? Because if they had been arrested, charged, or convicted of a variety of crimes, it's going to appear on that list, on the record we get from the New Hampshire State Police. But you're saying this can't appear. So this person, if they want to do that, they sign up for my class and come into my class. Now, maybe they aren't going to grab one of those guns and commit suicide, but maybe they just want to shoot. But it doesn't say anything about possession, per se. Receiving ownership of a firearm, but that's not possession. They're possessing them in my class. Next, we talk about NICS. NICS is not responsive at all. If you think, here's what I tell my clients. If you've tried to buy a gun and been wrongfully denied, and it was a handgun, just sign a release to me. I'm going to go to the New Hampshire State Police gun line. I'm going to show them the paperwork, and I bet it'll be fixed in no time. If you've been denied from the feds, you can write me a $50,000 check, and they go, whoa, $50,000 check? I go, yeah, $50,000 check, because we're probably going to have to sue in federal court. They're like, well, what? Here's an appeal thing, and here's this. I go, yeah, I understand all those things. Just because they write words on pieces of paper doesn't mean they work. Rarely going to work. The feds have a system, supposedly, that you can, quote, challenge a gun denial. I have unicorns in my backyard, too. And so, as a practical matter, it just doesn't work. And so we look at this. My other concern is, I think you're going to see situations where people are going to be forced, as they said, or coerced to sign these. I'm mother, and you want to live with me anymore, and I'm concerned about you, my adult child? Sign one of these forms or you're not staying home with me anymore. I'm a court. You want to go to jail? This is a choice. I'm not forcing you. You can go to jail for 5 years or you can sign one of these forms. No coercion here. Choice. I can think of all these things. I'm your therapist. I don't feel comfortable treating you unless you sign this form. And so you ask yourself, how many of these people are actually going to, quote, voluntarily sign this form? And I respectfully say there's a lot of room for coercion here. But then we talk about, well, we can be removed from this. But here's what's really important to me about the tractate for divorce versus marriage. The sponsors haven't prepared the forms, and the devil is in the details. Which courts are going to have jurisdiction to hear this? That's important. First thing the court's going to say is, Attorney Dean, show me the statute. Show me what gives me jurisdiction to hear this case. And so we're going to be going around like homeless people from knocking on every court door, and they're going to say, good luck to you. But the next thing is, we're talking 21 days. Let's say a person really wants their time period, but now how many days before they actually get their rights back that they, quote, voluntarily gave up? Well, first, 21 days after application's been received for removal. Now, then they have to have a hearing. But they have a hearing in what court? In where? And who gets to appear? And what's the burden of proof? Those are important things. And I can tell you, a judge is going to ask both sides to say, give me a memo on what's the standards? How do I decide these things? And that's only fair to the judge and make it easier to the court. The other thing is, what about landlords and stuff? And they say landlords won't know about this, but how do we know if someone is or isn't on the list if something isn't being printed on your Department of Safety record? And if it's not being printed there, does the Department of Safety have the software and have the capabilities to not put things like this on the record they're passing out? I don't know if someone talked to the Department of Safety about this. And that's a serious question that their computer geeks would have to work out. The other thing is, they talk about on page 2, line 1, establish and maintain the list. I thought there wasn't supposed to be a list. If you're putting in NICS, it's going to be integrated with the database. I can't imagine for anything that there's a separate list. It's all integrated. But the question is, NICS is pulled through every state in the country. How are we going to restrict what other states ultimately do with this data? We can't tell Utah what to do. And once it's out there, you can't unring a bell. You can't call back a bullet. It just doesn't work that way. So the question is, how are we going to protect these people? And worse yet, just like swatting people, what if someone swats someone and puts them on the list? If I'm a domestic violence abuser and I want to really fix that person's little red wagon, be it men or women, in addition to the fact abusing, I'm going to put them on the list. So now they go to buy a gun to protect themselves from me, and they're in a logistical nightmare here. So you have to ask yourself, how is that going to work? But then we go further, and if we go down the page on page 2, and we look at lines 12 and 13, within 1 business day of receiving an enrollment application, the Department of Safety shall submit identification information. What identification information? And again, I'm going back to the devil in the details. Will a passport work? Will a driver's license work? Has anyone talked to the Department of Safety about whether or not they have the manpower and which department is going to handle this? Because you're telling within 1 business day, that's pretty darn quick. And have submitted a form voluntarily, okay? And now here's the question. It comes to lines 15 and 16 on page 2. Database via the State Police Online Telecommunications spots for inclusion in the NCIC. So here's the question. When I get pulled over by the police and they run a spots thing, which is what they're going to do, probably the officer before he runs up to my vehicle, he's going to say, oh, this vehicle's registered to her. We're going to see if she's driving it. And all these things come up. Am I a wanted felon? Am I a bank robber? Is this going to come up that I've signed up to be on the list? And what if I'm open carrying then? He's going to say, wait a minute, you've signed up to be on the do not buy list and you're open carrying. How does this work? And so there's a lot of things that haven't been thought out and haven't been considered. What is that police officer supposed to do? Because maybe I said I didn't buy it, I already had it. I just signed up so don't buy any more guns. But the bottom line is that going to come up every time they run you? And does that mean that the police are going to treat mentally ill people differently? because I'm looking at like the big red sign on my head. Because what you're saying is this person is mentally ill or thinks they're mentally ill and not strong, and concerned about their own well-being, that they've signed this list. So how is that going to work in their being treated? But then we go to line 19 on page 2. Within 7 business days of receiving an application from a listed person to remove the listed person from the list. So they've got 21 days, then we got 7, we're at 28 days. So you're not wanting to get off the list. I'm predicting the Department of Safety shall initiate the process to remove the person from the list. I thought they were going to court. So maybe the Department of Safety is handling this now. Do they have a special administrative unit that's going to do this? Do they have a dedicated person? Is that person going to be trained? And these are serious questions. They might seem to be nitpicky, but if you're the person that gets signed up correctly or incorrectly, or you change your mind, how is this going to work? To remove that person from any state or federal list or database that would identify them as a prohibited person for the purpose of purchasing or taking ownership from a firearm or dealer. So the question you're going to ask, this says shall initiate the process. It doesn't say that they shall have completed the process within a certain period of time. What is there to initiate a process? If a person has asked to be off it, you've got 21 days, you've got 7 days. Why isn't it as simple as when you're convicted of XYZ, they put you in the database. It takes 2 seconds. You're now in. You get a DVP order against you, in the database, right in there. Why are you not switcho, changeo, taken out? The same way they would if they put you in. But here's the larger issue. I have had case after case where you annul things or have things that were improperly removed, and NICS sometimes will not remove them. And they're the big gorilla in the room, and they're like, make me. And so a person who's mentally ill or struggling, if they're truly on a road to recovery and change their mind, then the issue is how they're going to handle this. Are they going to have to fight with NICS to get themselves out? Okay, now, within 30, here's the next thing. This section shall not apply to a listed person who's also prohibited from purchasing or possessing a firearm because of a criminal offense or protective order. I think you better think that one through really carefully. And here's the reason. Protective orders are usually good for a set period of time, and they expire. So if a person wants to voluntarily put themselves on this no gun buy list, and you say, well, we're not going to put them in here because they're already subject to a protective order. I bet the protective order has an end date. And so you're not going to be solving your problem if you don't put them in there because the protective order ends. Now they're not prohibited. The other thing is people get their crimes annulled all the time. So you may be prohibited because you have a bunch of convictions, but if you get them annulled during the same time, this protective order for voluntarily no buy is supposed to be in place. Again, is that going to be a 42 U.S.C. 1983 or other charge against the government, massive lawsuits because they didn't enter it because they were told not to because of this? You have to think about that. Now, you're telling them about purchasing not allowed, but I think the most interesting part is found on page 3. And this is a case where it is absolutely word salad. And if you look at line 3, it says neither a voluntary waiver of firearm rights nor a revocation of voluntary waiver of firearm rights shall be considered by a court in any legal proceeding. That says shall. A judge is going to say, this tells me shall. Shall's mandatory. But you go down a couple, 3 lines, and it says lines 10, 11, and 12, any person appearing on the list with knowledge that person has voluntarily waived a person's right to purchase a firearm and who attempts to purchase a firearm from a federally licensed dealer should be guilty of a violation. Well, you're going to try and bring that evidence into court, and the judge is going to say, I can't consider it. And prosecutor's going to say, but it says anybody shall be guilty of a violation. And the judge is like, that's great. Show me other evidence you have, but I can't look at that because lines 3 and 4 says shall not be considered by any court. or shall be considered. I'm sorry. Neither a waiver nor voluntary shall be considered. Okay, so it says I can't consider it. We go down further. Any person, lines 13 through 15, any person who knowingly gives any false information, who makes any false statement with the intent of enrolling or removing another person onto or from the list shall be guilty of a Class B misdemeanor. So the question is, are these same forms not going to be allowed into court? So you say that you're going to keep people from essentially swatting other people, but if those forms are not admissible, how's that going to work? So that means really that a bad person can with impunity swat whoever they want because the evidence is not going to be admissible. I think you have to look at these proposed penalties and say, how does that work? If you look at lines 5 and 6, a voluntary waiver of firearm rights may not be required of an individual as a condition for receiving employment, housing, education, benefits, insurance, contracting, or other services. But it doesn't say other services. Again, it's not court. It doesn't say criminal convictions or criminal things. So I think that they still are going to be able to potentially say this, sign the waiver, or go to jail, sign the waiver, or pay a fine. But the other thing is, how would anyone know if you had a voluntary waiver? Because if they make you sign a voluntary waiver for receiving employment, let's say, I'll just go and remove it. You just wait the 6 months, you remove it. And so how are they going to know this unless somebody somewhere is telling them this? You know, this is supposed to be so confidential, but I think you have problems with it. And then it goes further, lines 16, 17, and 18. Any person who discriminates against a person on the list with respect to healthcare services, employment, education, housing, insurance, governmental benefits, or contracting because the person is on the list, how are they going to know the person's on the list, the supposedly confidential list? So I think there's all these mechanical problems that you have. But I think the most important problem is anyone who seriously puts forth something like this has got to do as supposedly the Jews have done. You put forth the solution first, which is how you get off the list and all the forms and how it's going to work, and then you talk about the list. I think this bill needs to be ITL'd for a million reasons, but even if one supported it, which I don't, I support an ITL, this is not the vehicle. It's not the mechanical, thought-out vehicle. It's worse than any Rube Goldberg you've ever seen. Actually, Rube Goldberg usually worked. They just worked weird. This is not going to work. This is going to keep you off the list forever. I'm happy to answer mechanical questions, but it's not well written or well thought out.
Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question.
I'm sorry.
So one of the questions that I had written down that I was waiting for somebody to answer, and you did, but I have a question with it, is on, what am I, on page 2, line 26. Any person enrolled onto the list shall not be removed from the list until 21 days after an application has been received for removal. Then you talked about the process for removal. So in theory, is there a timeline that the person would have to be removed?
They don't offer it in here. So they don't give you a time. If I ask to be removed in the 21 days, then they have the 7 days, but there's no penalties and there's no mandated time. Like it has to happen in 20 days, 30 days, 50 days. It's not in here.
So it could be in indefinite time. Okay. Thank you for answering my question.
No further questions. Thank you. Oh, Representative Stone.
Thank you, Mr. Chairman. And real quickly, given your profession, would you see this bill affecting those with limited financial means from ensuring their rights?
They would be affected the most because it breaks my heart. There are people with limited financial means call me all the time when their gun rights have been just totally decimated and they can't afford to hire me because even just an hour, I charge $300 an hour, which is actually very low for most attorneys. And they don't make $300 a week or $400 a week. They can't pay that. The the poorest among us are going to be hit the hardest.
Thank you very much.
Thank you for your testimony. The chair calls Jeffrey Fetter. Fader? Okay. Is this the last one? Again, the same one. Did he write bills?
Thank you. I'm Dr. Jeffrey Fetter. I'm a psychiatrist at New Hampshire Hospital, and today I'm testifying on behalf of DHHS in favor of this bill. I have some written testimony. I'm not going to read through the whole thing. I just want to highlight three particular points. Excuse me. One is that it has been shown in multiple studies that decreasing access to lethal means does decrease suicide rates. It's been shown in India in a study with poisons. The majority of suicides at that time in that place were done through agricultural fertilizers. When they replaced it with a different type of fertilizer that was less poisonous, people did not find other ways to kill themselves. There's a famous study where in an American city, there were two bridges. One was favored for people to jump off. One was not. They put fences so you couldn't jump off that other bridge. People did not walk 2 blocks to the other bridge. Similarly, in England, there was a study regarding the switch over from coal gas to natural gas. People used to mostly kill themselves by putting their heads in the stove. When they switched that type of gas to a less lethal gas, people did not find other ways to kill themselves. Denying access to lethal means is effective as a public health measure. Second is the short-term nature of suicidal ideation. About 20 years ago, there was a study where they interviewed people who survived jumping off the Golden Gate Bridge. And almost all of them said on interview that they regretted letting go almost immediately on the way down. People are not at their best when they are committing suicide, and it is an expression of their freedom to be able to have some control over those dark moments when they are at their best. It's almost like having an advance directive. We would never want to take away the right of somebody to make those decisions for themselves when they're not at their best, when they are able to think straight and make their wishes known. So for these reasons, DHHS is in favor of this bill as a public health measure. And I'll be happy to take any questions.
Representative Psychiatric.
Doctor, I have a question. That is this. How likely is this scenario? You are treating a patient who is suicidal, and you are concerned, and you say, look, I'm going to have you involuntarily committed based on what I've seen in our therapy sessions, unless you get on this list. That is a likely scenario, because I'm concerned about coercion. There are some well, never mind. That's all.
If I was thinking about involuntarily committing a person, this would not be enough reassurance to me that I would not involuntarily commit them. I would expect they could get a gun some other way.
Doctor, do you, in your understanding, if a patient you're treating tells you that they're suicidal or they're having violent thoughts about someone else, do you have an obligation to report that to the Department of Safety as it stands under our current statutes?
If I believe they have violent thoughts towards someone else, I have an obligation to take some sort of measure to protect that person. So if I can involuntarily commit that individual who told me about those thoughts, I don't have to notify the Department of Safety at that point. But if they have to be released from the state hospital for technical reasons or something like that, then I would.
I was thinking more if you were just under your license or treating someone outside of the hospital, for example, in a therapy session, and they said to you, you know, I'm thinking I'm probably going to kill myself tonight, or I'm going to kill my mother or someone tonight. What would your obligation be under the law currently?
So it's basically still the same. If I can have them committed at that point, that's considered the safer thing to do to contain the dangerousness. If I can't have them committed for whatever reason, then there's a rule called the Tarasoff rule that requires a mental health professional to notify the potential victim or the authorities to protect that person.
Thank you. Seeing no further, Representative Salig.
Thank you, Mr. Chair, and thank you for taking my question. Do you see this bill as being able to save lives?
I think there's a good chance that it could.
Representative Pratt.
I was a fire chief and a fireman in a town for 42 years, and I've seen 14 different suicides. Only 2 of them was guns. How does the people choose what they're going to use? And if we block one way of doing it, what's going to prevent them from using another way?
So that question has been studied, and in multiple studies that have been replicated, denying access to one lethal means, and it's been studied in firearms as well as the kind of strange methods that I mentioned, denying access to lethal means does decrease the chance that someone dies of suicide.
All lethal means? All lethal means?
Well, I mean, the most lethal means.
Okay.
So if, for instance, the coal gas is considered a highly lethal means compared to natural gas. So just switching that over, people did not decide, okay, I'm going to slit my throat or hang myself instead. They have an idea of a certain means, and throwing any obstacle in their way tends to make them change their mind. I've had patients tell me, I stood on the bridge, the patient I can think of who jumped off the Quechee Bridge, told me that if someone had just walked along and said, "What's wrong? Is there something going on?" I would have just turned around, but no one did. It's hard to commit suicide. You throw any little obstacle in their way and you might change the path.
Thank you.
Yeah.
Thank you for your testimony.
Thank you.
Chair calls Dr. John Hink.
Good morning. My name is Dr. John Henk, and I'm representing the New Hampshire Psychiatric Society. The New Hampshire Psychiatric Society supports HB 1050 to potentially reduce the risk of suicide and gun violence in individuals who are at risk. I have worked as a psychiatrist at New Hampshire hospitals since 1995. I have worked with many patients who did something very dangerous with a gun towards themselves or others when in an episode of severe mental illness. Many of those patients respond very well to mental health treatment, and they later regret their dangerous actions, which resulted in serious consequences. HB 1050 would enable those individuals to try to be proactive and help prevent this type of dangerous situation from happening again in the future. In closing, the New Hampshire Psychiatric Society supports HB 1050 as a way to improve public safety and decrease the risk of suicide and violence in individuals who are at risk. Thank you.
Thank you for your testimony. Who now? Representative Newman.
Yeah, I just want to ask a question about some of the testimony we heard earlier, and I can't tell you exactly what it said, but I'll try and paraphrase. That there were no peer-reviewed studies that show the various how firearms are connected to suicide.
No, I think to be clear, I think the witness said there's no peer-reviewed studies or with related to what percentage of gun owners supported this legislation, I think was what the comment was. But you may ask that question.
I'll withdraw my question. Thank you.
Thank you, Doctor. Anyone else?
Thank you.
Those wishing to testify on this bill was not testified on this bill. Seeing none, I hereby close the public hearing on House Bill 1050. We're going to be in recess for 15 minutes. Okay, opening the public hearing on House Bill 1186 and invite the prime sponsor to introduce their bill.
Thank you, Mr. Chairman. My name is Representative Jason Jamin. I represent Rockingham District 40, which is the towns of Hampton and Seabrook, New Hampshire. Today I introduce House Bill 1186 FN, and I'll get into the bill, but I want to give a little history here of why this bill is before the committee today. In 2018, the House of Representatives, Senate, put a constitutional amendment before the voters, and it passed, giving them, the citizens of New Hampshire, the right to privacy. That same year, a columnist in the New York Times placed a column explaining that the federal government, because they're restricted from doing a firearms registry, should attack firearms by going through the banking system. So Amalgamated Bank approached the ISO, which is the International Organization of Standardization. You've all heard of ISO 9000 certification, that sort of thing. And the ISO, based upon that petition, introduced a MCC, which is a Merchant Category Code, in September of 22. About that same time, after it was announced that they would be doing that, the New Hampshire Attorney General joined with 23 other attorneys general across the country and sent a letter to Visa, American Express, MasterCard, condemning this move to do a firearms registry, quasi-firearms registry via private industry. So in March 23, after several houses of representatives and senates across the state, across the country, introduced legislation to stop this type of registry, the Visa, MasterCard, and American Express said that they were going to pause their plans. So I'll talk about the states that have instituted this, a very similar bill, similar law to what I have before you today. It would be West Virginia, Idaho, Mississippi, North Dakota, Florida, Montana, and Texas. I understand there are 5 other states in the union this year that are contemplating a similar bill. So the first part of the bill is the definitions of who this would affect, what a firearms code is, which is actually a merchant, an MCC under the ISO. I'm using big words. If you have questions for me, again, I'd actually ask that you ask me during the executive session, because there's a lot of people here that want to testify on the bill. So this bill would prohibit the use of those firearms codes in the state of New Hampshire. And the third part is it places it before the Attorney General to investigate the violations of this law and the ability of whoever violates the law 30 days to come back into compliance with the statute. If they fail to do so, then there's a civil penalty. And there is a process in the civil court to appeal that. If it's passed by the House, Senate, and signed by the governor, this will take effect in January of 25. I just want to close in saying that if I go to Kittery Trading Post, a Bass Pro Shop, or one of these other places, you may not know, but I'm an outdoorsman. I'm an Eagle Scout. I like to go out and do things in the outdoors. If I go to Bass Pro Shop and buy hiking boots, a backpacking tent, a frame pack, hiking poles, Black Rifle coffee, Gore-Tex jacket, rain pants, and a kayak, and I get to the register and I use my credit card, and it comes up as a purchase of about $4,000. I don't want somebody mistaking that I went out and purchased a firearm. I don't want that discernible to any other sporting goods category. So basically, the bill is telling these places that they cannot use a a code specific for firearms, that it can be general merchandise or sporting goods, and that alone.
Thank you. And you've asked questions to be held for session. So
yes, sir.
Thank you for your introducing the bill. The chair calls Justin Davis.
There we go. Honorable members of the committee, my name is Justin Davis. I serve as the New Hampshire State Director for the National Rifle Association. I'm also a gun owner here in New Hampshire. I appreciate the opportunity to represent our members' belief that this bill should pass in New Hampshire. As Representative Janvrin so eloquently said, in 2018, the New York Times published How Banks Could Control Gun Sales When Washington Won't. The article argued that major banks and credit card companies could set new rules surrounding merchant category codes to track and potentially hinder firearm purchases. Just 4 years later, the International Organization for Standardization announced that they would create the MCC code on the purchase of firearms and ammunition. Now, the important thing to understand about this MCC code is that it's not just for if a firearm or ammunition is purchased, but if it's at a firearm retailer, right? So, like Representative Janvrin said, I go to LL Cody or Bass Pro Shops and I buy a tent, new boots, coveralls for my hunting. That would show up as a firearm purchase, just like it would buy if I went and bought a new CZ612 for duck hunting, right? So when you have these high level purchases or these large amounts, it could flag for the Department of Treasury or that credit card company, well, is this person a threat? They're buying large quantities of firearms. This creates a major concern for privacy, mainly because these purchases should not be flagged where a credit card company can deny these purchases because you want to make a firearm related purchase. And it also serves as a quasi gun registry, right? So we can see where myself, every firearm I purchased or every time I went to these gun stores, the government can then look at what we've done. So in a time where data privacy is paramount to the people of New Hampshire, I think that this is something that's certainly needed. And even as Representative Janvrin said, Visa and MasterCard and these major credit card companies have already paused this because there are major concerns about the facility of that. So happy to take any questions you have, but the National Rifle Association is strongly urging you all to pass this.
Representative Muse.
Something I'm trying to understand is how information that's recorded on your personal credit card can become public or can be disclosed to people, outside of you and your credit card company. So the way I understand merchant codes, and I actually appreciate them and my own credit card statement because they show things like charitable contributions and they can help me get organized for tax purposes and things like that. So I'm a little confused over how privacy rights might be violated and where the concern is coming from here.
Yeah, absolutely. So there's two prongs to that. One is that it can be flagged for the Department of Treasury if there's large purchases made under these codes. And I'm happy to provide some more of that information for you. I don't have it readily available from you, but I'm happy to provide you that information. Secondly, I think as we're all aware, there's a lot of data leak issues, a lot of stolen identity issues. So having that information become public for firearm purchases that you make, I know as a gun owner, I don't think I want the general public to know all the purchases that I make at certain retails for whatever, whether it's for hunting, whether it's for an actual firearm or ammunition purchase. I think there's a very real concern for people about the data privacy, not just in-house in these places, but for that to become public.
Is there some type of a federal law that authorizes the credit card companies to share information with the Department of Treasury?
I'll have to look at that to get a success statute for that, but I'll provide that for the committee.
Thank you. See no further questions. Thank you for your testimony. What bill you mean? Yeah, looks like 11. I think it's 86. Leonard, is that you again? Oh, yeah. It seems your handwriting is getting worse between bills, Doctor.
So as I said before, I represent the New Hampshire Psychiatric Society and the New Hampshire Medical Society, and I'll just be brief. Gun violence is a major epidemic in our country. It is the position of our medical societies and the American Medical Association that firearms be registered and firearm operators be licensed. So we have information about cars and ownership of cars, and we need to have information about guns as well. And I realize that people are in favor of gun rights are not in favor of these types of information being available but for people who are interested in gun safety, registration and knowledge about who are purchasing guns is important. That's all I have to say.
That's, you said enough. Thank you very much.
Thank you.
The chair recognizes Penny Dean.
Thank you, Mr. Chairman and members of the committee. My name is Penny Dean, and as in all these, I represent myself and myself only as a private citizen. And there are banking and credit card companies in this country that discriminated against gun owners. And the most famous is probably Bank of America. And Bank of America told Macmillan Stocks several years ago, and Macmillan, I would note, makes stocks on high-end competitive firearms. That was one of their main things. After being a customer for 20 years, Macmillan was told, take your money and get out of our bank. And bless his heart, he made that public. He took the letter that was given to him and spread it all for all gun owners to know that you probably shouldn't do business with Bank of America. And when Bank of America called him in and said, we don't want your money in your business anymore, he's like, why? We pay all our loans. We've had a great banking relationship with you. What's the problem? You sell guns. He says, I make stocks for custom guns. I don't per se sell guns. Didn't matter. It was gun business. And they looked at it as bad money because of guns, and they simply didn't want his business. So how many of us could see our banking and our credit cards shut down because it's going to be a gun purchase, because it's coded as a gun purchase? How many of us would see credit cards denied because when they run a credit report, they're going to say, you've bought a lot of guns because we have code numbers here and you shop at gun stores. And if anyone thinks that type of discrimination doesn't appear all the time, I'll respectfully say it does. And it's as insidious as racism was years ago. It's just a little becoming more and more blatant every day, depending on which party you belong to. So this bill is absolutely necessary. And as the representative noted, he sees codes on his credit card bill. And more of us are seeing those more and more of where you've bought the purchases. And so what happens when your credit card company happens to be the same one that your employer is? You have a employer's credit card, your own credit card, which you diligently keep separate. What happens when the credit card company mistakenly sends your personal bill to your employer or transposes the numbers in the accounts? And now your employer sees how many guns you buy. For some people, that could be a job killer, even though it has nothing to do with their job. There's a million things that how about when you go to apply for an apartment, they want to see your most recent credit card statements. You're going to see all those codes on there. So there's a million ways in which this can harm a private person. And so this bill I would strongly recommend is ought to pass because it is about privacy interests and civil rights. We should be treated, as they say, the content of our soul, not anything else. And how much money that we spend on any particular thing, be it jewelry or guns or cars, should be nobody's business. And so the bottom line is, and we shouldn't be treated differently by these companies because of how we choose to spend our money. And I think that could happen more and more and more because more and more gun owners have talked about Bank of America and certain other companies that don't want our business. So I'm happy to answer mechanical questions or practical questions, but I would ask respectfully that you consider this as an ought to pass, necessary to pass.
Thank you for your testimony. Chair calls Representative Cyril. Or Cyril Ward. Wards.
Difficult name, isn't it? Thank you, Mr. Chair. It's Ors. Thank you for hearing me once again, committee. I testified a little earlier today. And I just wanted to reiterate the fact about a little history. And when it was mentioned earlier here in testimony that gun registration is necessary, well, we know what happens in Europe in the 40s and 30s with gun registration. And the same goes with credit card information. When the banks are allowed to take credit card information and screen people, whether it's for business or whether it's the fact that they buy weapons or weapon-related materials, ammunition, whatever it is, the last thing we want in a free society, in our republic, is to have our privacy taken away by the government or anyone. And so I would like you to take that into consideration as we move forward on some of these bills. The last thing we want is Big Brother or somebody else looking over our shoulders and then going to tell us what to do or come after us, as we have seen as the DOJ and different organizations within our country become politicized. Thank you very much, and I'll take questions if you have any.
Thank you for your testimony.
Thank you.
Anyone else wishing to testify on this bill who has not? Go ahead.
Thank you, Mr. Chairman. I apologize for not having the card handy. I just wanted to quickly state that there are two purposes for having that code that identifies, gun businesses. The first one is to create a gun registry, which is not a policy that should be followed by anybody, since you'd be keeping a registry of people who did nothing wrong, and it was used in the past to harass them. I want to remind you that in California, there was a accidental leak of all the people on the gun registry who then ended up being harassed. I don't think we should keep that information. The other purpose for this, which is really the real purpose for this, is to treat gun businesses, gun firearm-related businesses, the same way the feds treat the weed businesses, by cutting off their bank access. One of the huge risks of having a marijuana business anywhere in the US is that no banks will do business with you. You got to deal in cash, you got to have armored vehicles and all that, because the federal law still says that doing business in there is illegal. There have been previous attempts from the feds to do exactly that unofficially, but they were stymied because they couldn't quite track who to cut access to. So now they want a code to make it really easy. Now, there was a question asked on whether this data would be available commercially. If you look up Senator Wyden's recent press release, he's talking about the fact that the NSA has purchased a massive amount of commercially available information to get around the Fourth Amendment and basically search your information without a warrant, because they can buy that from brokers. If you read the press release, it includes purchase information. Yes, that is available. That information is on sale if you want to purchase it. And if we think that having a bank code for firearm merchants is a good idea, would you feel that having a separate banking code for abortion providers would be appropriate? Would you see concerns then in terms of what would that do to the privacy of the people that use those services? They're not doing anything wrong. They're not breaking any laws. Why would I keep track of them? I want to assure you that I would oppose efforts to keep track of both those types of people or of anybody else who is doing something illegal, and the government has no business keeping track of them. I really appreciate the time, and I'm available for any questions.
Thank you. I have a quick question. The psychiatrist testified a few minutes ago from the New Hampshire Medical Association, and he said that they felt that there should be a list, a registry of people that own firearms and the firearms they buy. Do you think that we should have a list of people who go to see psychiatrists and we keep that for safety purposes?
I absolutely do not think the government should keep that list, because we already have legislation saying that there is a certain amount of mandatory reporting from the medical service professionals, but it should be a very high threshold before people end up putting on a registry that can result in them losing constitutional rights. And while I respect the professional opinion of a psychiatrist who has a professional opinion that less access to guns may save lives, our job as legislature is to look at the big picture and take a potential benefit and weigh it against the other costs that such legislation may incur. So my opinion as a legislature will consider the opinion of professionals, but it cannot just be driven by that.
Thank you. That, I closed the public hearing on House Bill oh, another person signed up. Simkin. Christ.
Thank you, Mr. Chairman, members of the committee. I will be brief. 3 words to begin. Data are lethal. 2 quick examples. 18 April 1943, the island of Bougainville in the Southwest Pacific. Japanese aircraft prepared to land. It was shot down by U.S. Army aviators. On board is Isoroku Yamamoto, who planned the attack on Pearl Harbor. Admiral Yamamoto, I guess, didn't know that the United States had broken Japan's naval code and thus had his itinerary. The only thing that the aviators needed to know, where and when, nothing more. Admiral Yamamoto did not survive the attack. Fast forward, 3 January 2020. In the evening, a car, accompanied by some others, left Baghdad airport. In one of the cars was a colonel, Qasem Soleimani, of the Islamic Revolutionary Guard Corps. He didn't know that a U.S. drone was up there. It fired 1 or 2 Hellfire missiles. He didn't survive the attack. Again, the only thing that the U.S. needed to know, when and where. So the idea that data are somehow, not dangerous is provably false. I don't have a horse in this race. I'm a licensee. I have never taken credit cards. Further, as a licensee, my name and address are published by the feds. This bill ought to be enacted with support from both parties because databases aren't secure. Anyone who pretends to the contrary should not drink Kool-Aid. When JP Morgan Chase, major bank, gets hacked, and the hackers are in their system for weeks, it's a big bank. It has plenty of money to spend on data security. You cannot imagine, you shouldn't imagine, that data are secure. I'll be happy to take questions.
Thank you for your testimony.
Thank you, Mr. Chairman.
Public
and
hearing
members
is
of the
closed.
committee.
With that, I open the public hearing on House Bill 1336 and invite the prime sponsor to introduce the bill. We got anything? For 1336?
Thank you very much, Mr. Chair. And I forgot to introduce myself when I spoke last. I apologize. I figured that 3 minutes later should cover both. I'm Daniel Popovich Miller, representing Windham, Rockingham District 17. I filed this bill based on a constituent request. Somebody came to me and told me, I have a problem. I know you're a state rep. I carry concealed. My employer is banning firearm possession on their property, and I want to respect that, and I'm fine with that. But unfortunately, because I have to park my vehicle in an employee-owned parking lot, that respecting that choice of my employee, which I want to respect, requires me to also not carry at all on the way to work. And I need to stop to grocery stores, stop at banks. We have a life, and I cannot make a separate trip to work, come back, carry, and now go around. So my intent was, and by the way, he obviously, due to the nature of the concern, asked me not to ask him to testify or to disclose his information because obviously there are concerns. So my intent was to find a way to protect the rights of people who want to carry concealed, while at the same time not infringing at all or as little as possible on the rights of the employers. I think this bill does exactly that, and I put a lot of thought into that. it's a very simple bill, by the way. I don't want to use lots of words when I write legislation. It basically says an employee who is coming to work in his own vehicle has the right to leave that thing locked and out of sight in the vehicle. As long as they do that, the employer is not allowed to ask them about it, to search the car, or to punish them in any way if they become aware that there is a firearm in the vehicle, as long as, again, the firearm is out of sight in a locked vehicle. Because the employer will, have that firearm potentially in the parking lot, there is a paragraph in the bill insulating the employers from any civil action in regards to any losses that may occur from them following the law. I don't want to have a law that puts employers at risk of being sued for something they are legally required to do. And really, that's about it. I recognize that there is a minimal impact on the right of an employer to control access to firearms on their property, but since it is so restricted to just a personal vehicle of an employee and the firearm has to remain locked and out of sight in the vehicle, I believe that I did everything I could to minimize that impact while at the same time protecting the rights of people that want to carry concealed on the way home and back to do so, and again, respect the rights of the employer. And that's my introduction, and of course, I'm available for questions.
Representative Muse.
So I know in New Hampshire, we spend a lot of time, especially on this committee, talking about property rights as well as gun rights. And I'm kind of curious how well you think your proposed law strikes a balance between those two things.
Thank you for asking. I acknowledge that concern from the beginning, right? I try to present my bills in as objective a manner as possible. So I acknowledge there is an absolutely minimal infringement that, in my opinion, is more than balanced by the benefits that it gives. Look, I do not believe that employers are creating those restrictions to control what people do outside of their property. Unfortunately, we do have that minimal area where I cross onto employer property to park, and that's it. And their desire to regulate that essentially extends that boundary tens of miles, depending on how long somebody commutes to work. I don't believe that's their intent, and I spend a lot of time trying to, again, address that issue with absolutely a minimal impact. And again, this is why they're insulated from any civil liability. I've done everything I could, and the bill, again, it's designed to minimize that.
Well,
would the liability protection in your bill, for example, extend, let's say, to an employer? Let's say somebody breaks into the car on site. A lot of companies have parking lots that are out in the open, steals the weapons and uses the weapons to rob somebody, shoot somebody, do harm to some other person. Because the employer had a policy allowing weapons to be stored on site that may not have been maybe in an area that could have been maybe better protected than it could have been, but maybe it wasn't. Does that create a situation where the employer is exposed to a different kind of liability?
In my opinion, no. I also spoke with the OLS drafting attorneys and asked that very question, and they assured me that this language would not expose the employer to any liability from this, because obviously criminally there couldn't be liability because they are obeying state law. And by the way, it's not their policy, it's a state law they have to obey. It's not a discretionary choice of theirs. This takes that decision out of their hands, so therefore no liability can be attached to them for following a state law. Essentially, this would increase the protection of employers that may otherwise be sued. Look, the real risk right now is that you have a policy that's not consistently enforced. If the same scenario happened, the employer would actually may be liable today. If we do pass this, this will protect the employer And frankly, the liability in that situation should be on the person who broke into a car and stole property. I really don't like the concept, the legal concept that I've seen applied that, I'm somehow responsible because somebody broke into my house and stole property and used that property to commit crimes. I mean, anybody of us could go to jail for that. I don't think it's okay to punish people who've done nothing wrong because they're a victim of a crime, but that's a discussion for another hearing.
Thank you.
Thank you.
Representative Newman.
Yeah, I just want to clarify, this law would apply to a loaded weapon that is just secure, is under the seat and the vehicle is locked. Is
The
that correct?
requirement is that the firearm be out of sight and the vehicle be locked. The intent behind this is to have reasonable protections against the possibility somebody may see something and be tempted to steal it. I mean, if you leave a firearm on your dashboard and everybody can see it, this does not protect you. You were careless. But as long as it's out of sight and in a locked vehicle, how much more can we reasonably ask anybody to do to protect their property? I mean, to me, that's as far as you can ask and be reasonable and not start entrapping innocent people in crimes.
Follow up?
Follow up.
And it also applies, well, I'm not going to ask the question.
Representative Selig.
Thank you, and thank you for taking my question. I'm wondering whether you would be open to a very small amendment that would say that the person would need to have their weapon in a locked case within a locked vehicle, essentially to double the layer of security, right? So that if someone happened to be randomly breaking into cars, as we know happens, or if someone forgot to lock their car that day, it would just add an additional layer of protection for the general public.
I will consider it, but my first take, since I had exactly 5 seconds to think about it. I come from Massachusetts, and I've seen Massachusetts prosecute innocent people for having their house broken into and firearms stolen because they violated the Massachusetts storage law. I think that anybody who breaks into a vehicle will also have the ability to break into a lockbox. Look, I have a little safe in my house that I use for my carry stuff, right? I know that if somebody takes it outside and uses a big hammer, in 5 minutes, they'll open it. It's meant to protect somebody from, a quick attempt to grab something in a few seconds. I think that anybody who already broke into a car will not be deterred by more boxes, and I hesitate to add more risk for the employees that I'm trying to protect and more costs without what I perceive to see a good benefit. But I would be open to talking about it maybe offline after the hearing and, seeing whether it makes sense. Thank you.
Chair calls Kimberly Moore.
That was my phone. Wow, I'm even short at the desk. While we agree that granted staters should be able to practice their fundamental human right to self-defense however and wherever they see fit, the government shouldn't be getting involved nor mandating what a private company does. We know of instances where companies have a no firearms policy, but in domestic abuse and stalking cases, they have allowed employees to carry firearms in their vehicles so they could be protected when they left the actual business. And another thing to think about is if this was actually implemented, and it could be easily flipped around if, God forbid, the gun control crowd was to gain control of the legislature and the corner office, they could flip this and say that no employers are allowed to ever allow employees to carry firearms, whether in their vehicle or on the person. And this would apply to ranges, gun shops, etc. This is an issue between employees and their employers, not an issue that the government should be involved with. Please vote inexpedient to legislate on this bill.
Thank you. Chair calls Attorney Penny Dean.
Penny Dean again from Concord, New Hampshire, representing myself. I respectfully say this should get an ought to pass. as it is. And here's the reason. We have more multinational companies in the state than you'd realize. And a lot of them are large employers. And some of them come from places where the Second Amendment just doesn't exist. And it's an abomination to some of them, sadly. But yet they choose to do business in our state. And this would give those employers cover. In other words, employees that work there would be able to carry firearms, and they would be able to tell their corporate owners in Europe, primarily Europe, some in the East, to say, look, we have to let employees carry here because it's state law. We can't do anything about it. We have to follow the laws of the state. We don't want to pick up and move. And the bottom line is the ones that claim that the only reason that they don't want employees to have firearms in their vehicles in the parking lot, they'll say, we're afraid of liability. Taken care of here. You don't have any liability. So the objections that they have are all solved right here. But the bottom line is I'm very fortunate. I work for myself, so I can do what I want. But I know a lot of people, because of family reasons, because of obligations, because of health insurance, because of careers, that work at places that don't allow them to exercise their Second Amendment rights. They are mandated to park in an employee parking lot, and the employee parking lot isn't allowed guns. And they know their vehicle could get searched at any time, and if their guns are found, there'd be a problem. Some choose not to carry guns because of the risk. Others choose the option that I suggest is you have to be alive to be fired. But again, that's an easy choice for a person that doesn't have a wife and 3 kids to support. So I look at this, and this gives people a level playing field. I respectfully suggest that there's harm to no one, that whether or not it should be between employers and employees as a practical matter, employees don't have the same bargaining power. And that gives those who don't have the education. I'm very fortunate. I have a fair amount of education. I have a lot of employment options. There's a lot of people in the state that don't have a lot of employment options. Even though we have a great economy and low employment, they can't just go anywhere. And so you have to say, this protects the least of us. This protects the man who can't stand up for himself. This protects the man with a high school diploma that's trying to support his family. So I respectfully say, if there's anything you can do to help the poor and the powerless, this does help them. This gives them the opportunity to protect themselves going home, maybe in the lesser quality neighborhood. You know, maybe shopping at the store or picking up their wife or whatever. I respectfully say I don't see the harm in it, and I see a lot of good in it. And I'm happy to answer any questions.
Thank you. Could you tell us what the state of the law is currently with regard to leaving firearms in vehicles in New Hampshire?
We don't have a law requiring they be locked in vehicles. So there currently is not a law requiring they be locked. And there isn't any statutory law per se. There is laws that say about negligent storage where minors get access to guns, of course. And you could say that's in a car or anywhere. So most prudent people are going to lock a car. But I do agree with Representative that adding lock boxes and stuff, that's just a pain in the foot and a recipe for disaster. Each person's going to make their own choices, but it's kind of like the robber or rapist that they'll break 10 laws, but they won't break 11. I'm not buying that. Anybody who's going to break into your car, you know, they're just going to take the lockbox with them anyhow. You know, so I think that this solves the problem, presuming you keep your vehicle locked. And I don't see any other legal impediments in New Hampshire to this bill. And it really does give the employers cover. You know, and that's what they claim they're worried about. Well, this bill takes care of it.
Representative Stone.
Thank you, Chairman Roy, and thank you for taking my question. In your opinion, or in the state of New Hampshire, is it viewed under law that your motor vehicle has a higher interest of privacy, such as an extension of your home?
It is. It is. We are very, very fortunate, and a lot of people don't understand this, but the United States Constitution has a baseline you can't go below in constitutional rights, but you're allowed to go higher. And in New Hampshire, in many areas, we've chosen to value our constitutional rights, if you will, greater than the federal. And so it is considered an extension of your person. And just like I wouldn't expect that you could just walk and get in my vehicle and start picking through my glove box, I would presume I have some privacy and everything contained in the vehicle. And as long as my employment contract doesn't provide otherwise, I think they should stay out of my vehicle.
Quick follow-up. Could you also remind me what the penalty for theft of a firearm in New Hampshire is?
Under federal law,
Under New Hampshire state law?
there isn't a penalty. It would depend on the value of the firearm. 1,500 would be a felony. So in New Hampshire, the penalty levels go on the dollar value of the item.
Thank you.
Is there a federal law that you're aware of regarding the theft of firearms?
I'm sorry?
Is there a federal law that you're aware of regarding the theft of firearms?
Depending on what you do, yes. Depending on how it's taken and such, yes. And from where it's taken, I should add.
Okay, thank you. Seeing no further questions, thank you for your testimony. The chair calls Catherine Giddens.
Thank you, Mr. Chair. I'm speaking right now just as for myself as a local resident, and I just wanted to add whatever weight that is, albeit very minimal, to the spirit of this bill. I think it does make sense that although you may be parked on your employer's, in your employer's parking lot, it's your car. It's an extension of your home. And if an employer is not allowed to inquire into your religion, if they're not allowed to make any decisions for or against you based on your sexual preference or your whatever creed you have, whatever race you are, I would argue that firearm ownership is part of a certain creed. And if you store that safely in your car, then it's no business of an employer's. And that is just my personal opinion. That's all I have to say.
Thank you. See no questions. Thank you for your testimony. Chair calls William Rogers.
Thank you again for giving me a chance to speak. I carry every day, and when I heard this come up, I said, if I was in that situation, I would have a problem. I would not feel I was being responsible if I left my firearm in a car, even if it was locked. My choice would be not to do that because it's too easily stolen. If it's stolen, well, let's face it, saints don't steal things. If they're going to steal it, they're probably going to use it in a crime. But when the representative said perhaps an amendment to have to put it in a locked box, still out of sight in a car, I would support that. But I could not support it without that amendment because, again, personally, I would not leave my gun in a locked car. That's all. Thank you.
Thank you. Chair calls the Honorable Bob Lynn.
Thank you, Mr. Chair, members of the committee. I appear here in support of this bill. I'm a co-sponsor, and I have to say, when Representative Popovici-Muller first approached me about whether I would be a co-sponsor on this bill, I have to say that I had to think about it because, as Representative Muse points out, I am also a very strong believer in property rights. And, the general view, I think the general rule is if it's the employer's property, the employer gets to say what the rules are. And as a general matter, I support that view. But I think here it's a question really of balancing that employer's right against the individual's right to be able to exercise his Second Amendment rights or his rights under the New Hampshire Constitution to own and to bear firearms. And as Representative Popovici Muller pointed out, the problem here is if an employer has that policy of no guns in the parking lot, it effectively means that the employee can't exercise his rights on the way to work or on the way home, because you're not gonna. What are you gonna do? It's just not practical. And I guess I would use a sort of personal example. Fortunately, I never worked at an employer that had a rule of no guns outside outside wherever you are. But I'm a target shooter. So on Tuesday night, it's very recently stopped because the other people on the team, got too old to continue shooting, and so that particular team kind of went defunct. But for 20 years, if it was Tuesday night, I was shooting at the Major Waldron Sportsman Club in Barrington, New Hampshire. We had a league. So I live in Wyndham, and I worked in Concord for a good part of that time. So if you chart that out, that's a pretty big triangle to drive from Wyndham to Concord to go to work, then after work drive to Barrington to go shoot, and then drive back home to Wyndham. So if I couldn't, and I would have, so on Tuesday night, I would have my .22 target rifle locked in the car, in the back of my car, and since it's a rifle, you can't put it under the seat. It was either in the trunk, or if I had a station wagon, it was in the back, and I always kept the case locked. Although candidly, that's not, as other people have pointed out, that's not really much protection. The case is locked. But somebody has a sledgehammer or whatever, they're going to be able to eat it's not going to take them very long to get into the gun case. And so I use that just as a very practical example. Is if I worked at some employer that said you can't have guns in the parking lot, what do I do, and why does it make sense for me not to be able to have a gun locked in the car? So that I can, so that at the end of the day, I can go target shooting. I just don't think, should I have to park off, and if you're talking about some big employer, I don't know, like GE or some big employer, their parking lot can be really huge. What do I do? I have to park like off the employer's property and somehow walk in, and then maybe I'm parking, and maybe there's no place to park in the area or whatever. It seems to me that on balance here, the infringement, if you want to call it that, on an employer's property right is pretty minimal compared to the protection of the right of the person to have, to pursue a lawful ownership and use of firearms. So for those reasons, I strongly support this bill, and I hope you'll decide to consider it ought to pass.
Thank you. Would you, in your understanding, would you consider the Second Amendment a civil right?
Absolutely. Absolutely. I think it's a civil right.
Are there any other laws that you're aware of that we allow employers to discriminate against people's civil rights?
No, I mean, the thing, I understand what you're saying. The only thing where I raise an issue here, because I think there is a point here of the property right. In other words, I suppose that an employer could have a policy of, no speaking. I mean, I'm making a sort of a really extreme example, but I suppose an employer could have a policy of no talking on on my premises except specifically about work. You can't talk about anything else. Now, I suspect that employer is not going to stay in business for very long, but presumably they could. And I guess it would be a question. There it might be a little bit different, because if an employer had that rule, at least that wouldn't infringe on an employee's First Amendment rights on their way to work or on their way home, whereas this sort of does. But there's, I guess, what would a court say if an employer did have that rule? No talking about anything other than, the employer's business on the employer's property. I don't know. I'm not sure the court has ever had such a case, and hopefully there's not an employer that would be kind of foolish enough to adopt such a policy. But it would be I think it would be an open question, I guess.
Well, to your point, a civil right that an employer impacted through their policy that not only impacted the person while they were there, but on their way to and from work.
No, exactly. I think that's exactly right.
Thank you. Representative Psychiatric.
No one this morning has mentioned, and I think it's a time that this get into play. We have passed a constitutional amendment guaranteeing privacy in New Hampshire. What right does an employer have to say about anything in my personal car brought onto premises, locked up? He has no legitimate business interest in anything in my car. And doesn't our right under our constitutional right trump the employer's right to the concern in my car, anything in my car, any more than the employer, it's his property, but I can use the washroom privately, can I not? I'm infringing on his right in that case? I want to bring up our constitutional right is my point.
No. I mean, I think the privacy issue is an important one. I mean, I guess, I think this is personally, I would kind of in the context of this firearm thing, I would draw the line at where this bill does. In other words, I would have a real problem. I think I would if there was a bill that proposed, listen, if you can lawfully carry concealed, you can carry concealed into the employer's business. And they can't have a policy that says nobody can be carrying concealed in the business, inside while they're working. I would say, no, that goes too far. They've got, inside the workplace, if you own the business, you can say, I don't want anybody armed in here. Even though I might personally, if I had a business, I would not have that policy. I would say, if you can legally own a gun, fine. You could come on in and carry out do your job. But I can certainly see that other people would have a different view, and I would not go, I would not support a bill like that, because I think that just would be too much of an infringement on property rights.
In your opinion, in other words, the constitutional amendment Representative Psychiatric brought up really is against the government versus an employer. But in your opinion, does this bill strike a balance between the rights of the employer and the rights of the employee?
I think it does, and I think it's very limited. It's only in the parking lot. The car's got to be locked. The gun can't be visible. I think that the intrusion on the employer's property rights in that circumstance, it seems to me, is pretty minimal. And I think the benefit to the person who wants to exercise their Second Amendment rights is pretty strong. And so I would say that that does strike a proper balance.
As we learned in New Hampshire, larceny of a firearm isn't necessarily a specific crime. It's based on the value. Would you not see some value in if we're going to contemplate this at the same time, making the theft of a firearm be a specific crime of its own?
Yeah, I think under current law, if it's a firearm, it can up the penalty from
enhancement.
Yeah, enhancement. But no, that might make a lot of sense to do that.
Thank you, Representative Muse.
Yeah, I did have one scenario I wanted to run by you and just have you comment on it. So let's say the business that I operate is a daycare center. And let's say the parking lot that my employees park in is next to the building. And next to the building is outdoor equipment that the children in the daycare center play in. Given the fact that all of us at one time or another have gotten text messages or found ourselves busy when we're getting in and out of our cars, and we come back and we go, oh, I forgot to lock my car. given the nature of a business like that, would you think that a business like that would have the ability should have the ability as a condition of employment to say, we don't want you to put firearms in your car when your car is on our property? And I guess on top of that, we also have a child negligence law in New Hampshire that actually penalizes people if their firearms fall into the hands of children who use them to commit crimes or shoot other people. So I'm curious how you react to that.
Yeah, I'm not sure that that would change my view on it. I mean, can the employer, I would, can the employer say, well, listen, you can't, in that circumstance of the daycare, the employer say to the employee, you can't bring, you can't pick up your prescription for Percocet or whatever on your way to work because you can't leave it in the car because, maybe one of the kids will get into the car, or you can't have, I don't know, if you break a glass or something in the car, you're driving to work with it and somehow you break a glass or there's glass in the car, you have to clean it up before you come into work because maybe one of the kids from the daycare center will get in and cut themselves. I would tend to say you shouldn't be able to do any of those things, and to sort of single out firearms, I would not think that would make sense.
Thank you.
See no further questions.
Thank
you. The chair calls Dr. Joe Hannon.
Good afternoon, members of the committee. My name is Joe Hannon. I signed in support of this bill for gun owners of New Hampshire, but I'm speaking on my own behalf right now. I didn't think I was going to speak, but there was a lot of comments that came up about why it's necessary to have this change in law. I actually worked at a very gun-free facility when I was in residency in North Philadelphia, and I'd like to say it wasn't the best. Well, let's just say it wasn't the safest neighborhood to commute to and from. My now wife, then girlfriend, a few weeks after we met, she was leaving the hospital, got into her car, drove home to a different part of Philadelphia, was walking to her apartment, and was pistol whipped by two armed individuals. Took her purse. Luckily, that was all that happened. She got a few stitches. That was our third date, watching her get the stitches. She became a very strong enthusiast of Second Amendment rights after this incident. Also, personally, I had several close calls or scares coming to and going from the hospital. I had been chastised by one nurse because I opened a medicine bottle with a Swiss Army knife. She told me you couldn't have any weapons in the hospital. I was okay. I didn't know that I couldn't have a knife. I was there as a foot and ankle surgery resident. I had a fistful of scalpels in my jacket pocket. That was okay, but a pocket knife wasn't. Anyway, I didn't even ask about a gun. I just let it go. But the parking garage was secured. We had to go in and out. There was a guard there. So even if someone did break in, they would probably be able to find them pretty quickly. So I wasn't worried about securing a firearm in the parking lot. However, most people did not do so. After someone wins the Super Bowl or a big basketball game, some cities have problems occasionally with rioting or celebration. Not rioting, let's just say celebration. After leaving the hospital one night after the 76ers didn't do very well, my car broke down. And there were helicopters, fires. It looked like something out of a science fiction movie. It was pretty crazy. I'm sitting at a gas station trying to get help. The person was ducked below some bulletproof glass, wouldn't even take $20 for a gallon of gas to help me keep going. My then girlfriend, now wife, dropped off some gas that she got, didn't even slow down, just threw a gas can at me and took off. So I think that someone, and we heard all these other arguments about, property rights, the car is an extension, all this other stuff. But I think it's important to understand that not everyone lives now I live in Lee, which is wonderful. I don't worry. Most people don't even lock their doors or cars. I still do. I'd lock my door when I check my mailbox because I grew up in that city. But I think this is very important. I think this is something that is not just a rights issue or a privacy issue. I think this is a an issue of, allowing an individual to protect themselves outside of an environment. Now, whether an institution can be gun free or not, I think that'll come up in some later testimony today, but I will just say that this is an absolutely necessary bill to prevent possible dangerous situations from happening to individuals. Be happy to take any questions.
Seeing none, thank you for your testimony.
And her scar looks pretty good too, by the way. So, thanks.
That's it. Anyone else wishing to testify on this bill who has not done so? Seeing none, I hereby close the public hearing. What? Did you turn in a card?
Oh, attorney Andres.
I swear I'll be very quick. It's Attorney Andrews.
Do you have a card or you didn't fill out a card?
I didn't fill one out. I certainly will.
Okay.
There was just a mention of whether or not theft of a firearm is a specific crime in New Hampshire. If you do steal a firearm, it makes theft a Class A felony under RSA 63711.
63711.
Yeah, is the penalties section of the theft statute.
Yeah.
Which makes theft of a firearm a Class A felony. So that'd be punishable by 7.5 to 15 years in the state prison.
So under this proposed bill, if someone broke into a car and stole a firearm, it would be a Class A felony with that penalty possible.
Whether this bill passes or not, if you break into a car and steal a firearm, it's a Class A felony.
Thank you.
Thank you.
Further questions while he's here? Okay.
I'll fill out a card for you.
That's right. And now it's really close. With that, I open the public hearing on House Bill 1337 and invite the prime sponsor.
Mr. Chair, I got to go with the sponsor.
Okay, yeah, we're going to take 10 minutes. Okay, with that, I'm opening the public hearing on House Bill 1337. I invite the prime sponsor to come introduce the bill.
Thank you, Mr. Chair, members of the committee. For the record, my name is Tom Manning, representing Hillsborough 1, the town of Pelham. This bill is a result of a constituent request. When they explained it to me, what the process is for having your property returned to you upon the expiration of a protective order, I had to reread the RSA several times to confirm, yes, in fact, we have a law in the books that requires a defendant to prove their innocence before the court. This is a complete inversion of due process, flying in the face of the foundational system that innocent until proven guilty. So this bill attempts to rectify this by inverting the responsibility to call a hearing before the court onto the plaintiff. And should no hearing be called, the defendant can retrieve their property without the injustice of pleading before a court to do so. A second granite stater also brought to my attention a situation where the storage fees they incurred from having their property held amounted to more than the value of the item. I haven't followed up with that individual, but it's an anecdotal experience. So I had an assistant call around to various police stations around the state, including one from this specific situation, and they all claim they do not charge storage fees for property seized from a protective order. So there's a contradiction between those statements, the anecdotal experience I was told, and the fiscal note attached. Since the phone calls lead me to believe that these stations aren't charging storage fees at all, I see no reason to give such leeway as a reasonable fee that may be inconsistently or maybe maliciously determined on a case-by-case basis. Now, if the methodology of this bill could be better served through some other design, I'm happy to work with the committee on amendment, but I believe it's plain to see that there's an inversion of due process on the books that needs to be remedied. Same for the storage fees. Perhaps a hard cap would also suffice in that in that realm. Regardless, I ask the committee to vote OTP on HB 1337. Thank you.
Thank you. Representative, did you just say you had an assistant call? I was wondering how you got an assistant. I must have missed that.
Yeah.
No, I didn't get one either.
It's like an intern.
Okay. All right. That's true. Thank you. Any questions? No questions. Thank you.
Sweet. Thank you.
I know. Did you speak right there? Is that no? The chair calls Dr. Leonard Korn.
Thank you again all for hearing my testimony. So this bill has to do with protective orders, and protective orders are difficult to obtain, and they are obtained when an individual is felt to be a danger to another person, usually a partner or a spouse. This is usually an abuse situation, and the protective orders last for a certain interval of time. Statute right now requires the defendant or abuser to go to court and get their rights to have guns, ammunition, and other deadly items back in their possession. It's the burden of the abuser to go to court for that to take effect. This bill in front of us changes the burden to the abused, and the abused person has to object to the hearing and create the necessary court situation so that the formerly abusing person doesn't get their guns back. I think it behooves the state to keep the situation as it is rather than present the abused person the burden to prove that their abuser is safe to get their guns. That's about all I would have to say.
Thank you for your testimony. Chair calls Attorney Penny Dean.
Thank you, members of the committee. I strongly support this bill, and I think it's highly necessary for many reasons. The last statistics I've seen, if I recall them correctly, were that about 75% of protective orders were ultimately granted, if I've read, and that's 2 years behind the way I read the statistics that are put out by the state of New Hampshire. So that's going 2 years back. I have not seen, because there usually is a delay in reporting the last couple years. I consider that pretty darn easy to obtain. The only thing I think is easier is indicting a ham sandwich. And those of us who have defended against these protective orders, most people are shocked when they know that they went to court on what they thought was a simple hearing and it took their gun rights for a year. And they call and they'll say to me, well, can we appeal this then? And I go, yes, we can appeal it, but we appeal on issues of law, not issues of fact. And the chance of winning that is pretty slim. You're going to pay me a whole lot of money and get a whole lot of nothing. So if they happen to come to me before the hearing, there's a chance. But here's what you have to understand. These people, generally women, who fill out 4 to 8 pages of allegations, and I say to them, in order to effectively defend you, because any one of these single allegations will win her this protective order. And here's what you have to understand why a lot of these women go get the protective order. While the protective order's in place, let me explain to you what happens. I have one most recently. Man owned the house. Guess what? He's out of his house because that's what she has been allowed to have, and he cannot change anything. So we had to ask for a longer hearing because if you've got pages and pages of allegations, you're going to have to ask for sometimes 2, 3. I've had multi-day hearings. You may have to wait up for a year for a hearing date. Well, while you do for a hearing date, that temporary order stays in place, which means he's still paying a house payment of a house he can't stay in. He's still paying the lights, the phone. I can go down the whole list. Lights, phone, cable. And he says, wait a minute, why do I have to pay the lights, phone, and cable for a house I'm not living in when I'm going to throw the broad out, if you will, because we're getting divorced or we're getting separated or we're not having a relationship anymore? And my answer is because there's a protective order in place now. And so she can do what she does, which is turn the heat up to 80 and leave the windows open, and you have to pay the heat bill every month. Because if not, guess what? You're in contempt. You can't change anything. You have to pay her phone bill. Every bill that's being paid up at that point, you have to continue to pay. And you say, where's the justice in that? And my answer is there isn't any. But the bottom line is the only reason this 75% statistic isn't higher, in my opinion, and I do not know, I don't remember from the sheet, is because a lot of these individuals, the complainant, if you will, don't show up for the hearing, and then it's automatically dismissed. And I do not, there's a percentage out there, I've seen the number, I just can't remember it to tell you. So this number would even be higher. So anyone that says these are difficult to obtain has never been in my shoes for my clients. But I think what's even worse is, as a practical matter, I've seen some departments say, now prove your guns. And you're like, but I turned them over and you seized them. You got them from me. I have a receipt here. Yeah, we know, but we need some receipts to show they're your guns or we're not giving them back. And even then, once you get a court order, which can take weeks and weeks and months, you then have to make an appointment with the evidence technician or the evidence officer. And the evidence officer, he only works from 2 to 4 on Tuesdays and Thursdays. And the particular time you make an appointment with him, yeah, they're shorthanded at the department. He went out on a call, come back. Well, I took the day off work today. Yeah, I know, but he had to go out on a call. So we're coming back. And so getting these firearms back is not as simple and easy as they would make you think it is. So and what's even more important here, this person has not been convicted in a domestic violence sense. This person has made the preponderance of the evidence standard, which means, just as we say, 51%, the scale tipped more that the judge believed the complainant. There's no evidence in these cases that the person's been convicted of anything. Because if he were convicted, he wouldn't be allowed to get his firearms back. So making it more difficult and more expensive for these people to get their firearms back when they're not under any restriction at the end of a domestic violence protection order to get their firearms back is unfair. It'd be like before letting someone out of jail after they serve their time, jump through some other hoops or do some other things. We don't do that to people. Once you've went through the process, you're now a free person. You're to be treated like a free person. But the other thing that you talk about is the storage fees, and more importantly, the obligation to store these things nicely. I've had guys with a brand new SIG, funny thing, went in there, came out, the front sight's all gone and damaged and messed up. Now, do you believe that just happened accidentally or whatever? SIGs are pretty rugged. You see abuse and damage to firearms that are sometimes darn near priceless, and there's nothing you can do about it. So I think every part of this bill makes common sense, and it begins to level a playing field, which quite frankly I think is unfair. Because what happens is the women who generally apply for these, we've got all sorts of state and volunteer helpers who help them fill out the forms, who come support them in court, and yet the person who's accused has got to go hire a private attorney, usually on very short notice, and sometimes to defend against pages and pages of allegations that are, quite frankly, a lot of times very difficult to defend against because they're allegations of he said, she said. So I'm happy to answer practical questions, but this begins to make it more fair and more equitable and, quite frankly, save these people from grief and getting their firearms back.
Thank you. If you could walk me through the process. So I have an order against me.
Yes.
I turn in my firearms as I should.
Yep.
The order expires. It's
Yep.
not renewed. How do I go about getting my firearms back right now?
You make a motion to the court where the domestic violence order was pending and ask for a motion for return of firearms. They're going to have they're going to set up a hearing. Now, there's no statutorily mandated date when they're going to set a hearing, so it can be weeks or months from the time you ask. When they go to the hearing, what is supposed to have happened or what the court wants to happen, and it's one of the many things that I disagree with, but it's the way it is that when you go to that hearing, and they're going to notify the complainant, the party whose DVP is against, and that person sometimes comes and says they object. Well, I don't even think they should be a party to this. I think it's wrong because whether they object is whoopity-doopity-doo-dah. They got no legal basis to object because the order's over. So you go there. Now, it depends on the particular police department that's holding the firearms. They may or may not show up. But let me tell you the worst thing that happens, and it happens all too frequently. Judges want a clean check from the gun line before they'll give the firearms back, even though there's no evidence before the court that the person is prohibited from firearms. So more than once you go to court, you pay your lawyer to go to court, we all go to court, and the judge says, well, where's the gun line check? Oh, it's not back yet, Your Honor. Reschedule this court hearing. And you're like, what? So what I try to do, if it's a case I'm handling, I call a court clerk and I say, hey, is the gun line check back yet? Because if it isn't, I try to continue the matter so the client doesn't have to pay me to go to court. I'll sit there and wait for our hearing, right? We go up, only to find the gun line check isn't back yet. And so the gun line check, and when I say the gun line check, they're not doing a gun line check because that's illegal. They're actually running a III check. But the gun line, what does it, if you will, the people that handle it, last time I checked. And so what happens is that if that check isn't back again and again and again, if whoever's involved, even though it should be able to be done, it's just like a spots check beside the road. A trooper can do that in 2 seconds. So there's no reason it's not instant, not done. It's because some sort of staff communication are busy. It can be weeks and weeks and months. So then you go to court, and then you get presumably an order that says you get your guns back. And this is to tell you how difficult some police departments even make it. So their officer was in court physically when this happened, when the judge said, give him his guns back, right? Gives you the order. So I tell the client, listen, you're going to have to go make an appointment with their evidence person to get your firearms back. But here's what we started doing, because some police departments, this is to tell you how difficult they make it. The client goes there, they said, well, where's your order? And he's like, well, you were in court right beside me when they said it. Oh, no, we have to have a copy of the court order. So the client goes and gives them a copy of the court order. Oh, no, we have to have a certified copy of the court order. And we're like, but you were sitting right there when it happened. So I can understand maybe a department where they don't go to court. I see no need for that record. So to me, as a matter of practice, I just tell the client, look, when we leave, we get certified records because some of them played this game. So you're just going to say, oh, good, I've got a certified record right here. But even then, sometimes even physically getting a hold of the evidence officer to make the appointment can take a client weeks. Literally weeks. And there have been departments I've had to call and say, hey, can I speak to this person and make an appointment for my client? Because it's taken an awful long time. So you're talking from the time this DVP ends till you get your guns back. It can be 6 months or more. I'm not saying there isn't wonderful occasions. I've had wonderful occasions where a wonderful department's there and says, hey, come back later and get your guns. Those are rare, rare, rare exceptions. So meanwhile, you've been without your guns, you now get them back, but it's months and months and months and weeks and weeks and weeks before you actually physically retrieve them, your guns and your ammo. And I've had officers say to my clients, well, you're not prohibited from buying guns now, just go buy another gun. Well, if you got lots of money, you can do that, but not everybody has lots of money. So it's an arduous process. And the other thing is clients are shocked if they didn't have a lawyer that they have to file a motion to get their guns back. Yeah, I mean, they're like, you got to be kidding. I have a receipt here. They took them, I voluntarily gave them up. Why do I have to file a motion to get my guns back? And I tell them, if you don't file this motion, you're not going to be getting your guns back. So there's no police department that I know without a court order that'll give them back.
What, if you know, is the average, what would you charge a client to handle just the guns giving back case? Because that sounds like it's a totally different case than
It's a totally separate case. Thousands, and here's why. I first have to fill out the motion, which is $60, $80, right? But I have to I charge, as many lawyers do, what I call portal to portal. From the time I leave my office till the time I get back is the time I charge. So we have to go sit in court. They're going to give us a court date. If we're lucky, we're in and out in a half hour. If there's been a kerfluffle at the court, if something else happens, which courts are busy, we could sit there for 2 hours waiting to be heard. So they're paying for me to sit there for those 2 hours, which I'm not happy about, but they're paying. That's $300 an hour and 55 cents a mile for my travel time. And then when we leave, of course, it's, $10, $5 to $10 for a certified copy. But then if I have to continue to call the police department for them, because sometimes it doesn't work, and sometimes you have to, I quite frankly, be extra nice to them because I want them to give my clients guns back. That sometimes means longer conversations. You can't just call them up and bark orders to them. You got to ask nicely. And so literally, if you do the math, it depends on where it is geographically. Like I have some clients say where I say, well, gee, I could recommend a lawyer closer. And they go, no, I want you to handle this because you've done this before. So it depends on how far geographically it is from Concord is the total price. I've had people pay me go to South Boston all the time. And they feel that, some of the things I know are helpful to them. So that's a lot of money to get your guns back. And sometimes the guns monetarily aren't that great. One of my favorite clients only had 2 guns, but they were his 2 guns and they were his property. It mattered to him. He had a handgun and a long gun. And one of my dearest clients, and like he said, they shouldn't get to keep his property. And that's why he's paid more on me than they were worth, quite frankly. And the other thing is sometimes when judges get objections from the original complainant, until they get a lawyer involved, they're disinclined to give them back, even though they quote, have to give them back. So it's a very difficult and arduous process for the person who's doing this, who's trying to get their firearms back. And again, I know it seems so simple. You say you file a motion, you go to court. If all the pieces aren't in place, you don't know how many times the courts tell you to come back again. And the the accused person who had the complaint order against him, he's not going to know to call the court clerk and make sure the gun line ran the check. You know, he's not going to know that. And he's taken a half day off work. And some people work by the hour. They've not only made their employer not happy, but they've missed income. That's a lot of money for a working man.
And just to be clear, the people we're talking about here are innocent, correct? They haven't been convicted, because then they wouldn't be able to get their firearms back at all.
Yes, these are not convicted men. These are men who are innocent of all crimes that we're aware of, because if they had been convicted in a thing, they would not be allowed to have these firearms. So these are innocent citizens that are being penalized. I call it the double whammy by the system. And so there's no reason to do this to these people. These are innocent men whose property's been taken. They have receipts. Everybody agrees it's their property. And all they're asking for return of their property. Because meanwhile, again, average working men can't go out and buy a bunch more guns. These are the ones they use to protect themselves, to protect their home, to protect their families. And they just want them back. You know, that's really what it comes down to. They're people who have done, in my mind, nothing wrong. Now, they might have had a protective order against them, but sometimes, again, as we know from the Innocence Project, even those that are convicted are not always guilty. You know, so, but these men have no criminal convictions and no legal impediments to getting their guns back. They just have practical impediments through bureaucracy, through the court system, and through some police departments.
To obtain a protective order, you don't necessarily have to have actually been accused of abusing someone. It could be that you are an imminent threat of abusing someone.
Yeah, absolutely.
So even that isn't necessarily true, that they've done something. It's only been accused, and then they weren't proven guilty.
That's exactly it. Here is what I think is the worst part of these things, is it comes down to what I call he said, she said, usually, or she said, she said, or he said, she said, is that I could say that he said he's going to cut my throat with a knife. Guess what? Protective order, here we come. You know, because that's the threat of abuse. It's the threat of physical violence with a weapon. And the bottom line is it depends on who the judge believes. And here's the thing I keep reminding people. In this state, we do not elect judges, so we can't unelect them. Once they're on the bench, they're there forever, or until 70. You know, they're there forever, and it's a big difference. I come from a state where you elect judges. And so I'll tell you something that I believe every defense attorney, or even attorney in general, will ask you. If you come to an attorney with a problem, some of the first two questions most of us ask before we ask about the facts or anything, we ask two questions: who's the judge and who's on the other side? Because that makes a huge amount of difference. And you think, well, the facts should matter. You know, what the actual conflict is and what the specifics are. Yeah, it should, but guess what? Makes a huge, huge difference. You know, we all know the judges who lean one way or lean the other.
Representative Janvrin.
Thank you, Mr. Chairman. I'll try to keep my question brief. I actually had a conversation with one of my constituents in the last couple months, told him about this bill, that we were going to be facing it. And he told me, and I'm just wondering if you could tell me how many times you've heard this occur, where the domestic violence order has expired. The police department is so onerous to get the firearms back, to go through that process, and it costs so much. But it was easier for them to go to a federal licensed dealer and purchase a new firearm and leave the firearm in the possession of the police department. It took about 10 years, and finally the police department reached out to him and says, are you ever going to come back and get this firearm? He goes, I've already owned like 16 of them, so I don't need that one back. Have you ever heard of that happening?
Absolutely. Absolutely. But it's happened even more so because the person doesn't want to go without a gun. In other words, I can't tell you how naked I feel. I've only went a couple places where, you know, my guns can't go with me, and I felt naked and exposed and whatever. And so most people, the minute they're able to lawfully protect themselves again, they want to go get another firearm. And when they see it's going to be, who knows when they're going to get it back, they're like, what the heck? I may as well just go buy another one, because, you know, you take 2 or 3 days. I mean, I've had clients after initially try to get their guns back, but they take a half day off work. There's a kerfluffle at the court, so they've already lost that money. And they like, wait a minute, I've taken 2 half days off work. I still don't have my guns back. I may as well save my court money and go buy a gun. So yes, no, that's sadly happened more than once.
Representative Pratt.
You answered my first question about the cost there, excessive cost. Would that be the same if a person was found not guilty? We're talking about a protective order expiring. But if a person went to court, getting the guns back after the court?
Sadly, the process is the
The
same.
same, yes. Okay, thank you.
Yeah.
Representative Stone.
Thank you, Mr. Chairman. Thank you for taking my question. My question is going to be, if the expired order happens, an individual can purchase a new firearm under both federal and state law. What is the purpose of the law or the history of it that we passed to maintain the firearms, to have a separate hearing, to go before a judge and have an order issued to return firearms if they can just go out and purchase new ones? What are we doing with this law?
I think it's horrible the way, I think the law, state of the law right now is horrible the way it is. This bill improves the horrible state of the law quite a bit. Do I think the entire process should be scrapped? I do. But as I'm realistic politically and realistic practically, the best I can hope for at this point is that you pass this bill. But I agree with you, that shouldn't be the process. I agree with you that we have a protective order that ends. I should be able to go get my stuff. The stuff that I had to give to you, I should be able to just go pick it up. But that's not the way it is.
Thank you.
Representative Sue Newman.
Yes, thank you. If I took my notes correctly, you said about 75%, maybe a little more, of protective orders are granted. Yes?
Yes, and so I should be real clear because probably members of the committee don't understand something. I didn't explain something to you. Is that initially the individual will go to the court or the police department and ask for a protective order to be issued. That's considered a temporary order. And then the person who the protective order has been granted against has an opportunity for a hearing. And at that hearing is where the numbers come from, the way I receive them. In other words, that of the people who apply for that initial order, which is considered a temporary order, and then what we call a permanent order, which is the typically 1 year. I've never seen them issued for less than 1 year. So 75% of those who apply for that temporary, they become the permanent. Yes.
Yes. If I could continue, thank you for that. But the approximately 25% that are not, do not go through, no weapons are taken or dangerous devices are taken, while those are being considered to be dismissed, I guess.
No, I should explain this to you better. And I apologize for not being clearer because a lot of members of the committee probably don't understand this. So I want to, if I may, just start from the very beginning. So let's say that someone goes to the police department, person one, and says, and they call a judge or magistrate, get a temporary protective order out. What they then do, protective order against person number two. The police department, where person number two lives, literally drives immediately to person number two's house, who the protective order is against. And they say, sir, you've been served with this protective order. And this is where some horrible abuse begins. And I'm really glad for your question, Representative, because it's important. Is they say to the person, do you have firearms or, weapons, that type of thing? And they usually have already asked the person who's protected against what weapons they think they have. And if the person says, yes, I do, they say, where are they at? They will not let you go back in your own house, and they'll tell you they'll arrest you if you do. They will go in and rummage through your house and get all your guns and all your ammo and anything else that they think is in violation of it. And this becomes really problematic, and I've had this happen in many cases. You'd be surprised, or maybe you wouldn't, the amount of adult people that still live with their parents. So let's say it's a 30-year-old adult man, and he still lives at his parents' house, and his mother and father have their own guns. The police take every gun in that house, every round of ammo, everything. Even if the parents, the mother and father, are sitting right there saying, this is our house, we can show you the property deed. He lives with us, his driver's license is here, but these are our guns and our ammo, and this is his guns. The answer is all guns. All guns, all ammo are taken. And so while this temporary order is pending, all guns and ammo are not only taken, but he, meaning the person who the order is against, cannot go buy any guns, cannot possess guns, cannot have access to guns, ammunition, or ammunition components, which is powder, primer, and brass. He cannot go buy a gun. Now, here is the next problem. Technically, he has a right to a hearing 3 to 5 days. As a practical matter, if he wants any type of, in my opinion, unless they are lucky they have time, good attorney, an attorney who's going to prep the case, he is going to have to waive that timeline. Because if Johnny Joe calls me tomorrow and says, I've got this protective order, I first have to read the order. I have to meet with him. It depends on how long the order is as to whether or not I'm going to get a private investigator to go check things out. It depends on a lot of specifics. But I likely will not be able to take that case and prepare to defend him in that hearing for a month or two. So meanwhile, we have to waive time limits with the court in order to get a continuance, and he is living with that protective order for probably 30 to 60 days. Now, during this 30 or 60 days, there's some other things you have to understand that are in it. If, in fact, they were married, he's obligated, as I've said, to pay all these bills and continue it. If, like here, they're separated or they don't live together, that's something different. But a lot of times you even have people it's like people who are attracted to stars who think they have a relationship with someone they don't. And they file these orders. And that happens too. So meanwhile, that person can't have any third-party contact with the person. There's all sorts of rules and regulations. And so I have to tell all of my clients, I say, you have to call all your friends right now. And I said, you need to tell every one of them, do not call her. Because the first thing their friends want to do is call and say, what are you doing? He's a great guy. Why would you do something like this? That's considered witness tampering or intimidation, and that can get you some new charges. So I tell them, make sure you call all your friends and family and tell them, do not call her, do not talk to her, do not say anything to her. Make sure you, and this happened to one of my clients, make sure you lock her on your phone, because how many of us have butt dialed people on cell phones before? Probably all of us, or purse dialed. If you accidentally dial their phone number during that time period, that's a violation of the protective order. So yes, from the very beginning, that person goes and makes the complaint, all their weapons are taken from them.
Seeing no further questions, thank you.
Thank you.
Chair calls Pamela Kiley.
Good afternoon, Mr. Chair and members of the committee. My name is Pamela Kylig, and I am the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. The coalition is the umbrella organization for our state's 12 community-based crisis centers, and we serve nearly 14,000 victims and survivors of domestic and sexual violence each year. I'm here in opposition to HB 1337, legislation that would change the process for how deadly weapons will be returned to domestic violence abusers. I think first and foremost, and I know you've heard this from me before, but this bill will place victims at increased risk of lethality. Domestic violence is the most lethal crime in the state, and more than 50% of homicides are the direct result of domestic violence. The majority of these homicides are caused by firearms. We know that domestic violence and firearms are a deadly combination. A victim of domestic violence is 5 times more likely to be killed by their abuser if there is a gun in the home. Firearms in the hands of those who have been violent increase the risk of lethal outcomes and serious injuries, not only for the person who is protected by a court order, but also for the community at large. So this is really about public safety at its core. This bill puts the burden on a victim to further prevent their abuser from accessing these deadly weapons. This can potentially put them in more danger because they will have to go before a judge just before the protective order would expire. I want to clarify some of the statistics that were shared earlier today. According to the most recent report from the Domestic Violence Fatality Review Committee, which I have a copy of the report I can pass around, actually only 40% of final protective orders were granted between 2020 and 2021. And they do it on a biennial basis, so we won't have the next report for another year. So I think it's just really important to clarify that there is a very high bar in order to get a protective order. They're not handed out freely. It is not 75%. And so in order to be granted a domestic violence protective order, 3 things need to be true. There needs to be a finding that the law has been broken, that domestic violence has been committed, and this is in a civil process and not a criminal process. There needs to be evidence that the victim is in immediate danger, and there is a credible threat of further abuse. So there is a finding that harm and violence has occurred. And so I think that's really important to emphasize here. And I think what's another piece I want to highlight is that this is really about prioritizing victim safety in this process. So we know that the most dangerous time for victims is when they are trying to leave an abusive situation. And when a victim seeks relief by filing a protective order, the process can already place them at risk. It is not always safe to seek relief via a protective order. That is something that needs to be taken with utmost consideration for their safety and whether or not this is the right time or if it could escalate violence. This bill would only further place them in an untenable situation. In domestic violence cases, victims are frequently have to balance their own safety with that of their children and are constantly in fear of making decisions that could further jeopardize their life. When someone has previously exhibited violent behavior and been found by the courts to be a safety risk, why are we putting victims in a more vulnerable and potentially threatening situation? And so again, this is not the appropriate approach to address some of the issues that have been brought up today when it comes to returning firearms. So in conclusion, HB 1337 is a nightmare for victims and makes unnecessary and potentially dangerous changes to RSA 173B, the civil domestic violence statute, which was intentionally written to establish protections and enshrine best practices when it comes to responding to domestic violence in New Hampshire. And I urge you all to please vote no on this bill. Thank you.
Representative Chairman.
Thank you, Mr. Chairman. Thank you for your testimony. But it spurned a question in my mind. If a person that has abused another person and the protective order has been put in place, there has been a conviction of domestic violence, that person then, under the Lautenberg Amendment that was made many years ago by a congressman or a senator from Connecticut, that person is now a prohibited person. They'll never get their firearms back in their lifetime. So I'm curious why, if you'd be opposed if the domestic violence order has expired, for them to go through the rigmarole and still not get they will not get their firearms back. Are you aware of that?
Thank you for the question, Representative. I think I'm following. I would just say that this bill just shifts the timeline in a system that is already working just fine. There doesn't need to be a change to the law, and we have a concern that someone would have to go before a judge to say this person is dangerous days before a protective order could expire, which could trigger retaliation from an abuser. So it's more about the timing and the safety risks that could then come. We feel firmly that the statute is doing what it needs to do and was intentionally designed. Thank you.
Thank you, Mr. Chairman, for the follow-up. And I don't mean to put you on the spot. If the person that has been abused, even if there hasn't been a conviction, still believes that that person's still a threat, they have the ability to go and renew that order, correct?
That is correct. Thank you. All right.
Representative Selig.
Thank you, and thank you for taking my question. I just want to clarify one of the points you made about the most dangerous time might be just before a victim of domestic violence is ready to leave. And I'm not sure if you heard about the incredibly tragic story out of my town of Durham, where the news broke yesterday, where the victim will not be charged because she was acting in self-defense, but that the circumstances were that her abuser found her escape plan, and that's what triggered the final fatal attack. I'm curious, I mean, she didn't have time to get to the protective order stage, but whether there are other people who might be in a situation, and how that might relate, I guess.
Yeah, no, thank you so much for that question. I won't speak to the specific case, but I will speak to the pattern of domestic violence. So domestic violence at its core is about power and control. And that is why oftentimes when someone realizes that the victim is trying to leave, they're trying to then find ways to exert power and control, and that can escalate violence. And I'd be happy to share additional materials with you if that would be helpful. Thank you.
Representative Newman.
Thank you. And this just relates to the question that the previous representative asked about the a prohibited person would have weapons and would never get them back. You said in order to get an order, you need a finding that criminal abuse has occurred. Could you just explain what that means?
Yeah, thank you so much for your question, Representative. So RSA 173B has the definition of abuse and outlines the qualifications that you need to meet in order to qualify for a protective order. There is an enumerated list of other crimes like animal cruelty, simple assault, and stalking and so on. It's a long list. I'd be happy to share the statute with you. And so when one of those things occurs, that is part of the protective order.
Thank you.
To be clear, though, abuse does not have to occur to get the order. Only the threat of abuse can get the order too. Is that correct?
There are some folks in the room that can probably better explain the legal process, but and I'm sorry, I don't have the exact definition in front of me, but you have to demonstrate that there is a credible present threat to your safety, and that has to meet the strict criteria in that list.
Okay, thank you. Representative Stone.
Thank you, Mr. Chairman. Thank you for taking my question. So, under a civil protective order that is expired, an individual is no longer prohibited from purchasing a new firearm or possessing a firearm. Doesn't it make it a moot point to make an additional process to go through returning firearms that were previously owned if they can go out and buy a brand new one?
Can I get back to you on that question? Because I don't know I'm not a law enforcement officer, so I don't know the process around return of firearms. And so I'd like to just look a little bit more into that. Thank you.
Thank you.
Thank you for your testimony. Chair calls Councilor Dave Wheeler.
Good afternoon, Mr. Chairman and members of the committee. I'll try to be brief. I'll start off by saying that I agree with Attorney Dean's analysis of the situation, but I'd like to add a couple of points. When someone is, and the domestic violence order has expired, it hasn't been renewed, it hasn't been made permanent, then there should be a presumption of innocence. So it's my opinion this bill doesn't even go far enough. I support this bill, but I don't think it goes far enough. I would go down to line 29, where it would put the burden, 21, put the burden on the court. The court is the one that issued the original domestic violence order. Put the burden on the court, like it says in line 21, to do the check to make sure that that person hasn't robbed a bank in the last year, that the protective order was in effect, and just have language that says if there is no prohibitor, the court shall
issue an order returning the firearms. And I understand that the law enforcement has some issues. They want someone else to make this decision, so there's no liability on them. So I think we could have an agreement with law enforcement. I think they might agree with this approach by putting this on the court, the one that made the order, and the one that says, nope, we checked your background and you get your firearms. And I would suggest that you consider making this bill even better. And I kind of resent the testimony of some others who said, well, whenever there's an order, they are still presuming that that person is guilty. And if the order isn't extended, they are no longer guilty. They are innocent. So I would ask that you construct this bill with that in mind. Maybe a few tweaks here and there. I'd be happy to work with you on that. I would also say this about the storage. I don't support removing the liability for law enforcement from damaging firearms in this legislation. Firearms are not only a defensive tool, but they are also an asset. Some of us buy firearms because it's like putting money in the bank. When I graduated from high school, I bought a Colt Python, paid $300 for it. That Colt Python today is worth $1,200 if it's in good condition. So if you remove the liability from police of not keeping guns in good condition, you not only hurt the owner, but if you remove that liability, I don't think the police will any longer inventory those guns coming in and put a condition on those guns coming in. It's into their best interest now on the way in to say this gun's in good shape, this gun's in fair shape, just in a layman's, view. But if you remove their liability for keeping these firearms in good condition, I don't think there's any incentive for them to keep them in good condition. I think you need to keep the incentives there. So that's my 2 cents on this bill.
Thank you. I think you might be mistaken. I think that Python's probably worth about $4,000.
It could be, but it's a little used now.
That being said, Representative Jammer.
Thank you, Mr. Chairman, and thank you, Councilor, for taking my question. My question is a little bit semantic. If the bill were to call for the state police gun line to have a report from the SPOTS computer system 2 or 3 days before a DV order has expired that tells them to go and run this guy a gun check and then notify the police department that's holding the firearms that the DV order has expired, he's passed the gun check, give him his guns back. Do you think that would be workable?
Yeah, but I think that the burden should be on the court to go to the gun line. I mean, obviously, when there's a protective order in place now, you become a prohibited person on the gun line. And so there's a mechanism now when you're not a prohibited person to get off. And there are reports that come from the court. And if my recollection serves me right, about 400 a year of these type of cases. And we have the statistics, which I don't have with me, when those requests come to the gun line for the check, the vast majority of them fly right through as an innocent person. So I think there is a mechanism, we could think that through, but I think the burden should be on the court to ask, and I think there should be some timelines, on the court. They can't drag their feet. But also, with my executive branch hat on, we're wasting a lot of court time requiring hearings for all this that shouldn't happen. We're already short about 7 circuit court judges, and we need to see if we can find a way to get rid of some unnecessary work so that the rest of the people can get their justice swiftly.
Thank you for your testimony.
Thank you.
Bill Bright. Chair calls Bill Bright.
Good afternoon. For the record, my name is Bill Bright. I'm a major with the New Hampshire State Police. I thank you for hearing my testimony this afternoon. I just want to say that when I signed in opposed to this bill with the language that it's written as of now. So I think that the way the bill is written now, it shifts the burden to the victim to request a hearing, which I don't necessarily agree with. What Counselor Wheeler suggested in this, the burden being shifted to the court to come up with some sort of way to determine whether or not they can issue an order to return firearms, I think is something that we can work with. My suggestion would be to give us a little time to work on this bill to see if there's some middle ground that we can come to on it. I think that the suggestion that everybody that has a protection order is innocent, that may not always be the case. As you know, criminal cases have to be proven. There's a burden of proof that has to be met in order to get a conviction in those cases, and that's not always possible, even when there are even when abuse has taken place, and there may be many different circumstances to come to that conclusion. But I think that from a law enforcement perspective, a court order is necessary to return these firearms because there has been a determination made by the court that there was a credible threat at whatever point that was. So to put that burden on law enforcement to say, hey, you have to give these guns back just because a year passed, I think that's a difficult place to put law enforcement in. And I just think that there's probably some common ground that we can come to here, whether that's a hearing, and I know that additional hearings can be burdensome to the court, or if there's some process that can be built here so that there's some protections for victims, that they're not put into a difficult situation as this process goes on, as well as for those that are accused, that if they truly are innocent, that they're not that they're able to get their rights restored completely, and for law enforcement, so that we're not put in that difficult situation to make that decision on our own without the court's input when the court has already had input on this process.
Thank you. To be clear, though, if there is no orders have been allowed to expire for whatever reason, and there's no conviction, the state police has no position on whether or not the firearms are returned. It's the question of the burden being on the victim.
Well, the way the law is now, in order for us to return firearms, there has to be a court order.
Right.
So whether just because the protection order expires, we still don't return those firearms without a court order, which is why the requirement is on the defendant to request the hearing to get that court order.
Okay. So if there were an automatic mechanism that upon expiration of the order, the court were to issue an order to return the firearms, would that be sufficient?
So I don't want to commit at the moment, but we would certainly look at the language and help develop some of that language so we could get it to a place where everybody could work with.
Okay. All right. Thank you. Further questions? Representative Muse?
Isn't part of the reason why a hearing is part of this process to determine whether or not a creditable threat remains?
That could be part of the process, and this is this is what I'm talking about. Maybe that still needs to remain part of the process. I'm not sure. I just know that there's a lot at stake if this bill were to go through the way it is right now. I think it's worth taking a deeper look at. I also think that there's some requirements for the checks through the gun line and the criminal records and things like that should probably take place.
Thank you.
Representative Chambers?
Thank you, Mr. Chairman, and thank you, Major, for taking my question. I'll try to speak up a bit here. I had said earlier to another person that was testifying that if a person had a DV order against them and they surrendered their firearms, and during that year period they were convicted of a domestic violence criminal statute, then they would become a prohibited person. Is that your understanding as well?
I believe that the protection, it could become a permanent order for the protection order, and that there may be some things established with that conviction that would prevent them from owning firearms. Yes.
Follow-up. Thank you, Mr. Chairman. And as a follow-up to that, if there has been no conviction of the criminal domestic violence, which would trigger the Lautenberg Amendment, and the order has expired, other than liability of the police department that's holding the firearms, is there, I understand you're saying the court told us to take them, we want the court to tell us to give them back. Is there anything on your end that you would get a notice that this DV order is expiring? Do you get that notice at any point?
I actually don't have the answer to that. I don't deal with these on a regular basis, but I can find that out. I'm not sure.
Representative Stone.
Thank you, Mr. Chairman. Thank you for taking my question. As I said before, and you probably heard my last question, if we have no legal basis to deny somebody a right to purchase a firearm once the orders are expired, what legal basis do we have to retain their property if it was seized, other than the current state law, which might sound very questionable to some of us on this committee?
Well, the current state law requires a court order to return the firearms. And so that's the basis of my statement. So I guess that is the basis of us keeping those firearms at that point. I don't want to keep somebody's firearms that we don't have a right to, but in that instance, the court has determined that we are supposed to take their firearms. I think it's reasonable for the court to determine that we give them back.
If I may just clarify, I think what we're all asking is if the order's expired and the person is not a prohibited person and they can go to the gun shop and buy a bunch of new guns, why make them go through the hoop of getting the order and all that? And you see what I'm saying? It seems like it's, why do it if they can get them anyway from, they're not a prohibited person?
I see what you're saying now.
Yeah.
I didn't understand before. So I don't have a good answer to that question, unfortunately.
Can I have a quick follow-up? Yeah, go ahead. Is it more of an administrative thing that there is no mechanism currently in play that notifies your agency that this person's now orders are expired? There's nothing prohibiting them from receiving the firearms? Is that the paperwork concern of your agency, is the liability aspect of returning someone's firearm without knowing what the standing in the court is?
Well, I don't want to speak to whether there is a mechanism in place because I'm just not sure that there is or not to let us know that that court order is expiring. There may be, I'm not 100% sure. And there may be, I'm sure that there's somebody in this room that probably knows the answer to that question. And the rest of your question was just whether or not, can you ask the question again? I'm sorry.
Basically, I'm asking, is it kind of a CYA thing to make sure that you're giving the guns back legally to somebody?
Yeah. So before we return any firearm in any case, I mean, I think it's prudent to run the necessary checks to determine whether or not that person can legally have a firearm. And that does take place now.
Thank you.
Thank you for your testimony.
Thank you.
Chair calls Attorney Steve Enders.
Good afternoon. My name is Stephen Enders. I'm an assistant county attorney in Merrimack County. I've been a prosecutor for over 20 years. I do disagree with some of the wording in this bill. And as we just heard, I think a court order is necessary really to return firearms. When we talked about the process earlier, as many people have said, you have to file a motion for return of firearms. It's a one-page form that you fill out, and I can certainly leave this with the committee. It's a standard court form. It's nothing onerous to fill out. It's nothing that really would require an attorney to fill out. It's my understanding that there's no filing fee associated with filing a motion for return of firearms, so there's no cost in doing it. In terms of time frames, there is a time frame in the statute in RSA 173 B5 section Roman section 10A. It says you can file that form within 15 days of the expiration of the protective order. And upon receipt of such a motion, the court shall schedule the hearing no later than 15 days after the expiration of the order. So this isn't a case where, this lags on for 6 months. With reference to, the term innocent, I think that's certainly a loaded term. While these people may not have been committed of a crime, there is a judicial finding that they present a credible threat to the safety of an individual. And I think if the court makes the finding that you present a credible threat to the safety of an individual and orders the police to seize your guns, it makes sense that the court should be involved in returning those firearms. So to me, it makes sense that you would need a court order. The motion simply triggers the court order. It doesn't make sense and the hearing on that motion to return firearms is very limited in scope. Again, under 173B5 Roman 10A, there's two things which the court can consider. The first thing is whether or not the defendant is subject to any state or federal law or court order that prohibits them from possessing a firearm. And the second is whether the plaintiff has requested an extension of the protective order. So having the plaintiff start the process to prevent the return of firearms almost makes no sense to me, because the plaintiff may say, look, I'm scared for my life. I'm not going to renew the protective order, but I'm very frightened of this individual. Well, the plaintiff couldn't theoretically go to the hearing and say that, because that's not one of the things the court is empowered to consider when returning firearms. And I presume that the reason the statute reads the way it does now is to prevent essentially like a red flag law situation where it's pretty black and white. If you're legally entitled to possess your firearms, the court returns your firearms. With reference to the striking of the fees and the liability for the police departments, really that's a policy issue for you guys to decide. As I said once before, I've never heard of fees being charged. Again, when you look at the fees statute, the police department can't make money on that. Essentially, they can pass fees along if they encounter fees. And I can certainly envision a scenario where a person in a small town has a very large gun collection and the police department simply can't store it, stores it with either a storage company or has to rent a facility to do that, and passes those fees along to the person. And I mean, really, that's a public policy decision, whether those fees go to that person or are spread among the taxpayers in the community. And it's really the same thing with immunity. With reference to, some of the stories you hear about evidence officers being unavailable or taking time to return firearms, this bill doesn't address that, and that's going to occur, no matter what happens. I've told people before, I ended up having some of my property in a police department property locker, and I tried to get it back, and I'm the guy who writes the motions for the police department. I'm on a first name basis with everyone in the police department, and it took me about 2 weeks to try and get an appointment to get my property back, because everyone's busy and everyone has their own schedules. But I do think that it is essential to have a court order. And I would just note as well, whenever the police department obtains property, and we're not just talking about firearms, we're talking about any property the police department obtains, there is a statute under 595A6, which sort of defaults that the court should request the police department holds the property as the court is directed. So in order to get property returned, I would seek a court order almost no matter what that property is. So I don't think it's unusual to have the police, request a court order. With reference to sort of the two-part, the question of, well, if this person can go out and buy a firearm anyway, what's the point of the police department not returning their guns to them? I think there's a two-part answer to that. The first is, how does the police department know this person can go out and purchase a firearm? Because I don't think the police departments can run NICS checks on people who come in and say, I'm here to retrieve my firearms. The second part of that answer is liability. And while you may say, well, there's no real liability there, it's more than liability. There's a public perception. If a court made a finding that a person presented a credible threat to the safety of another, so much so that the court ordered that they relinquish their firearms to, say, the Concord Police Department, and that person then went to the Concord Police Department at the expiration of that order, picked up their gun, and went and used that gun to kill their victim, I guarantee that it's going to be all over not only the local news, but the national news that that person received the gun from the Concord Police Department. And whether the Concord Police Department had a legal obligation to return the gun or not, nobody wants that exposure. Nobody wants to be on the news for that. So we are always going to default to wanting a court order. I'm happy to answer any questions.
I understand the concern, but it seems to me that it could be much more streamlined. If someone gets a temporary order based on allegations they make, we know that sometimes they don't follow through and that order's allowed to expire. They just never come back for the following hearing.
Yes.
So the person now has to incur the expense of going through another hearing to get the firearms back that were taken, that the person never came through and followed through with the order in the first place. It seems that in the interest of justice, someone shouldn't have to go get their property back and pay that kind of money if it could be more streamlined. It seems that to me. If it's not carried through and it's not followed through on.
Well, again, in order to obtain a temporary order, the plaintiff needs to make a showing as well that there is, and it's actually, in my opinion, a higher showing than a permanent order, which again makes sense because it's granted on an ex parte basis. So the plaintiff does have to make a showing of abuse and essentially some threat that they need it immediately. So there is a finding made. With reference to whether or not that person follows through, one of the things I can say is that domestic violence is unlike any other crime. It's very frustrating as a prosecutor doing domestic violence cases because I think the National District Attorneys Association talks about 80% of victims recanting. And certainly that doesn't mean it didn't happen. It's that victims' goals in domestic violence cases vary very differently than the normal sort of crime victim. If someone breaks into your house, you may want that person punished. You may want that person to go to jail. But with domestic violence, you're talking about a person who's an intimate partner. So most victims want the abuse to stop. And that's their main goal. And they may get a temporary order and feel that the abuse has stopped. And there may be factors weighing in on them to not get a permanent order. And it's not that it didn't happen. It's that they think that's the safest thing for them to do at that point is not follow through. So I don't think you should read too far into a temporary order being issued, but then a victim perhaps not following through with the process. I don't think that means that they're not in danger. I don't think that means that the firearms shouldn't have been seized to begin with.
No, I'm not saying they shouldn't have been seized. I'm just curious as to whether or not you think there's a way to streamline it so that in the cases where the person could, in fact, go buy more firearms,
right,
that they don't have to pay extra to go back to court again to get their property back.
Well, and I think Representative Wheeler's suggestion, essentially that the court begin these sua sponte, is a possibility to streamline that. Right now, as I was saying, you have to file a motion to trigger the process. You could certainly have, upon the expiration of the protective order, the court triggers the process on its own. But I think that's a sizable burden on the court.
Representative Pratt, hold on. We have a list.
I'm sorry. Counselor Wheeler. Sorry.
Thanks. Yeah, thanks for the question. When an honest person goes to court to release their property back after they've been not charged, nothing holding against them, you recommend a one-page form? You recommend going to court without a lawyer?
I'm saying that the court has created a one-page fill-in-the-blank form to streamline the process and make it easier for people.
So you just fill that out and you don't have to go to court?
You would fill this out, file it with the court, and the court would give you a hearing notice. And then you'd show up at the hearing. And again, there'd be two things considered at the hearing. The first would be whether or not you're a prohibited person, which You
Right.
could stand there quietly, and Gunline is the one that would have to say you're not a prohibited person, and whether or not the order's being extended.
Okay. I'm only aware of 3 cases of this happening, and every one of them was multiple months, multiple dollars, multiple legal fees, more money than the guns were worth in 3 different cases. That's a problem, I think, that's just what we're talking about today. You also mentioned a police department couldn't run the NICS check. Why couldn't they, before they released the guns, run a NICS check?
I think they're prohibited by law from doing so.
Really? They do it every day. I was wondering why they couldn't do it for that.
They can run a criminal record check every day, but to run a firearm specific
NICS is
check,
separate.
the
Okay.
FBI doesn't let them do that.
All right. Thank you.
Representative Stone.
Thank you. Thank you for taking my question. Would it be satisfactory if, like at a final hearing, if the petition was dropped or found not sustained, that there could be a simple box on the form that could AOC or judicial branch could implement to facilitate firearms being returned, since all parties are at that hearing? Or at least if the other party didn't show, at least somebody appeared before the judge. Would that satisfy the requirement in your mind for at least that portion of it?
I think that there's sort of 2 parts to that. I think that you could check a box to initiate the hearing, but I still think there should be a NICS check prior to returning the firearms. So I think that those 2 considerations that are currently in 173B5, 10A, 1 and 2, the court should still make those findings prior to issuing the order to return firearms.
Follow up. So again, it sounds to me like the real issue is deferring the liability onto the court from the agency. Is that correct?
I think having a court order, again, is appropriate.
Putting
What
it on the
triggers that court order, I don't know that I care, but I don't think it should be on the victim to
Or the agency to
get
return the
involved.
firearms.
Right.
Safe answer. Thank you.
Thank you.
Representative Psychiatric.
I have a question and a half.
I have an answer and a quarter.
Typical lawyer. Now, first part is this. There's something a little slippery in what you had said earlier. I'm not sure if you buffed it out later, but it sounded like this. I forget the context, but it was, but she's still scared, but she's not going to renew the order. Well,
Yes.
now wait a minute. If you had the gumption to get the order in the first place, why isn't this order continued? It would seem that if the facts and circumstances have not materially changed, it would be an automatic extension. I want to talk about that particular part of what you had said. The other thing is this, and this is the half question because others have asked it. Sounds to me that with a little bit of education, you can do this pro se. If you're clean when it's after the expiration of the order, protective
Yes.
order. They're my
I'm happy to answer your half question first, which I think you can do it pro se. Again, it's a pre-printed form that you fill out, you file it, there's no fee, you go to the hearing. There's 2 things to be considered at the hearing. I'm sure you can find lawyers that are willing to take your money to do that, just like, you can find lawyers to represent you for a speeding ticket. With reference to your first question about why a person who is in fear for their safety not renew a protective order, again, my experience has been that domestic violence is a very complex thing. And I've seen victims act in ways that wouldn't necessarily make sense to you or I, but certainly make sense to them in the circumstances. So I do think you have people who choose not to continue protective orders without feeling secure.
Thank you for your testimony.
Thank you, and I'll leave that form with you.
Thank you. Is there anyone else wishing to testify in this bill who has not turned in a card? Seeing none, I hereby close the public hearing on House Bill 1337, and we will be 10-minute recess before the next hearing. No. What? Lunch? No time for lunch. 15. I have to actually leave, so I have to introduce my bill, and then you guys can take it. I didn't think of that. Oh, you're right.
Ladies and gentlemen, before I open the public hearing for House Bill 1711, first off, I would just like to thank everybody for their patience today. We are aware that we are running a little bit behind. We want to give everybody the opportunity to speak because that's what you came here to do. On this particular bill, I will ask that if we call your name to testify and what you had planned on saying has already been said, please just let us know so we can move on to the next person. And I would like to remind the members of the committee that you will be recognized to ask questions only. Please keep any of your comments or lead-in stories for the executive session. With that being said, Mr. Chairman,
Jeff,
I now open the public hearing for House Bill 1711.
You're not going to bang the hammer? Wow.
I just did.
It is heavy. Okay. Thank you. My name is Representative Terry Roy. I represent Rockingham District 32, and I'm here to introduce House Bill 1711. 1711, the reason I brought 1711 in the first place, as many of you are aware, there was a tragic killing of a former police chief at the New Hampshire hospital last year. It came to our attention that the person responsible for that shooting had been a previous patient of the hospital and had had firearms taken from them in the past because of their mental illness. They should have never had firearms after that. There's a federal law that says that if you have ever been involuntarily committed or determined to be a mental defective, which is an ancient term, in other words, mentally ill and dangerous, you are a prohibited person from having firearms. In New Hampshire, we have, up until 2016, there was never a law that required reporting of people who have been found or who have been involuntarily committed because they were dangerous, reporting it to NICS, to the FBI, so that they would be added to the list. In 2016, Representative J.R. Hole from the New Hampshire Firearms Coalition put a bill in that said that no one could be reported for being involuntarily committed unless they had been first deemed by a court to be dangerous and there was a court order. Well, that was already law that you had to go before a judge to be involuntarily committed. The process to be involuntarily committed requires that you get an attorney if you can't afford one. One's given to you. You are allowed to cross-examine witnesses. You are given full due process before you are involuntarily committed. If after that it's found that you are a danger to yourself or others, the court will commit you involuntarily. At that point, you are a prohibited person. So before Representative Hole put that bill in 2016, we didn't have anything that mentioned involuntary commitment and NICS together. At that point, the Attorney General attempted to start putting people on that list, reporting people. Unfortunately, the New Hampshire Supreme Court found there was a conflict in the laws where the involuntary commitment statute had confidentiality in it that wouldn't allow. The two laws conflicted, and they said it was unclear. This law clarifies that. What this law does is it makes it so that if you are involuntarily committed and found dangerous, because you can be involuntarily committed for other reasons besides being dangerous, but if you're found dangerous, you are going to have your name put on that list. Now, what's important to understand is also in New Hampshire, prior to this, if you're on that list for a mental health reason, there's no way for you to get off, ever. Right now, there's hundreds, if not thousands, of citizens in New Hampshire who cannot buy firearms because either their doctor has reported them, because under RSA 332I:2, a doctor can report you to the Department of Safety. If you are speaking to your doctor and your doctor says, you say to your doctor, I'm thinking about killing someone or myself, they can report you and you'll end up on that list. And there's no way to get off. The ATF will not take anyone's name off of that list unless the state has a law in place that establishes how someone can get their rights restored. New Hampshire has no such program. So anyone who's a citizen of New Hampshire who ends up on that list is there for life, regardless of whether or not their mental health gets better. So you could be a college student and go through a rough time. You could lose a child and you become despondent. Anything could happen and you have a rough period in your life where you are in danger to yourself for a short period of time and you do need mental health and you end up on that list. you will be there for the rest of your life if this law or something like it does not pass, because there's no restoration process in New Hampshire. So what this law does, it does two things. It fixes the gap that was created after Representative Hull's bill came in and said, okay, we'll report to the NICS, and the court said, no, you can't because of the confidentiality. Now, if this law passes, people who are involuntary committed, their name will be submitted to NICS, and eventually, if they get better, they can get their name off that list. So it does two things. It fixes that hole that was created, and it also gives people a way to get their rights back. And it's incredibly complex. I want you to know that we spoke to everyone. We spoke to the mental health professionals. We spoke to the Attorney General's office who worked with us on this. We went to representatives of the court. Any possible stakeholder you can think of that I didn't talk to, I'd be shocked. We talked to everyone, and many of them here in the audience today, if their testimony is necessary. So with that, I'm happy to take any questions.
Representative Muse.
Thank you for taking my question, and thank you for partnering on the bill. Can you briefly run us through the process for firearms restoration under the bill?
I can try. So the ETF actually has a form that has a list of things that have to happen for you to get your rights restored. One of them is that you have to get a judge to say that you are no longer a danger, an independent medical evaluation. As part of that, it has to be entered into the system. I'm trying to think of what else was on that list. You have to get the independent medical evaluation. The judge has to say that you're no longer a danger. And I believe, if I'm missing something else, you'll have to help me out. But there's a specific list of things that the ATF, and what's important to know in this bill is that I put a mechanism in it that if the ATF first has to approve our restoration process. So the bill specifically says, if the ATF doesn't first approve the restoration process, no one's name goes on the list. So we're not putting the cart before the horse. If no one can get off the list, no one goes on the list. So the first obligation is going to be on the Attorney General's office to get that process approved by the ATF. Once they say your process to get people's rights restored is okay, then people's names can start being reported. First, that has to happen. And I apologize if I missed some of the steps, but there are several.
Follow up.
I think the point was just to have people hear that there is a process,
yes.
and that one of the things that this does open the door to is New Hampshire actually being able to get funds from the federal government, because we do have things like the relief from disability process.
Yeah, that's true. The federal government as far as reporting goes, the federal government makes funds available to states to help with their NICS system if they report people according to the federal government's wishes. Well, we haven't been reporting people, so we haven't had the ability to get those funds to help with our NICS system. By reporting and having the way for people to get off, that makes us now eligible to get funds from the federal government to help pay for our system. So that's also a key important part. Not the driving one, but it's a side bonus that we will be able to get those federal funds now.
Any further questions? Thank you very much, Chairman Roy.
Thank you.
Dr. Hannon.
Good afternoon, members of the committee.
Allow me to correct myself. Honorable Dr. Hannon.
It's okay. Joe's fine, thanks. I'm here speaking on behalf of gun owners of New Hampshire, and we're in opposition to this bill as written. There's a few reasons. I understand the intent and naming the bill. I understand this man was a hero. nothing against him. I think he was doing an amazing job in horrible circumstance. He was an unarmed individual whose job was to stop potentially armed people from entering a secure facility. I think that's one of the most important aspects we have to look at when looking at this specific incident. We have too many dead heroes, and I think we need to do things that prevent that from happening. People should be allowed to defend themselves if they're charged with doing something such as this. A few other things, you know, I appreciate Representative Roy talking about this is only for people who have been adjudicated and considered a potential danger to themselves or others. But if you look at the list on page, where is it? On line 24 on page 1, adjudicated as not guilty of a crime by reason of insanity. Well, the person could be temporarily insane, but their deprivation of rights are permanent at that point. And we know that this is something that's extremely hard to undo. Be adjudicated and incompetent to stand trial and found by the court to be a danger to themselves or others. That sounds nice. But then C, involuntarily committed to a mental facility pursuant to RSA 135C 34 through 54. And in New Hampshire, the involuntary treatment standard, the standard to be used by a court physician or psychiatrist in determining whether a person should be admitted to a receiving facility for treatment on an involuntarily basis shall be whether the person is in such mental condition as a result of mental illness as to create the potentially serious likelihood of danger to themselves or to others. This person may not have committed any crime. They may not have actually said they're going to hurt themselves. The standard is different for criminal prosecutions and deprivation of rights as it is for people that are having their rights deprived under these statutes. And I think that's something that needs to be considered. There could be an individual who was a young person or even an older person who was involuntarily committed because of bulimia, because of substance use disorder as a teenager, all kinds of things. Postpartum depression. These are things that are temporary that could lead to a commitment order. And under Section C that I just mentioned, involuntary commitment, that person would not be able to correct that very easily. And we know we've heard for other testimony in different bills that it's a very expensive and costly process. Even if the state does get money, the individuals don't get money to hire lawyers. That money goes to the state. Just a couple of real brief things. There were many reasons, and I don't want to dwell on the fact that this person was unarmed, defending these people in this manner. But the person who committed the crime was, we heard that he was guilty of many other things committed before, and charges were dismissed from probably to competency concerns. But they also had protection orders, and their firearms, not exactly sure the details, may have been taken in the past. How did they get them back is a question I have to ask. And even if charges were dropped, why was there no protective order? There was an inquiry made, I think, by the media not long after this to see what the court order was, and it wasn't released by the court. So we don't know if there was a protective order. Should there have been? That could have been enough to prevent that person from obtaining firearms through a legal means. Nothing would prevent someone from obtaining them through an illegal means or committing harm to themselves or others through any number of other deadly and dangerous means. So I just ask that we take into consideration the words of William Blackstone. It's better that 10 guilty persons escape than that one innocent person suffer. If it may catch somebody, but we're stigmatizing and we're criminalizing by depriving people of their civil rights just by the fact that they have a mental illness in a lot of cases. And I think that's wrong. I'm happy to continue this conversation with the sponsors and see if there's anything that could be done in the future. But as it stands, I think this needs to be ITL'd. The other thing, it's a minor issue, but it's significant to those officers. We're also ordering court officers to go and take the firearms from a person who has this order. That potentially puts the officers in danger, which is part of their job, I understand, and they knowingly do their job well and bravely. But it also puts the person who they're taking the firearms from in danger. What if the person comes to the door with a phone in their hand and they think, that's his gun, and they just shoot him? These things have happened. We've seen it in the media. We've seen it in the news. And I don't want to put not just the officers at risk, but the individuals who are potentially being victimized by having their rights deprived through these means. I'd be happy to take any questions.
Thank you very much. Are there any questions? Seeing none, thank you very much.
Thank you.
Members, Chairman Roy has an amendment for this bill that is here that I didn't know. So I'm going to pass this out. I'm just going to spread them down for you. I'll take the one. Karen Rosenberg.
Would it be possible to grab a copy of the amendment? Are there extras?
Sure. Let's just see how many we have. Brad, do you have any down there? Would you mind doing that for us, please? That'd be helpful. Thank you.
Thank you.
So we are going to get some copies of the amendment that we will have at the back table. We're working on that now for everybody else. Okay. We can at least put those ones over so people can have it. Thank you, Representative. All right, we all set?
Thank
Okay,
you.
thank you for your patience.
Oh, that's okay. Thank you. My name's Karen Rosenberg. I'm the policy director for the Disability Rights Center. We're the state's protection and advocacy system for people with disabilities, and our charge is to protect and advocate for the rights of people with disabilities. So this is a challenging bill for our office, frankly, because it does represent a departure from some privacy protections that were afforded to people with disabilities. And also it involves potentially removing rights that all people are guaranteed under our U.S. Constitution. That said, with the amendment, which I'm hoping it looks like what I think it's going to look like, I think it's something that our office would not oppose. And I want to talk about the amendment and what my understanding is about, assuming it says what I think it says, the concerns that it addresses that I reached out to a couple of you about. So some of the concerns my office has involve privacy and confidentiality of mental health records. And the other issue we have has to do with how traumatic confiscation of weapons could be following an order of dangerousness and an order that someone surrender or have their guns, their firearms removed. And then because that could happen very quickly under the bill as introduced, and the person could be hospitalized and come home to a home that was broken into. And thirdly, our concern has to do with the time frame and process that someone would follow when they're no longer posing a danger, they're no longer committed, and how long they might have to wait for restoration of their rights. So I'm going to try to multitask here and read and explain how I'm hoping that this amendment addresses those concerns. So in the bill as introduced, there's a provision that has to do with what information is communicated to NICS once the person has been involuntarily committed or, falls within this purview of what this bill is trying to address. So what it says right now is, and this is on page 2, I think it's line 10, it allows for the reporting of the person's name and identifier signifying what the applicable prohibition is for them to own firearms, as well as any non-clinical identifying information. That gives me pause, because what is that? NICS, as my understanding is that NICS only requires certain information. Does require the name of the person, does require the applicable provision that would prohibit them from owning or possessing firearms. It does include their social security number, I think, and even their date of birth, but nothing else. So I think it would be, I'm hoping that this amendment does actually remove that sort of nebulous additional phrase from the bill, so that we're not, opening the doors here to certain other confidential information being available. So hopefully that does that. Secondly, with regard to a person who is involuntarily committed. So what the bill provides for is for a court to have the authority to then order that to inquire about whether that person actually owns or has access to firearms, and then to subsequently order that if they do, that those firearms be seized within 48 hours. So as I alluded to earlier, while that might be that could be a reasonable order that the court might make, it would be incredibly difficult as a person who's now in a mental health crisis, getting hospitalized, stuck at a hospital involuntarily, to then be released, come home, and their house has been broken into and their stuff has been gone through, and who knows what kind of state it would be in. So what I suggested to Representative Roy, and I hope is in here, forgive me, I'm not a speed reader, are two things. One is a requirement that at the hearing that the judge would inform the person of this possibility. So even before issuing, thank you, Representative Murray, even before issuing an order, determining whether the person ought to be involuntarily committed and whether, therefore they might be required to turn over their firearms, that the person's put on notice that, this is a likely outcome. This is a possible outcome. If I'm the judge, could order that your firearms be confiscated. But you have an opportunity, if you want to avail yourself of it, to make other arrangements. And in that process, actually, so that person will be represented. They have a right to counsel in involuntary commitment proceedings. So, or even if they are, if they've entered this realm through the criminal justice system, they also have a right to counsel. So their counsel can work with them and talk them through what their options are and provide them with an opportunity to make other arrangements to avoid having their homes broken into. What kind of flows from that also is that if the court does in fact rule that they ought to be involuntarily committed and that their firearms, that they should not have access to firearms, it just sort of neatens things up a little bit to provide these several options that the person would have. So the court could order them to surrender their firearms in accordance with the arrangements they've made. The court could order that they deliver their firearms to an authorized person. This is already in the bill. It just kind of sets it out more clearly. So an authorized person who doesn't live with them to hold on to those, or it could order the police to come and seize the firearms within 48 hours if no suitable arrangements have been made. So it retains that possibility, but it provides a little bit more opportunity for someone to have control over how they choose to dispose of or store their firearms. The third concern for my office had to do with the time frame for being able to just petition the court for restoration. So remembering that it's the court that is going to ultimately decide whether the person in this predicament or this situation is going to get their firearms back or their ability to own firearms back. And what this does is say, if the person obtains an absolute discharge, and I'm going to tell you a little bit more about that, then they have to wait another 15 days, but then they can petition the court for permission to have that right restored. Now, if they do that, the court then is going to have to they're going to have to submit to a mental health evaluation also. So it's not like, there are other processes in place. That mental health evaluation is in the current version of this bill. But just one thing that's really important for you all to know, if you're not intimately involved with the mental health system in this state, is that when people are involuntarily committed to the mental health system and they are at New Hampshire Hospital, they may be released conditionally. And actually that happens quite frequently. So they are stabilized, they are allowed to return to their communities, but they're not really officially discharged from the hospital. They are conditionally discharged. Conditions typically being that they comply with treatment recommendations or orders, actually, in this case, right? So it's generally connecting with their local community mental health center, participating in treatment with a therapist, usually taking some medication. Those are very common requirements. And if the person doesn't comply with those requirements, they can be hauled back to the hospital. The other thing that's really important to know is that when people are determined, when it's determined appropriate to involuntarily commit someone to the state mental health system and to the hospital, these commitment orders can be for up to 5 years. And I've never seen one less than a year. I mean, and they get renewed. So what happens is, someone is essentially not really discharged when they are physically allowed to return home. And an absolute discharge happens when that person has demonstrated that they've successfully engaged with the mental health system. They've demonstrated that they are taking their medications and they no longer present a danger. That's when they get an absolute discharge. For that reason, it seemed really discriminatory to prolong the time period even further for which someone could be just even eligible to petition for restoration of their rights. And so that's why the amendment shrinks that down to 15 days. It also, there's another little adjustment that reflects current practice, which is that generally in these involuntary commitment cases, when there's an evaluation ordered, and there are always evaluations ordered, independent evaluations, the court has a panel of psychiatrists that do these evaluations, and courts generally order these evaluations and then arrange for them to happen. So that's just a small adjustment to reflect what current practice is. And then after consulting with Dr. Fetter, who's the chief medical director at the state hospital, and also with one of the attorneys I know who represents people in involuntary commitment cases, what I learned is that generally these evaluations are scheduled pretty quickly, usually within 15 days. So the bill right now provides for 45 days, which is retained, but the technical adjustment is, and this is in line with, I believe, what Dr. Fetter had in mind, and I think he will confirm this, I hope, is that the thinking was that these evaluations would be completed within 45 days, not just scheduled within 45 days. So that's the small tinker about the timing. And then the other timing that I inserted, or well, hopefully you will insert, that's in this amendment, is to also create a time frame for these hearings to occur. Because, like I said, someone could be unconditional discharge for years and years, and now they're absolutely discharged. How long is it reasonable to prolong, their opportunity to have their day in court? And so what this would do would say, okay, 15 days you file your petition, 45 days later you have, you've had your evaluation, it's reported, and 15 days after the completion of the evaluation is when the court would schedule a hearing. So within 60 days, the court schedules the hearing. It seems fair because you've already waited a pretty long time to have your day in court, and you'll have an opportunity to review the results of the evaluation. The last thing it does is it maintains a provision that generally, if the person loses, they've filed their petition, they lose. Generally, they would have to wait 2 more years to file again. But what this does is it inserts some, it basically puts some discretion on the part of the court. If there's a compelling reason why the person ought to be afforded an earlier opportunity to petition again, the court would have that authority to grant it. And that could come up in a situation where someone's situation changes, like maybe their behavior was attributable to a brain tumor that, was operable, and that's why they behaved the way they did and ended up in the hospital. So it just basically gives some discretion to the court. It doesn't require them to do anything. So I think that explains everything that's in here. And please ask questions.
Thank you very much. There is a lot to take in here. Representative Wheeler.
Thank you, Madam Chair. Thank you for taking my question. I actually have a really simple question, and it's just I can't write as fast as I would like to, and I didn't get what organization you work for.
Oh, sorry. I'm with the Disability Rights Center of New Hampshire.
Thank you very much, and thank you
for
the work that you're doing.
That was a softball. Thanks.
Absolutely.
Representative Muse.
I wanted to thank you for your input both before and after the hearing. I wanted to one of the things that I wanted to try to get into a little bit, because it in a hearing like this we get so mucked up in the details, but why is it important that we're paying as much attention as we're paying in this bill and in this process to the people who the bill would actually prohibit from possessing firearms? I mean, why are we kind of an inelegant way of asking, but why is this why is what we're doing here by creating this amendment, by making sure we get these processes right? What are we accomplishing for people?
I think that what we need to recognize is that people with mental illness ought not to be stigmatized unnecessarily or discriminated against in terms of their access to and ability to enjoy the same civil rights that everybody else can enjoy. And I think that's that's why it's important to get this right and pay attention to those people, because we as a society often look upon someone who has experienced a mental health crisis or experiences mental illness as less than and less entitled to the same lives that that are enshrined in our Constitution. And that's wrong. And that's why we ought to care about making sure that, yes, if someone is dangerous and they are actively dangerous and actively posing a risk, we have a mechanism to respond to that, and can make a rational, and decisions might be made that we do this with people who are felons, right? Courts will, if you are committed a violent crime and you're a felon, a court will remove your right to possess firearms. You will, because of dangerousness. And I think that it's a mistake to assume that just because someone has a mental illness that they are dangerous. It's an assumption that's really unfair.
Thank you.
Thanks.
Representative Knoll?
Thank you, Mrs. Chair, and thank you for taking my question. As the, I think I said miss. Anyway, Madam Chair. My question is around confidentiality, and especially when we're discussing the stigmatization, and of course we don't want to put anyone in that position. I appreciate that you're here to really guide us and help us make sure that we do the best we can for people with disabilities. My question is, to your understanding, having worked with the sponsors to bring forth this amendment, when it is reported, if someone goes to purchase a weapon and then they cannot because of a situation like this, does the privacy provide for that information not to be conveyed to the person that they're trying to purchase a weapon from? The reason?
So I've had zero personal experience with NICS, but my understanding from people who know more than I is that when someone goes to purchase the firearm, and if they are on the NICS list, the licensed firearms dealer would get a notification that they are not eligible to purchase the firearm. I don't think that they would receive information about the reason why.
Thank you.
You are correct.
Phew.
Representative Selleck?
Thank you, Madam Chair, and thank you for taking my question. I just want to clarify, you made a reference a few moments ago to withholding weapons from convicted felons. You are not equating people with mental illness.
Oh, my
You are making
goodness.
sure to make a distinction between those two. I just
Yep.
wanted...
Oh my goodness. No, thank you. No, I didn't mean to do that at all. I think what I'm trying to say is that courts know how to remove, weapons from people who are dangerous. And I understand how that might be necessary at times. And I just use that as, an example.
Okay, and can we ask a quick follow-up? And people with mental health illnesses can presumably recover, yes?
Oh, thank you for asking that question. Yes, all the time. People with mental illness can recover fully, can also, if it's more of a chronic nature, can manage their symptoms with medication and treatment. I mean, that happens all the time.
Seeing no further questions, thank you very much.
Thank you.
Victoria Sullivan,
She had to leave.
she gone. All right. Stephen Burrow,
I am for this bill.
if you could just state your name. I know I did, but
Stephen Bureau, representing myself. I think there should be other amendments to this bill because there's people that are having adjudicated or committed mental defective added to their NICS background check, but were never found incompetent, never found to be a danger to themselves or others, and were never involuntarily committed. But yet they have adjudicated or committed mental defective on their record where it doesn't apply. And there's no way to remedy that. And that's wrong. I mean, if a person is denied because of, such a finding on their record, there should be justification for that information to be there. And I'll give you a couple instances. There's a person who was denied a permit to carry. They actually received the federal background check, which they're not supposed to receive. That's not supposed to be copied or disseminated to anybody, including who the check is done on. However, the NICS background check came back with adjudicated or committed mental defective, and it showed the court, the case number, the charge ID, and when that information was referenced, looking at the case summary, it showed that that person had the charge dismissed. There was never a question of competence. There was never a finding of dangerousness. The person was never involuntarily committed or had any other prohibiting factors, but yet had adjudicated or committed mental defective on their record. How's that person supposed to have that removed from their record? It should have never been there to begin with. So I think there should be amendments in this bill for people who have false information added to their NICS background check to have that removed. And they shouldn't have to jump through all the hoops. If that information is false and it shouldn't be on the record, a person shouldn't have to go through a trial in court and then an evaluation to prove that they're competent. There was never a proper finding for that to be there. Another instance, a person had another court case. The charge was dismissed. The person was allegedly found incompetent to stand trial, but not a danger to themselves or others. They were never involuntarily committed. And in fact, that person turned around, had that charge annulled. Once something's annulled, the person is to be treated as if that arrest has never taken place. But the state turned around, went to the court, wound up getting access to annulled records, non-conviction, wound up getting access to sealed documents pertaining to a evaluation. The state turned around and then had adjudicated or committed mental defective added to that person's record. There's no finding of dangerousness. The person was never committed to a mental institution and didn't have any other prohibiting factors. In fact, had a clean record. And the question of competence is being thrown around way too much. There was a case in, I believe it was 2007, in the New Hampshire Supreme Court, the state of New Hampshire versus Scott Buchanan. And the Supreme Court made it perfectly clear that incompetent to stand trial cannot be equated with adjudicated or committed mental defective. There has to be the question of dangerousness. The state continues to equate incompetent to stand trial, regardless of if you were found not to be a danger to yourself or others, or even involuntarily committed. The state is still equating incompetent to stand trial with adjudicated or committed mental defective and having that placed on people's background check, denying them their constitutional rights. Now, in order for a person, if a person was found adjudicated or committed mental defective pertaining to a criminal case, that person wouldn't be able to have those charges annulled. Another thing is, if there's a question of competence, that denies a person the right to file suit against, say, the police if it was an unlawful arrest on false charges and the person had their rights violated. That person no longer can file suit in the United States District Court under Section 1983 for rights violations. It deprives them of that right. Now, there's another instance where a person had a criminal case. They represented themselves. If there's a question of competence, a person cannot represent themselves, even if it's a Class B misdemeanor, and they typically wouldn't be afforded appointment of counsel. If there's a question of competence raised, not only is the judge obligated to file for an evaluation, but that person can't represent themselves. But on a criminal case where an individual represented themselves, there was no question of competence, there was no finding.
Mr. Burrow, if I could just, are you speaking on House Bill 1711 or 1701?
1711.
Okay. Please disregard.
Now, on that case, the person represented themselves, and there was an alleged finding of incompetent to stand trial, but the person was found not to be dangerous. What's to stop the state from taking that and placing incompetent to stand trial on that person's record? There was another case where, and the question of competence only pertains to criminal cases. But yet there's a case where an individual had a speeding ticket, represented themselves, and the judge dismissed the speeding ticket, claiming that the defendant was incompetent to stand trial. That doesn't make any sense. What's to stop the state from taking that incompetent to stand trial, even though it doesn't apply to such a case, and the person is not a danger to themselves or others? What's to stop the state from adding adjudicated or committed mental defective to that person's record? So there should be some sort of remedy for people who have had adjudicated or committed mental defective added to their record, but that's incorrect. It doesn't even apply to them. So I'm just asking that there be some other amendments made to this so that people who have had adjudicated or committed mental defective to their record and it does not apply, there should be some remedy that or process that a person can go through and have that false information removed. I think there's parts of the system that are being abused and people are being denied their rights and privileges. So I don't know if there's any questions.
We'll find out for you. Representative Knoll?
If I am remembering from what Chairman Roy introduced in the beginning, what he was talking about, one of the benefits of this bill was that it did allow for someone to adjudicate and be removed from it if it were a temporary situation. So if that is indeed the case, are you in support of this bill?
I'm sorry.
It sounds to me like you're discussing your concern is around whether someone can be removed and if there is a process for someone to be removed from that and therefore restore their right to possess firearms. So my question is, if that is provided for in this bill, a remedy and a process for that to be adjudicated, are you in support of the rest of the bill?
Yeah, absolutely. But but what the bill covers is for people who have been through a legitimate process and been found incompetent to stand trial and dangerous to themselves or others, which would fit the criteria for involuntary commitment. But if a person hasn't been found to be a danger to themselves or others, nor have they been involuntarily committed, then it shouldn't be on the record. Only a person who's been through the process and had a finding of incompetent and dangerous to themselves or others, or has been involuntarily committed, or other things that are covered, it only applies to them. It doesn't apply to people who have had the information falsely placed on the record where it doesn't apply, because then that person who's had the information added to their record falsely would also have to go through the same process, which means they'd have to go to court, they'd have to be evaluated. And a person who has never, you know what I mean? If the information isn't correct, a person shouldn't have to go through an evaluation and this and that because it never applied to begin with.
Okay, thank you.
Thank you.
You all set? All right. Thank you very much. Jay Simpkin.
Good afternoon, Madam Chairwoman and members of the committee. Thank you for giving me an opportunity to testify. I make it my mission when I testify to bring information that I'm fairly certain will not otherwise reach you. In the interest of full disclosure, I'm a federal firearms licensee and have been so for a tad over 40 years. So I'm well familiar with ATF as an agency. I want to again repeat a foundational fact, which often is overlooked or not known at all, which is, as at end 2022, there were approximately 474 million firearms in the United States. These are firearms made after on or after 1 January 1898 to present. There are various exclusions, and I could list them if you wish. Anything so numerous cannot be controlled. Everyone here seems to assume that someone who is prohibited has to go to a dealer to get a firearm. This is simply wrong. Criminals own and rent or sell firearms. People can borrow firearms from neighbors. So the notion that, oh, we're going to enact this and it's going to stop those who are mentally defective and dangerous from getting firearms, this is simply pulp fiction. It will stop some of them, but it will not stop all of them. Now, to come to the specifics of this bill, and I have prepared testimony, this bill, if enacted, in effect, in fact, will ensure that those who have a spell of mental distress forever lose their civil right to be armed. The bill should be subtitled the Roach Motel Gun Control Bill. And it should, as it is, and even as amended, should be voted inexpedient to legislate. The bill's proponents set forth ways for a person who has been involuntarily committed to regain their civil right to be armed. But those pathways are a fiction. They're a fiction because a person who has been involuntarily committed cannot choose his or her own attorney, and key point follows. And they cannot have that attorney's fees and costs reimbursed from taxpayer funds at that attorney's normal hourly rate. So basically, once someone has been involuntarily committed, they are in the Roach Motel. They check in, they can never check out. And in my prepared testimony, I will actually direct you to the website for this Black Flag product. There's a YouTube from 1981. the idea here that a court or a doctor is going to make a finding that an adjudicated person has regained mental health and is eligible to own firearms, I suspect is pulp fiction. Those of you with long memories may recall that in the 1988 presidential campaign, much was made of the fact that a Massachusetts governor had granted a furlough to a convicted murderer. And while this convicted murderer was furloughed from prison, he committed other violent crimes. The idea that a public official, whether a judge or a doctor, is going to put their good name and their financial well-being on the line by certifying that someone is cured. It may happen. I don't think it happens often. Why do I come to this conclusion? Well, here in New Hampshire, since 1996, pardons have been few, likely fewer than 5. So few, I can't find any official data. So if the governor or the governors of New Hampshire have not been willing to grant pardons very often, why would one think that other officials would in effect grant a pardon? I'm deeply skeptical of that. The other issue that I think is not well understood has to do with the costs of litigating with a state. I have some relevant experience. This is a Massachusetts temporary non-resident license to carry. Its predecessor was revoked wrongly in 2009. I spent about $125,000 to recoup the license, which I did by virtue of a unanimous decision in order of the Supreme Judicial Court of Massachusetts in mid-2013. The cost would have been far higher had I not done most of the law and legislative history research. So the idea that a person who has been adjudicated can somehow handle this on their own resources, it may be occasionally true, but I think that would be by far the exception that proves the rule. Further, there's another assumption behind this bill that I believe is factually wrong. And that error will have catastrophic consequences. Once a person's name is put into the federal FBI NICS databases as having been adjudicated, New Hampshire has no way to compel the federal authorities to recognize any restoration of their civil right to be armed. I understand in the bill there's this provision, we'll make a deal with ATF, but ATF can change its mind, and it does. For example, there was, circa 1990, a type of shotgun that was fed by a 12-round revolving cylinder. So each shot, the cylinder, just like a revolver and a handgun. ATF allowed it to be sold. Then ATF said, wait a minute. There's no, quote, sporting purpose, end quote, for such a shotgun. We are going to reclassify it as a destructive device. So every time that it changes hands, a $200 tax has to be paid. ATF can change its mind. It did, and I can prove it. And they wouldn't argue with me. Fast forward. You've probably heard about arm braces being used on certain types of pistols. ATF initially said, no problem. Then they said, no, we think putting one of these onto certain pistols makes a short-barreled rifle. Then they went back to saying, well, maybe they are permissible under certain circumstances. So the notion that a deal that you make or that the Attorney General makes with ATF is set in stone, sorry, Representative, is wrong. This isn't theoretical. As a non-attorney representative, I appeared before the New Hampshire Supreme Court on behalf of a friend who, a dozen years before, had acquired a simple OUI conviction in Massachusetts that made him a prohibited person under federal law. He went before a specifically created Massachusetts entity called the Firearms Licensing Review Board, which found that he had changed his ways, and they gave him a letter so stating. In due course, he moved to New Hampshire. He, being an honorably discharged veteran, Army, decided he wanted to work as an armed security guard. He applied for that license to Department of Safety, disclosed his OUI conviction.
Mr. Simpkin, if you could please stick to exact.
I am right on, Madam Chairman, I am right on target. So I'll sum it up really quickly.
Thank you.
Even though he was totally honest with Department of Safety, they revoked his license. He sued, they restored it. Then after that, Safety, probably at the behest of the U.S. Bureau of Alcohol, Tobacco, Firearms, and Explosives, again revoked the license on the basis that the department didn't want its employees to risk being prosecuted for issuing a license to a person whom the feds considered to be prohibited. Now, this matter ended up litigated before the New Hampshire Supreme Court that found that Massachusetts had restored his civil right to be armed, and his armed guard security license was given back to him. I know because I wrote his brief and was before the court to make his case. Key point, the feds do not have to accept anything that New Hampshire does. The Attorney General of New Hampshire tried to get the U.S. Supreme Court to overturn the New Hampshire Supreme Court's decision restoring his license. The U.S. Supreme Court denied the petition for certiorari. Why that was done, I have no clue. So, any enactment that relies on the feds respecting what you enact here is based on error. And this bill is so based, and it should be deemed inexpedient to legislate. For those who are skeptical, I attach a copy of a letter to the Attorney General from the then acting U.S. Attorney for New Hampshire, providing immunity to state officials who would act to restore this gentleman's revoked license. But he, and we're now 10 years down the road, still will not go to a licensee to acquire a firearm for fear that the feds still deem him prohibited. He will be denied, and then he will have committed a felony because the feds will argue, you knew you were denied, and that we paid no attention to what the New Hampshire Supreme Court decided. I will cheerfully answer questions on anything that I've said or anything related.
Thank you very much.
One final point, very quickly, if there's anyone here who knows who ordained that Chief
Mr.
Haas,
Simpkin, thank you very much. Dr. Hank? I don't think Chairman Roy would agree that this bill should be called.
Good afternoon. My name is Dr. John Henk, and I'm representing the New Hampshire Psychiatric Society and the New Hampshire Medical Society. Both societies strongly support Bill 1711 as an important legislation to reduce the public safety problems of gun violence and suicide. I have worked as a psychiatrist at New Hampshire Hospital over the past 29 years, And I was working at New Hampshire Hospital on November 17th when gunshots were heard in our lobby. All the patients and staff had to shelter in place because an active shooter was in our building. Only later I found out that security officer Bradley Haas had died heroically while protecting all the patients and staff at New Hampshire Hospital. When I first started working at New Hampshire Hospital, I thought that individuals who were committed because they were a danger to themselves or others were being reported to a background check system to prevent them from purchasing or possessing firearms. I thought New Hampshire was complying with the federal Brady law. Eventually, I found out that New Hampshire was not complying with this federal law, and this has resulted in an unsafe public safety situation. House Bill 1711 is a solution to this problem. The American Psychiatric Association has called for legislation to utilize background checks as a way to reduce gun violence and promote public safety. Research on background checks suggests that denying firearm purchase to individuals legally prohibited from gun ownership leads to reduction in the risk of violence among those denied individuals. A study that focused on mental health related firearm prohibition similarly found a protective association when the relevant records were stored in the appropriate background check databases. Another study showed that the implementation of the Brady Act was associated with reduction in firearm suicide rate for people aged 55 and older. In closing, gun violence is a public health crisis. The New Hampshire Psychiatric Society and the New Hampshire Medical Societies strongly support House Bill 1711 as a way to potentially reduce the risk of suicides and homicides in New Hampshire. Thank you for your attention, and I'm open to questions.
Nobody? Thank you very much for your testimony.
Thank you.
Angelo Veltri?
Thank you, Madam Chair and members of the committee. Thank you for the opportunity to publicly address House Bill 1711. My name is Angelo Veltri. I'm the Northeast Regional Director for National Association for Gun Rights, a member-supported organization with thousands of members and supporters in the state of New Hampshire. Today, the committee is obviously hearing comments on 1711, a bill that will tie mental health records to background checks and uniformly report this information to the federal government's NICS system. On behalf of National Association for Gun Rights and our members in New Hampshire, I come before the committee today to oppose House Bill 1711 and vote inexpedient to legislate by this committee. New Hampshire, the live free or die state, has historically been opposed to the overreach by the federal government and has previously taken action to uphold this principle of honoring states' rights. One way in which the state has done this is by passing the Second Amendment Preservation Act, barring the enforcement of unconstitutional federal gun control laws in the state of New Hampshire. This law protects law-abiding citizens and law-abiding gun owners from falling victim to radical ideas of California and New York that we must put unreasonable barriers in place and jump through many hoops and hurdles before being allowed to exercise our God-given Second Amendment rights. Another way in which New Hampshire has defended gun owners in the past was by passing constitutional carry, allowing granted staters to carry a firearm that they are legally allowed to possess. This law has not only saved lives here in New Hampshire, but has also saved lives in the 26 other current states where it has been enacted. As a resident of the communist state of New York, I thank New Hampshire for taking these actions to save lives and protect citizens' constitutional rights. But now, Democrats and Republicans alike are coming together to support House Bill 1711 and undo the progress that they've made in upholding the Second Amendment. This comes in the wake of the shooting at the New Hampshire hospital in November, where a mentally deranged individual would take the life of Security Officer Bradley Haas. While I am for reducing these types of tragic events, this bill will not do a single thing to prevent this type of shooting from happening again. The shooter, John Medore, previously had his guns taken away in 2016 and was taken into custody by Stratford police. Following his arrest and psychological evaluation at the New Hampshire hospital, he was released back into society and subsequently gained access to firearms once again. Proponents of this bill say that by passing it, it will prevent people like Medore from gaining access to firearms because their purchases will be checked against the NICS system and will be denied from purchasing the firearm. There are problems that arise with this check, though, including people being falsely reported as not being able to own a firearm when it's really somebody else with a similar name and identity. If this does happen, it becomes a lengthy and costly process to appeal the decision. And also the fact that Dylan Roof, the shooter from South Carolina who shot up the Black-owned church, should have been flagged by the NICS system, but wasn't because his arrest was never reported to NICS. So this only provides a false sense of security to the general public. Besides the unconstitutionality of the NICS system, the bill, simply put, will not work because of other ways to purchase a firearm. Aside from commercial sales, criminals will still be able to get their hands on guns through private transfers, the black market, or through flat-out theft. This is proven by a 2019 report from the US DOJ showing that only 10% of firearm-related crimes were committed with a gun purchased through commercial means, while 90% were committed with a firearm obtained through private transfer, theft, or off the street. The only thing that this bill will do is dismantle law-abiding gun staters' rights to privacy and disincentivize them from exercising their Second Amendment rights. Overall, our main points of contention with this bill are: 1, the historical framework of New Hampshire fighting back against federal overreach; 2, the unconstitutionality of the NICS system and other federal gun control laws and systems; and 3, that it will only affect law-abiding citizens and not actual criminals from getting their hands on a firearm. With this, I urge the committee to mark House Bill 1711 as inexpedient to legislate and stop the bipartisan attack on gun owners in New Hampshire. Instead of placing more restrictions on law-abiding gun owners, you should seek to let people like Security Officer Bradley Haas defend their institutions by carrying a firearm for self-defense. Thank you, and we'll keep our members informed of your decisions.
Thank you very much. Representative Prue?
So do you believe that if Chief Haas had a firearm that day, things may have turned out different?
Much so, yes.
And the state took away his right to protect himself and to do his duty properly?
Correct.
Anybody else? Right. Representative Psychiatric?
Did you make the statement that the NICS system is unconstitutional?
Correct.
How come the courts haven't, nobody's challenged that? No, has the court found that, or is that your statement?
We can't put our trust in the courts. That's my statement.
Are there any further questions? Thank you, Mr. Veltri.
Thank you.
Let me just ask. Is Dr. Korn still here? Okay. Catherine Giddens?
She had to leave as well.
Oh, I'm sorry, guys. All right. Kimberly, you're up.
I'm not sure if I want food or a drink after this.
Same.
There are multiple bills this session that are nothing more than gun control or gun confiscation bills masquerading as mental health bills. This one is no different. While we should all be saddened and angry that an unarmed security officer, former law enforcement, was murdered, this emotionally written bill does nothing to stop criminals from, number 1, committing murder, and number 2, from getting firearms. One of the biggest issues we have in this state and across the country is mental health. If someone is violently mentally ill, why would they be even released from a secure mental health facility? Rather than pushing more discriminatory gun confiscation bills, why don't we actually do something to address the serious mental health issues we have? We should be reopening mental institutions so that those who are violently mentally ill can have a safe place to live where they won't hurt themselves or others. Contrary to what psychiatrists said in the 70s and 80s, when they pushed closing all of these institutions, some people cannot live in society because they are too dangerous. And we have seen this on multiple occasions with mass killers across the country. We need to stop handing out psychotropic drugs like candy. Many mass killers have been on these drugs. These too were pushed by the same psychiatrists who claimed, without actually knowing, that these drugs would make it so violently mentally ill people could live happily in society. We need to have more and easier access to mental health care. And make no mistake, a majority of people with mental illness are not violently ill. In fact, a majority are more likely to be victims of crime than commit crimes. Pushing gun control as a mental health issue is an affront to common sense, the mentally ill, and our fundamental human right to self-defense. Please vote inexpedient to legislate on this bill and maybe try doing something to help solve the serious mental health issues we have in this state.
Any questions? We're good? Thank you. Representative Psychiatric?
Could you, in maybe 2 sentences, say exactly what your problem is with the bill? I don't want as succinct as you can make it, please.
It's a gun confiscation bill, and it's discriminatory against gun owners.
Okay.
Thank you, Ms. Moran. Dr. Swelter? Was it Sweater? My apology. Doctor, if you're going, if you handed us actual testimony, if you could highlight Representative Psychiatric, please. If you could highlight, if your intention was to read everything that you're passing out, if you could just highlight those parts since you're passing it out, that would be great.
So what I'm passing around is the APA position statement from the American Psychiatric Association. It's not my testimony. Good afternoon, Madam Chair, honorable committee members. My name is Dr. Samantha Sweater. I'm the Associate Medical Director and a psychiatrist at New Hampshire Hospital. However, today I am not representing New Hampshire Hospital, but I'm representing the New Hampshire Psychiatric Society. The New Hampshire Psychiatric Society is in strong support of House Bill 1711, and we would also like to recognize the monumental bipartisan legislation on such an important topic. I also want to refer to the APA position statement on firearms in support of my testimony that I'm passing out and will not delve into during my testimony. One thing I think is important to distinguish is an IEA versus an non-emergent involuntary admission. So this bill would only report people that have been found to have a mental illness and be dangerous to themselves or others by clear and convincing evidence in a non-emergent involuntary admission, which means they have already gone through the is different from the emergency involuntary admission. So the emergency involuntary admission is the IEA, and that is 135C 27 to 33. It is not included in this bill, which is 34 to 54. And the IEA is for people who, that's the prayer and complaint that you file and you send someone to the emergency room, or anyone can file, and send someone that you're concerned about to the emergency room, and then a provider will evaluate that person and then send them to a designated receiving facility on an emergency basis. And then they are detained for up to 10 business days. If the person goes to a designated receiving facility and they're found to have a mental illness and be a danger to themselves or others due to that mental illness, then the provider can petition with the team for a non-emergency involuntary admission. And that's the conditional discharge that you already heard other people speak about today. So that would be an involuntary admission order with the conditional discharge. Outside of that, I do think it's important to distinguish that a temporary emergency involuntary admission order is not covered in this bill as it's currently written. And so therefore the only people who are adjudicated to be found to have a mental illness and be a danger to themselves or others are included in that bill. Outside of the other comments that have been said today, I don't have anything else to add other than to recount the experience on November 17th, as I was also there at New Hampshire Hospital, when shortly after 3 o'clock, I heard a scream and someone sprinted into my office, flew open my door, ran into my office and slammed the door behind herself, hiding behind the door. And she said, "There's an active shooter, call 911. I grabbed my phone, started calling 911. And after I was done, I realized that there had been no code silver called. There had been no announcement. No one else in this building, where there's hundreds of employees, knew what was happening, and everyone was in danger. So I tried to call the paging system, and it was down. We couldn't notify anyone. I've been working there for over 5 years. These people aren't just people I work with. They're my family. And I couldn't tell them that they were in danger. And it was an hour of that. I tried to notify everyone I could, trying to text people and trying to figure out ways of notifying, trying to remember and off the top of our heads the numbers to the units and call them to just try and tell people. And it was genuinely one of the worst moments of my life, just not being able to protect people. I'm a healthcare professional to help people, and I couldn't. For an hour, I just had to sit there while people I love are in danger. And then after an hour, we were evacuated, and it wasn't better. We were all in a room, big room, I suppose. Many of us crowded in a hallway or outside in the cold. And then that's when we found out that Chief Haas had died. And that was someone that many of us saw almost every day, leaving the facility. And a coworker, was murdered 100 feet from my office while I stood there. And then I had to sit there while other people I loved were in danger, and I could do very little to help them. If something like Bradley's Law had existed, it's possible that that wouldn't have happened. And so I urge you to vote ought to pass to try and prevent similar tragedies from occurring in the future. Thank you.
Thank you, Doctor. On behalf of the committee, please accept our condolences for your loss.
Thank you.
There won't be any questions. Attorney Dean.
Good afternoon, members of the committee after a long day. Penny Dean, yeah, that's right. And I oppose this bill for several reasons. The first reason, of course, is ideological, but the second reason is mechanical and practical. This bill is poorly drafted. So even if you support the concept, and even if you support what it purports to do, you've got huge problems with it. Now, I have a copy of the amendment, and I was trying to follow the bouncing ball and make sure I'm speaking to what I believe is the amendment and not the original bill. So if I make a mistake, I apologize, but I'm trying to follow which one replaces what. And so I want to start talking about on page 1, how they number on page 1, is that this applies to people who it's a danger to themselves. And I have a huge problem with this because each person has a right to make their own autonomic decisions. I mean, there are those who cry, say, listen, women have a right to make choices over their own body. Well, if I have a right to make a choice over my own body, the womb, I have a right to make a choice over all of my body, what I do or what I don't do. So you might think, me running out and banging my head against the wall of my house is really bad and it's going to cause a brain injury, but that's my right. You might think another Haagen-Dazs when I need to lose a few might be bad. But again, my body, my choice. And so I want you to consider that sometimes people are, if you will, would come under this bill because of a danger to themselves, not a danger to others. And that's a big, big deal. But secondly, to think that anybody can't get guns elsewhere, I think someone should get in the car with me. We'll go to Manchester, the city of your choice. I bet within 10 minutes we can score some cocaine, heroin, or any other illicit substance you want. They're illegal. Get them, no problem. You just have to find the right street corner. It's the same way with these drugs. It doesn't make it, same way with firearms. There's still people who are going to sell illegal firearms, no matter what. But the other thing you have to look at is that this allows the current bill, if I'm reading the version correctly that I have, on page 2, line 14, allows any party, sua sponte, to order that the person's information be transmitted to the NICS system. I have a huge problem with this. So we supposedly are going to rely on the doctors. We're going to rely on the court, whoever's on the other side. So anybody in the world gets to make a decision except for me about me. I don't think that's equitable or fair. The other problem that I have, and it's a very serious mechanical problem, and it's on page 2, line 15. I'm making sure I'm following the original versus the amended. It's the original version. I think that still is those parts. Page 2, line 15 says, talk about court transmitting it to the Department of Safety for entry into the NICS indices. I think this is such a huge job that when I used to have employees in my office, there were certain things that only I would do because the buck stops here. So the question is, and I'm in no way maligning any hardworking court employees, but do they understand the implications of incorrectly faxing or transmitting the wrong name to the NICS indices? And I would say they maybe don't. So we don't have a designated person here that's doing this. For example, with petitions to annul and annulled files, those are kept in a lot clerk's office, and on the electronic system, only certain people with passwords can see those. Are we going to let any front office clerk fax these things over? Electronically send them over? What if they mistakenly hear what the judge said? That's a huge deal. This has to be handled by a specific, designated, high-level person that really understands what's going to happen if you get it wrong. Next, we look at lines, this is on page 2 still, lines 17 through lines 23, particularly lines 22 through 23. And I know there's been some changes that's part of the amended version, but it still doesn't solve the problem. We have three things here. It is perfectly lawful in this country. I could find a convicted felon boyfriend or husband tomorrow morning at 8 o'clock. They could live in my house, full with my guns and ammunition. I would just have to keep them inaccessible to that felon. In other words, I can still have my guns, I can still have my ammunition, my powder, my primer, my brass. They just have to be inaccessible to that person. What we're doing here in taking this person's guns, and it's very explicit,
They cannot be in a house with guns. So you're going to treat a mentally ill person less than you would a convicted felon. That's got to be wrong on so many levels. So many levels. Because we talk about the authority the court is going to have to take their firearms. So what if that felon's firearms, or I'm sorry, what if the mentally ill person's firearms are in my house? So the police, according to this, are going to have right to come into my house and go through my house. There has to be specifications that if it isn't the mentally ill person's house, that they've got to get a warrant. There has to be some sort of hearing and finding, because a lot of mentally ill people sometimes end up on the street, and sometimes they end up couch surfing through the homes of friends and family, because some of them can't maintain employment or whatever. And so that'll be a true case of no good deed goes unpunished. You've got to make sure, and this legislation does not do it, to find out if you're going to Johnny Joe's house where they're couch surfing, that you need a warrant, and ask Johnny Joe first, you're going to come through and take my guns too? Because that's what this says. Just because I let him stay in my house or on my couch. You have to look further. We look on lines 24, 25, and 26 of page 2. And it says, law enforcement shall carry out the order of the court as soon as possible, but in no cases 48 hours after the order was issued. That is a very short period of time, and we're still not talking about how that is going to be accomplished, because again, they come in with a no-knock warrant. Is this going to be a nighttime warrant? There's a huge difference. When you apply for a search warrant, a judge has a right to say if it's a daytime warrant or a nighttime warrant. I think there should be only daytime warrants allowed, number one, in this situation. Number two, I don't think no-knock warrants should be allowed here. No-knock warrants are dangerous, and it's presumed they're no-knock. They should be knock warrants. That's a huge difference if it's your house. But here's the other issue. What if the person, again, because mentally ill people do make mistakes or deliberately do things, do essentially like swatting does. Say their guns are located at my house and I don't even know them. If we don't have a hearing procedure, we have cops coming and knocking or, quite frankly, breaking down my door to get guns for a person who never lived there. We're just taking that person's word, and that person we're claiming is so mentally ill, we got to lock them up. And we're going to take their word for something like this? There has to be some verification. There's no procedures there. The other issue, which is really huge, and one of the other witnesses touched upon it, is this is all contingent on approval from ATF. ATF speaks with forked tongue, and that is the kindest thing I can say about them. ATF, over the years, has changed their position on what was called street sweepers, and they changed it in such a way, and you have to understand the mechanical thing. People went to normal gun stores, bought street sweepers, had them for years, and if you weren't part of the gun community or checked regular gun regulations, you didn't know that you had 30 days from the date they gave an strike that. I can't remember if it was 30 days or the number of days, but a very few number of days from when ATF made the announcements to register your street sweeper as an NFA device, or it was considered contraband. And after that, you couldn't register it. And if you got caught with it, felon, here you go, federal felon, because you're in possession of prohibited property. No reasonable person would have ever thought that would have happened. But worse yet, the ATF has issued opinion letters to federal firearms licensees and manufacturers, said, ATF, we're building these. They did it with the arm brace. They did it with the reset triggers. And most recently, cases I'm working on in federal court in Boston, they did it with what's called suppressor wipes, where the manufacturers went to ATF and said, this is what we want to do. Please give us written guidance so we can make sure what we're manufacturing is within the law. They gave them written guidance. They said you have to apply for a Form 1 and build your suppressors. ATF is now, about a year later, some 2 or 3 years later, we're calling those Form 1s that they approved saying we changed our mind. They have years and years of history of not honoring their words, with nothing changing on the other party's side. And this is what's important to know. There were no changes in the wipes. There were no changes in the manufacturing. And so we are going to now put our citizens' names in a system where ATF can change their mind about what's acceptable. They did that with Greg DuPont in Massachusetts. They first said it's acceptable that the Firearms Licensing Review Board restore his right to carry, his Second Amendment rights. They then changed their mind years later for no reason. So what I'm trying to say is we are playing a very, very dangerous game here when we rely on ATF to say this is going to be okay and that our process and our procedure is okay. Because here's the problem. Once you get people's names into the federal indices, we cannot make them pull them out. And sometimes they refuse to pull them out. So you have to think about, what are we going to do for these poor people? Their name are in there forever. If you go to the next page, I want to make sure I'm following the pages right. I'm sorry. The other things, the other problems that we have, at least from my perspective as a practical problem, is at these hearings, there's nothing here that says they're going to be closed hearings or confidential by law. So, just like these hearings here or courtrooms, they're public. Anybody in the public can walk in and walk out and hear and see everything that's happening. So you are now going to take this information, which was confidential, and you're going to make it public, because you're going to force these people to make it public if and when they want their rights restored. And so you look at that and you say, why do I want to make this public? And that's going to be my only chance to get my rights back. But I think the other thing that always has amazed me, and it's disgusted me and upset me, is everyone makes a big deal about, oh, they have to be locked up by clear and convincing evidence. We don't lock people up in the state prison other than beyond a reasonable doubt last time I checked. But yet we lock these people up. And that's what you're doing. If any of you have never been to the New Hampshire hospital or Concord Hospital, their special ward, you should go there. You won't like it much. And say that standard is good enough to put these people away. And you look about, and I'm asking myself, when they say the emergency and voluntary admission is not part of this, well, that's not quite telling the whole truth. Because the emergency one becomes a regular one after the next process and procedure, and it becomes one. So the initial one, yes, is not covered, but that morphs into second ones, and I argue that it is covered by this. So to say the initial one is technically true, but it's not telling the whole story. And that's what you have to do in these type of things, is tell the whole story. The next thing we look at is page 4. And we look at lines 2. I want someone from the Department of Health and Human Services, Behavioral Health, evaluating my mental health. The same day I want Sarah Brady and Gabby Giffords doing it. You got no chance. Because there are some people that think the mere thought that we love guns is wrong. And particularly in the medical community, there seems to be a high number of those individuals. But here's what I'm asking myself as a practical matter, and it goes back to money. And a lot of these people don't have money. If we want an independent psychiatrist to evaluate our client and to say in open court, with essentially their licenses on the line, that they're not going to act in a manner dangerous to public safety, I'm going to suggest a couple, 3 things will happen, and I will bet a nickel on it, and I rarely bet my hard-earned nickels. And that is that somebody who's anti-gun, trying to shut down the gun people again, are going to go to the malpractice carriers that write malpractice insurance for these psychiatrists and psychologists, and they're going to ask a question on their malpractice renewal. Do you do these types of hearings? And they're either going to refuse to insure them, or they are going to escalate their rates through the roof.
Because if you're an insurance carrier who tends to be cautious and wants to make a lot of money, ask yourself what you're going to say to your friendly psychiatrist who is now writing evaluations and going to court and testifying as an expert witness that you believe these people are now okay. I think that's a huge thing. So how many psychiatrists and psychologists are we going to be able to find who are going to work for us and testify, and at what price? That's one thing. The next thing that I think is really problematic on page 4 is lines 11, 12, and 13. And they want the court to review the circumstances, minimum mental health, and any criminal record. So you're not asking the court, actually you're not mandating that the court can review only this instance that brought them there. You're letting the court review their entire criminal record. You're letting the court review the reputation and these two words here, character witness and character evidence. Lawyers go by the rules of evidence, and a lot of people don't know by the rules of evidence, but the rules of evidence are all these court rules that allow what comes in and comes out. And character and reputation evidence, with certain exceptions, are like the things. You try and bring those in, and everybody's on their feet going, that's reputation, that's character, that's propensity, with exceptions. There's always exceptions. And that's what you're going to bring in. So are we going to have swearing contests here, where if I can line up 10 people that says I'm a good girl now and I'm all better, and you can line up 50 that say I'm still some crazy old woman, does that mean I don't get my gun rights back? I mean, really, what are we looking at here? And it's just really, there's no specific times about how quickly they have to have these hearings. There's no specific limits on how long they can be. Judges want to rush things in and out in 15 minutes, short on court time. I sometimes want 3 days for a hearing to bring an adequate record forward. We don't have any specific timelines. The other things that courts say all the time, in all fairness to them, is these are statutory things. We have to have this hearing, and this hearing within this many days. Anything that's not statutory, you get pushed out in the weeds, because we don't have to have your hearing within days. So what are we going to have here? 5 years later, we get a hearing. 1 year later, I don't know. Will that be enough stress on someone who's trying to get their firearm rights back? I don't know. The other thing that you really want to look at, which is laughable in a black humor such a way, is page 4, line 18. If the final court order grants relief, the court shall, as soon as possible, request that the NICS entry be redacted and shall notify the United States Attorney General that the basis for the record being made available no longer applies. That's not how we do things now. Right now, they have, in New Hampshire, they report it through the State Police Criminal Justice Information Services, and I've asked 1 million times over the past 20 years if data is exchanged hourly, daily, by the minute, every 24 hours. I have never been able to get an answer. So how frequently that data is exchanged, I do not know. I would love to know. I've never been able to learn that. But the bottom line is, I've got to tell you, if you sit at a court sometimes and a DVP comes in, they are at that fax machine faxing over, taking the guy's guns. They're doing that in record time. And I've seen them be not so quick when they're dismissed to take them back. So the question is, when they say as soon as possible, we don't have a timeline here. If you don't have a timeline, you could press that little fax button a minute before. Why can't you press that little fax button or electronic thing in a minute now? So I think that's going to matter. But again, what's really huge is, are these public or private? When you appeal to the Supreme Court, which is line 20 on page 4, if you're denied, I don't know if anyone has talked to the court about this, but the Supreme Court shall review the case de novo and has the discretion to review additional evidence. The Supreme Court is not a trial court in New Hampshire anyhow. It's an appellate court. I don't know if anyone's talked to the court about how they're going to handle this. And again, we're going back to, are these public or are these private? As we know, juvenile and certain other matters are private. They're closed. Literally, they have the bailiffs at the door. You're not coming in if you're not a part of it. When you look at page 425 through 33, I've addressed, and I think it's huge what the ATF has done, and that alone should give everyone pause to say, do we want to go down this path this way? Because we really can't trust them. And it isn't just me with my distrust for them. We have years and years of practical actions that they have taken and things they have done where they have changed their mind to say that we have to know that their word is no good. Part of the amendment still, from what I can see, still treats the mentally ill person that they can't live with other people that have firearms. That's, again, the huge problem. And I don't see a change in the amendment. I see it still being set that way, which again restricts how many people they can live with, or the people they're going to live with have to be willing to give up their firearms. And I don't know, even my best friends or whatever, if I'm willing to give up my firearms to give them a place to live. Maybe I'll pony up some money from an apartment for them. But I think when you look at this and you look at the standards, it's almost like a popularity contest to get the rights back. And more importantly, there's not a timeline. This is another thing that's hugely important. Courts do not have, with rare instances, a time in which they have to issue an order. So if you look at the New Hampshire Supreme Court, at the U.S. Supreme Court, it's not unusual that they will hear a matter and they won't issue a decision for 6 months, a year, year and a half. And that's their right. There's no timeline. I don't see a timeline in here. So you put your evidence before the court, they can take a year to decide. They can take however long they want. That's huge when you're the person waiting for your rights. So you have to ask yourself, I always put myself in the shoes. If I were the person going through this process, how fair would I think it is? How well would it address my needs? And I respectfully say it wouldn't. But I think the other practical thing that needs to be done, there has to be a list of licensed psychiatrists that we think would be acceptable to courts to opine pursuant to page 3, lines 1 through 6. And ask how many of them would be willing to do these type of exams. And once we see that list, I can tell you from my experience, there was only a couple that I think I could call in this state, and one of them, unfortunately, is deceased, that would give my client a fair hearing, that would be objective, and that didn't hate guns, and that would make a professional opinion about whether or not my client should have guns. And so I just respectfully say to you that even if you're for this concept, which I'm not, and for this process they want to do it, this is not the vehicle. It's deeply flawed. And I'm happy to answer any questions I can for anybody.
Thank you, Attorney. I just wanted to ask one question just for clarification. When you were speaking of whether it would be an open or a closed hearing, on the very first sentence on the top of page line 2 on the original bill, where it says notwithstanding any other provision of law, including the requirement of a closed hearing and file under blah, blah, blah. Is that what you referring to, or is that something different where you weren't able to find that?
Let me, you said we're on page...
The very top of page 2, the very first sentence.
Notwithstanding any other provision of law, including the closed hearing. No, I'm sorry. I was referring to when the person's attempting to get their rights back.
Okay.
This is the process there. And even then, I see problems there, but I was trying to highlight what I consider to be the largest problems. If I were doing what I call a proper job, you guys wouldn't even get dinner. You know what I'm saying? In other words, I would go through this and really, really what I call bird dog and do a proper lawyer job. So I'm not going to represent that I did a proper lawyer job on this. I hit what I called the biggest things that I think any one of them alone should make this bill fatal. It should not go anywhere. But with all of those, without even me going into what I call the minutia of it even more, it's just got some mechanical problems.
Representative Prue. Thank you, Attorney. There is a lot to unpack here, without a doubt. Thank you.
Yeah.
For, I don't see any questions. Thank you very much. Stop. Susan Stearns.
Like I won the lottery being called. Good afternoon, Madam Chair, honorable members of the committee. For the record, my name is Susan Stearns, and I serve as the Executive Director of NAMI New Hampshire, the National Alliance on Mental Illness. I'm a resident of Samberton, and I have family members who live with mental illness. Indeed, I'm not a lawyer, I'm not a doctor, I'm first and foremost a mom. I do want to say on behalf of the NAMI New Hampshire family, our staff, our volunteers, and the folks we serve, how incredibly saddened we were with the events on November 17th and the loss of Chief Haas. Many of us knew him. Indeed, I've heard from so many family members about how caring and kind he was to them when they would visit their loved ones at New Hampshire Hospital. So on behalf of NAMI New Hampshire, I'm here to offer testimony in what I would call cautious support of HB 1711. There are indeed several key provisions in the bill that we feel are critical to preventing discrimination and protecting the civil liberties of people living with mental illness, as well as helping to ensure the safety of both individuals and law enforcement. According to the National Institute on Mental Health, 1 in 5 Americans is living with a mental illness. 1 in 5. The vast majority of people living with mental illness get up in the morning, put their kids on the bus, go to work, come home, make dinner, help the kids with homework, do the laundry, go to bed, get up and do it all over again. Given this, it is critical that the language in this bill limits who would be prevented from purchasing a firearm to individuals who have been found to be a danger to themselves or others after probate commitment hearing, and to people who may have been found not guilty to stand trial, but who have also been found to be dangerous to themselves or others. In addition to those conditions, at NAMI New Hampshire, we feel strongly that several provisions that are in the bill and that appear to be in the amendment as my first read through, that are really essential to its fair and appropriate implementation. These include that the report made to the NICS system be made by law enforcement or the judicial branch in order to protect that therapeutic relationship between providers and patients. That there is a process by which a person can petition the court for relief and to have their rights restored, and that any removal of firearms should be done in a way that limits engagement of the individuals and law enforcement in order to avoid dangerous confrontations. The reality is that for many people, the initial diagnosis of a major mental illness is a crisis. Yet treatment works, and making sure that people understand that there is help and hope is a critical part of the recovery process. This bill, as written, helps ensure that people who have been determined to be a danger to themselves or others do not have access to firearms when they are unwell, yet does not permanently deny them a constitutional right and offers the promise of recovery and the ability to live a full life in the community. On behalf of the nearly 44,000 folks we serve each year, we ask that you ensure that any bill on this matter on which you vote ought to pass addresses the concerns we have raised and protects the rights of Granite Staters with mental illness. And I thank you all for your service and your dedication.
Representative Psychiatric.
You said 44,000 people you represent. Who are these 44,000?
We served last year nearly 44,000 individuals.
Give me the demographic of what that looks like.
That is individuals who are impacted by mental illness. They could be living with a mental illness. They could have a loved one who has a mental illness. It also includes people who may have lost someone to suicide. It also includes people who may have been impacted by co-occurring mental illness and substance use disorder. It is a broad array of people who are impacted, as we know. And I don't think there's any one of us who is not impacted in some way in our personal lives.
Thank you very much. We have 2 cards left. So if you are holding on to a card, now is the time to turn it in. Because after these guys are called, we will be closing this public hearing. We still have one more left after this. Jeffrey Fetter. Did I say that right? Yeah.
Thank you, Madam Chair, members of the committee. This time, as I come before you, I am representing the New Hampshire Psychiatric Society and New Hampshire Medical Society. I am so glad to be able to testify today because I think this is important legislation on an issue that I've been thinking about for a long time. This bill is tailored to New Hampshire's approach to mental health law. Rather than targeting the mentally defective, as the Brady Bill does, this bill uses procedural triggers for legal events that demonstrate a patient's dangerousness. This approach is important to minimize the stigma of people with mental illness. Advocates often point out that people with mental illness are more likely to be victims than perpetrators of violence, and this is true, initially proved in the 1998 MacArthur study and replicated several times since. But I think we can be nuanced in how we talk about this. Patients are more vulnerable than they are dangerous over time, but there are such things as behavioral crises, and that is why psychiatric hospitals exist. There have been a number of objections raised I'd like to briefly address. One is the idea that because of the availability of guns in our society, that this bill would do no good. I feel that potentially is an instance of stigmatization, the conflation of the mentally ill with criminals. Most patients who come through our hospital are not criminals. They would not know where to go to pick up an illegal gun any more than any other person without a mental illness who's not a criminal would. The objection's been raised regarding reluctance to pronounce a person cured. When I am done with my testimony, I'm going to pass out to you a resource document from the American Psychiatric Association from 2020 regarding to restoring access to firearms. Excuse me. This document provides guidelines to allow psychiatrists to have a framework and a standard of care for which to perform these evaluations, a resource document to refer to and to allow the judge to understand the limitations of their evaluation, and recommendations of how to proceed with that evaluation. Moreover, as I suppose everyone knows, doctors take calculated risks all the time. Every time we discharge a patient from the hospital, we are taking a calculated risk to society and to the patient and to our liability. That is not something that we are totally averse to. We have to do that. That's part of our job. And I might add that if one were to do, as a psychiatrist, if you were to do one of these restoration evaluations, you would be doing it as a forensic evaluation. You would not have a doctor-patient relationship with the patient the way that this bill is written. Therefore, you would not have malpractice liability. You would actually not need malpractice insurance to do a forensic evaluation because by definition, they are not your patient. Some objections were also raised to some of the language on page 3, 13 to 15, and also the language around de novo review by the Supreme Court. All of that was carefully selected language in order to meet the ATF's requirements to take a patient off the NICS list. If it were not there, and it's not there in current New Hampshire law, they won't comply with a request to take the patient off the NICS list. We thought this through. This is designed to work, to protect the patient's right to be restored. SB 1711's intention is to prevent events like what happened on November 17th, 2023. You've already heard some accounts of that, so I'm not going to go through my account. It'll be in my written testimony and you can read it. It's a little different, but it's always the same. But I do want to talk a little bit about the aftermath. Since November 17th, there have been both expected and unexpected fallout. There's been patients who have been stabilized for long years and now have lost many of their gains. There's staff who have had to take time off to seek help for the stress of living with what they have seen. For 3 of us, this was our second active shooter event. There was one in Dartmouth-Hitchcock a few years ago as well. For me, I was deeply angry. Angry that I could not help a man who was down in my own hospital. Angry that a man who honorably served his community would lose his life and his family lose their time with him. Angry that we had not somehow been able to prevent this as a hospital, as a mental health system, or as a society. Angry that we've spent years trying to build this hospital into something good, where people with mental illness can find care, where families can feel comfortable leaving their loved ones, where people can spend a productive career advancing the field and doing meaningful work, and then to think that on November 17th, so much of that was lost, and that perhaps it could have been prevented. 2 psychiatrists and a judge had determined that this shooter was dangerous, if you count the IEA, an additional psychiatrist and judge. His guns were seized, but there was no system in place. But there is a system in place to ensure that he would not be able to buy another gun. But New Hampshire had no way to report this information to that system. HB 1711 allows us to join the majority of states which do. You can't help but relive it. From formal event reviews, reminders around the hospital like signs and cards, well-meaning friends and family who want to support you. Vivid memories come to mind every day, remembering the surprise of the thought, I could really die today. The helplessness of being trapped, and the guilty worry, I hope I'm doing everything I can to not let my people down. And yet the very next day, with the Franklin shooting, the world had already moved on. I am a psychiatrist. I hear stories every week where any reasonable person would say, well, that guy shouldn't have a gun. Where a patient's family member would thank you for making sure they can't have a gun. Where patients themselves, later, in a different state of mind, would be grateful that they couldn't buy a gun in their darkest moment. Please vote ought to pass on HB 1711 and give us this tool to keep our patients and the public safe. I'm happy to take any questions.
Psychiatric.
This, Madam Chair, you may rule this question out of order, and I'm happy to. No, I'm going to ask my question. You can stop me, but I'm going to ask my question. The players are here. The bailiff at my court is armed. How come if you've had 2 incidents at the hospital, the chief was not armed?
I'm here speaking for the Psychiatric Society. I'm not authorized to speak for DHHS or the Department of Safety. Okay.
Thank you very much.
Thank you.
Representative Hall. Ladies and gentlemen, this is our last card. If you have a card, turn it in. Okay, that's your warning.
Thank you, Madam Chair. Representative Hull, serving the towns of Dunbarton, Hooksett, Allenstown, and Epsom, here in opposition to House Bill 1711. I am speaking as the bill was introduced. I understand that an amendment may have been proposed. I have not seen the amendment. I cannot speak to the amendment. I will speak to the bill as introduced. If one of you would kindly get me a copy, I would like to review that. Secondly, my condolences to Chief Hoff's family. We lost a public servant that day. I think it's a real tragedy that we're going to nickname a bill after him, because every law enforcement officer that I know carries privately because they understand the society that we've come to live in. And it would be really a real tragedy if it was the state that denied him the ability to protect himself and the others in the hospital that day. I really think that this committee should do the investigation to find out why a former law enforcement, in this case, the chief of police, was disarmed when managing the metal detector and being the first primary defense for the hospital. That alone should be the only thing that comes out of this bill, is to find out why we disarmed a public servant. His family is owed more than we're going to give them, because he lost his life that day because he couldn't defend himself. Next, I had the chance this past fall to learn a lot more about mental health than I ever wanted to. A dear family member had a mental health crisis that I hadn't expected. I learned a lot. Learned that diet, actually, believe it or not, what you eat is highly tied to how you do mentally. There's a big understanding of the gut mental health link. Apparently 50% of epilepsy cases can be solved just by changing someone's diet. I had no idea. I learned a lot. So with that said, we do have a mental health crisis in the US and in New Hampshire. We need to do something about it. Changing the diet is clearly a first step. But these are not violent patients for the most part. There are exceptions, but I want to be clear in my testimony that the vast majority of people that have mental health issues are not violent. Okay? There are exceptions to that. And what this bill will do is allow those that are exceptions to go into society unrestrained, because we put a piece of paper and says, well, they're not going to buy a firearm. Timothy McVeigh was not ruled a mentally handicapped or deranged individual, but he managed to take fertilizer and diesel fuel and end the lives of over 160 people. These people need our help. They don't need to have their firearms restricted. That's not the solution. The way we help them is to give them the residential care that they need. Next, I want to report on NICS, since NICS seems to be the foundation that we're going to, the magic bullet, the magic silver bullet, we're going to solve this. Paragraph 1 on page 2, right? We're going to be entered, these names are going to be entered into NICS indices for those who for those found by the court to be a danger to himself or herself or others. In 2018, the Government Accountability Office did a report. I have sent this to all of you via email. I would ask that that be entered into the file, because I think it's important. What the GAO found, the Government Accountability Agency, in 2018 was, quote, few individuals denied firearms purchases are prosecuted, and the ATF should assess the use of warning notices in lieu of prosecutions. First, it is a federal crime to knowingly fill out a Form 4473 as a prohibited person. There were 8.6 million federal NICS transactions in 2017. There was 111,000 denials. There was 12,000, roughly in order of magnitude, investigations. And would you believe there was 12 prosecutions? Say that again. 112,000 people who were denied, 12,000 who warranted an investigation, and 0.1% of those, 12 people were prosecuted. Now, this is a felony level offense, and we're saying that this is the magic cure to the issue at hand. I think we can do better than that. I think we should first find out why the chief was disarmed. This bill should be completely rewritten, and we should find out which state agency prohibited him from protecting himself. We owe that information to the family. We also know that the NICS list is not being managed well based on what the GAO found. It is not the solution that everybody thinks it is. So just because names get entered doesn't mean that people are actually prohibited. And those that are prohibited, okay, if they were truly prohibited, no one's bothering to do any prosecution. So it's not going to solve anything real. We also know that if you are prohibited by a federal agency, and I don't know how this ties into this bill, this is not my area of expertise, either in law or medical, but if the VA hospital were part of the process and they were the agency that actually was part of the recommendation by which you were reported, there might not be a way to get off through a state level form, as someone mentioned before. That means we put our veterans at a disadvantage. I truly want to solve abuse, suicide issues. We've seen a lot of suicides. That's unfortunate. Miss Fallon, who's a state employee, sends out a monthly report on the number of opioid overdoses. I would encourage you all to get that. It's a good report. The last one I have is from early January. We had 201 people who died of fentanyl last year. Now, I'm not a drug user. I don't know that many people who are, but I don't think fentanyl is high on the list because everybody knows the real consequences of using fentanyl. Okay, that was fentanyl alone. That wasn't mixed with some other drug. That was fentanyl alone. These are people who have given up on life and are choosing to end it. If we truly want to solve suicide, let's look at the predominant killer in the state of New Hampshire, which is opioid abuse, not firearms. I would ask that you would find this bill inexpedient to legislate. I do think this committee should call for an investigation of why Chief Haas, was unarmed when he was providing security detail. With that, I'll end my testimony. Thank you.
Any questions? Thank you, Representative. I'm closing the hearing on House Bill 1711. And you've all been very, very patient, as all of our members. And I do need to let them have at least a 10-minute bio break. We will come back. We will hear the last bill of the afternoon, which is House Bill 1701. And Representative Muse, if you could just give me a second so we can figure out, before you guys all run out of here, we are execing some of the bills this afternoon. We have to. We're here. We got to do it. So do what you need to do for 10 minutes. Those of you that have been here for the duration of the day, once again, we thank you for your patience. We've also been here for the duration of the day. We understand. With that being said, we are on our last bill. We do have quite a few people that would like to testify, and in the spirit of giving everybody their chance to be heard, I do not have intentions of limiting testimony, but I would ask that when you do present, please just be very specific to the bill itself, and then we shouldn't have any need to have to limit any testimony. With that, I will now open the hearing on House Bill 1701, and we recognize Representative Mannion to introduce his bill.
Thank you, Madam Chair, members of the committee. My name's Tom Mannion, representing Hillsborough 1, the town of Pelham. This bill is also a result of a constituent request. Its purpose is to annul involuntary commitments of individuals that have been deemed potentially harmful to themselves and required psychiatric treatment. And to be abundantly clear, this bill specifically excludes commitments as punishment for crimes pursuant to RSA Chapter 651 as being eligible for the annulment. There are those in society that go through life experiences that they are unable to cope with. Trauma, grief, devastating financial problems. The list is extensive. In some instances, these problems lead people into a dark place where the state must intervene to prevent the worst from happening. Rehabilitation will take time, but we are resilient, and many people can bounce back from what could have been another tragedy. However, the stigma of receiving that care follows you for the rest of your life. This bill creates an avenue for people to petition the court after enough time has passed to have the commitment annulled and treated as though it never occurred. I remember when I enlisted in the Marine Corps in 2004, despite the fact that they were waiving all kinds of prerequisites, the recruiter was extremely inquisitive about whether I'd received any kind of psychiatric care, as it would be a disqualifier for enlistment. It's understandable at face value, but implies that rehabilitation is impossible, which to me is a discredit to the mental health profession and the resiliency of the human mind. In a somewhat parallel path, the NICS background check, which I've stated before this committee violates our right to not self-incriminate under the Fifth Amendment of the United States Constitution, also requires divulging involuntary commitments. While the ATF, which shouldn't exist, has a mechanism for relief from disability, we do not qualify and don't and shouldn't submit names to them in the first place. I believe this bill, similar to our cannabis annulments RSA, serves as a clean path to keep the federal government out of this intimate matter and allows a recovered individual to regain their rights. I ask that the committee vote OTP on HB 1701, and I'm open to questions.
Thank you, Representative. Can you maybe just give us a little bit of a synopsis of what this bill does?
Yeah, so the bill, it allows for annulment of involuntary commitment as long as it's nonviolent, right? So there's the punishment section where if you're committed for a violent crime to a psychiatric care, all of that is excluded. This instead allows you to annul it and treat your commitment as if it never happened, to include, like, if you were to approach a military recruiter, you can treat it as though it never happened. You could be like, I'm fine. And when you fill out the NICS background check, there's also the checkbox, like, I've ever been committed. You could say no, honestly, because as far as our law is concerned, it has been annulled.
With the annulment. Okay,
Yes.
Thank you very much. Representative Psychiatric?
I'd like to ask you about Romans 7. I want to be sure I understand it. A journalist or reporter shall not be subject to penalties for broadcasting that a person has been involuntarily committed subject to a commitment order that has been annulled, including the content of the record. Does that mean that the reporter is free to say this person has an annulled record and it contained the following information?
When I filed this, the OLS had asked if I wanted to mimic exactly like how the cannabis one had been, and I believe that's there to just kind of make it so if a reporter ever reports on it, they're not guilty of any crime for divulging the information. Like, I'm assuming if they got a hold of the information, they may have got it through nefarious means. There may be a criminal thing there, but
if I can follow. So that means that while it may be public, they can broadcast it as public information. Nothing can be done legally about this. They're
To the reporter.
subject to it. They can get their job, go in the Marine Corps, do whatever.
Sure.
Even though this is known, it's been annulled.
I would say, yeah, under the state statute, like it shouldn't concern. As far as the law is concerned, it didn't happen, right? That's the purpose of annulment.
Representative Muse?
What would you consider your level of expertise to be with issues like voluntary and involuntary commitments and discharges and annulments in the state of New Hampshire?
I don't have any expertise whatsoever. My background's in software, and I come
Thank you
from
very
a Marine Corps military background.
Anybody else? Thank you very much, Representative.
Thank you.
Representative Reed? Representative Reed?
I will do my best to answer questions afterwards. This is going to be a little difficult. For the record, my name is Ellen Reed. I represent Rockingham 10, that's Newmarket and Newfields. You may be surprised to see me as a co-sponsor on this bill. It is odd. I entered as a co-sponsor with a very clear agreement with the prime sponsor that I would come and testify that I'm not okay with the current language as it is written, and I will not support it as currently written on the floor, but it does need an amendment, and I do think with the amendment it is worth supporting, and I will tell you why. First, I need to state, because one of the rights, the main right probably that's being restored here is the ability to own a gun. I need to state my position generally on guns. I see them as a tool that hopefully you don't ever really need, usually. I think people who are obsessed with that particular tool are kind of weird. However, there are proper uses for that tool. And I also taught American government at college for 4 years, which meant I taught the Constitution. So the other side of that is the Second Amendment does exist. I understand it exists. I understand why it exists. And when I taught that, I would frequently show my students footage of Tiananmen Square and unarmed people being mowed down. I will say also that the Supreme Court has backed up the meaning of the Second Amendment because it does refer to a well-regulated militia. However, just as everybody in this room, I'm sure, would not question the right of a sovereign nation to defend itself, it turns out that that right, as Supreme Court has stated, is built on the inherent human right to defend your own self, your own body from harm. And so therefore, my position may seem nuanced on guns in general. So as I said, I signed on to this bill specifically that I understand that the language says that if it's somewhat, that the rights are restored after 5 years after an involuntary commitment, unless the person pled guilty by reason of insanity to a violent offense. I think that needs to go a little bit further. And actually, no one who was involuntarily committed in relation to any violent offense, whether they pled not guilty by reason of insanity or not, should be excluded from this restoration of rights. If there was a violent offense committed, you should not be getting your firearm back. However, and this is where I'm going to get into my personal story, the vast majority, as I understand it, of involuntary commitments across the country, and I cannot speak specifically to New Hampshire, are 72-hour holds after someone has tried to kill themselves. I've actually told some of this story before in my first term in favor of a gun safety measure. And I think it's funny, I have to tell the same story kind of almost on the other side. So my story is when I was 18 and I didn't have a lot of social education, I didn't really know a lot of things about the world. I got involved with my first major boyfriend who turned out to be extremely violent. For a year and a half, I was beaten repeatedly. He held me captive for 3 days in an apartment. He hit me with a car. When the cops saved me from one instance, they said it was the worst case of domestic violence they'd ever seen where someone didn't die. And if I didn't leave, I would definitely die. This went on until actually he had a warrant. He ended up with a warrant, and I got away from him in a relationship sense, but he continued to stalk me and send me threatening messages until there was a warrant taken out on him in the state, and then he was forced out of the state, and he continued, this was when I was in college, he continued to send me death threats to the point that, and apparently he had other warrants in other states as well, the FBI got involved. I literally had 2 FBI agents in my dorm room as a college student. And it didn't end until I moved to Japan for 3 years, where he lost track of me. During that time of a lot of upheaval and me not really, at 18-year-old me not really knowing how to handle things, in a particularly low moment, I took an entire bottle of my brother's Klonopin, which is an anti-spasmodic drug, because I just didn't know what else to do. My life had become so bad at the age of 18. And I was rushed to the hospital. Apparently, they couldn't find my blood pressure. Apparently, my temperature was 84. And the point of all this is that I was put into a 72-hour involuntary commitment because I had tried to kill myself. The irony is, I get through that, I get away, I go to Japan, I come back to the States, I get my master's degree in New Hampshire, I have this kind of much, much, much better, healthier life. And after 11 years, he found me and he started sending me threats again, to the point regularly, to the point that the police officers in Newmarket had to get a warrant for his phone records so that they could find his location to deliver an order of protection against him. It turns out he was in Texas, by the way. So at that time, I was scared and I went to go shop for a gun, as one might do. And I personally, like I said, it's a tool. I personally don't like guns, but at that point, I thought maybe I should be familiar with this tool. I ended up not purchasing one, but it turns out I wouldn't have been able to. So very ironically, the very cause of the reason I almost killed myself was the reason I needed protection later. And here at the age of 44, because of me being in a low point at the age of 18, I would not be able to buy a firearm today if I was honest on those forms. And that is why I agreed to co-sponsor this. Sorry, just give me a second. So to the point of suicide, 5 years is a good time to wait for someone after they've hit a low spot. And I know that mathematically because insurance companies, when you go to buy life insurance that would cover accidents and the like, they will cover suicide, but only after 2 years after you've had the policy, which means that the insurance industry has mathematically figured out that you are no more of a risk of suicide 2 years after being suicidal than the general public, because they are willing to pay you for that life insurance policy, even if you kill yourself, if it's been 2 years. Suicide is a problem. I don't think that we take away the risk of suicide simply by taking away what we think of as the means of suicide, because when people are determined, like I was in that moment, they will find a way. I think the way you deal with suicide is you provide people who are struggling with robust health care, mental health care, physical health care. I think you provide them with the basic needs of living and the tools to improve their lives. I think you provide them with compassion, stigma-free compassion, and dignity and support. And in case you think I'm speaking callously or without experience from suicide, that boyfriend that I mentioned, he ended up killing himself in 2016, the same year that I got elected. So he's no longer a threat in my life. My uncle also killed himself, but more importantly, I wasn't very, very close to my uncle. My dad, who I was very, very close to, killed himself when I was 21. And as much as I would love to have him with me today, he was very depressed. And if he asked me in the moments before he did that, give me another option, how do I end this suffering? I wouldn't have been able to give him one, because those supports that I just listed for you, we don't give to people. So even though it pains me to say, I do believe in people's bodily autonomy and I do believe in the right to die, because I don't have a better option for people who are suffering unless we provide them with health care. So if what you want to do is prevent violence, then you focus on the people who were violent, which is why I ask you to amend this bill. Focus on the people like that boyfriend that I had. But you don't punish people from having their constitutional and human right to defend themselves just because they went through a bad time 10 or 15 or 20 or 30 years ago. Sometimes to defend themselves from the very reason they went through the bad time to begin with. And especially when there's no evidence that they are any more likely to take their lives after 2 years, but in this case, 5 years. And with that, I will try to answer questions.
Thank you,
Oh, I
Representative.
shut everybody up.
Well, we generally try not to ask questions on such things. And Representative, just so you know, we try really hard to let it be the sponsor. If you think that an amendment is necessary, we would ask that you take care of the amendment and not ask the committee to do that. Just so
I'm happy
you know.
to offer my assistance. Thank you.
All right, here we go. Representative Hall.
Thank you, Madam Chair. Representative Hull, serving the towns of Bow, sorry, too many years of doing Bow and Dunbarton. Dunbarton, Hooksett, Allenstown, and Epsom. I would like to thank Representative Reed for her testimony. As I said in the prior bill, I had the chance to have a deep dive into mental health in the last 6 months. Not on my roadmap, not for me personally, but someone I care about. Learned a lot. I'm here in support of this bill, back to the same rationale that I gave before. Most of the people who have mental health issues are not violent. I had a discussion with an attorney several years ago. We were talking about, in broad strokes, that attorney's client, and that attorney's client basically couldn't fix an issue, but if it was tied to a crime, they could. So if there's a criminal element to this mental health adjudication at all, then you can get the whole thing annulled. But if there's not, you're stuck. Why does our society have a policy in place that it's better to be a criminal so you can clean up your record than having a health issue, in this case, mental health issue, so you can't? This seems like a clean, simple thing going forward. Representative Reed, I'd like to see her amendment in terms of excluding certain individuals. From at a high level, I don't see a major concern about that. I mean, if you have pleaded insanity to a violent crime, and that's how you believe at the time, or your counsel led you to believe that that was the right thing, and you're in the mental health hospital in Concord, I'm not sure upon release you get a chance to get that annulled. But outside of that small, narrow scope, as I said before, most mentally ill patients are not violent. Why are we giving, and in some cases, they may have been depressed. Rep. Reed nailed it, right? She had a bad experience, had about an episode of depression of some sort, and then that triggered her inability to defend herself. This happens a lot more often than we might think. And I would ask that you would pass this bill. I will gladly join if there's a subcommittee to work on the language. I don't know if this is an early bill or not. It's an FN, so it probably is. But no matter what, I'm willing to help shepherd this through because I think it matters. We should not require people to be criminals so they can get a record annulled. Thank you.
No questions? Thank you, Representative. Before I slaughter this name, is there a Cynthia here? If you could just, for the record, state your name since I was not able to do that, be awesome. Thank you.
I'm Cynthia Babonis, and I work at New Hampshire Hospital. And New Hampshire Hospital wanted to express and share some information regarding the bill. Just concerns in terms of the vagueness of the wording with regard to the annulment and how it might impact our medical record and our ability to provide continuity of care to patients admitted to New Hampshire Hospital or committed to New Hampshire Hospital who may in future days require another commitment because of a relapse in their condition. So on page 1, line 27, section 6A, the person whose record is annulled shall be treated in all respects as if he or she had never been involuntarily committed. We just would like to see some more clear wording around that to help protect our medical records at New Hampshire Hospital so that we can continue to have that information for people who've been admitted to us in the past. And then section 6C, court records and any medical records relating to an annulled involuntary commitment shall be sealed and available only to the person whose record was annulled, his or her attorney, or his or her medical professional. And just his or her medical professional is kind of a vague term as well. We're not quite sure what that means. Does that mean the medical professional at the hospital if you are committed in the future to New Hampshire Hospital? Does that mean your outpatient provider? Just some more clarity around that document, around those terms. Thank you.
If I may just add, I have a pink slip in too, but I can just quickly spit it out if you want. So the impact of the potential to have that language around having to, what is the language? The impact of 6A is that if taken at total face value, we would not be able to use prior medical records if the person needs to come in for another commitment, if the patient needs to have a dangerousness assessment, if the person needs to have a competency to stand trial assessment. All those records would be unavailable to forensic assessors and essentially really cripple their ability to render a informed opinion to the court regarding those types of questions. So that's a concern regarding our ability to execute RSA 135C.
Hold on one sec, Representative Newman. Could you just remind us of you said you did turn in a pink card?
I did.
Okay, could you just remind us of your name as we're just trying to get it.
I'm so sorry, Jeffrey Fetter.
Thank you. That's Representative Newman.
Could you just comment on how the wording might be changed, or what you think about how it could be changed to address that, where an annulment means it's gone and you can't keep it and there's absolutely no record. So how can you have an annulment without that?
I don't have language at the top of my head, but in all respects needs to be narrowed.
Well, thank you very much.
Thank you.
Dr. Hannon's still here? He gone. Attorney Dean?
Thank you, members of the committee. I mistakenly understood that this bill was tied to 1711. I apologize. It is not. I'm very much in support of it, knowing that it's a standalone, or believing that it's a standalone bill, if that makes sense. So, yeah, just so the card can be corrected, I don't want it to. Thank you. And I apologize for making the mistake. This bill is a fabulous bill, and it's too bad that one of the sponsors couldn't hear me testify, because I think all of her concerns would be allayed. And here is why. There is already massive provisions in the current annulment statute, which is RSA 651.5, that solves, I believe, all of her concerns. And specifically, I would direct you to, but not limited to, RSA 651:4 5, Roman 3, sub number 2, sub the letter B as in boy, the letters H as in Harry, the letter I as in ice cream. And specifically 651.5, Roman 13, A through H as in Harry, and 651.5, Roman 14. There's many, many, many exceptions for all sorts of violent crimes and rape and robbery and, a giant list that I won't read to you that cannot be annulled. This statute or this bill would not change that. But I would just ask you briefly one thing, because I know it's the end of the day, so I'm not going to bird dog this one either. But I'm going to explain to you that if a person commits a crime and they're IEA'd, I can get their record annulled and get their rights back. But let me tell you what some mean police departments do. They deliberately get people IEA'd and do not charge them with a crime, even though they can charge them with several, because they know they won't be able to get their gun rights back. And I had a case years ago, and I called the chief and I begged him to charge my client with something, anything. He could even make it bad, and he had a whole list of crimes he could have legitimately charged my client with. He says, "You want me to charge your client?" I said, "I do, please." And he says, "Why?" My mistake was telling him why. He was like, "Absolutely not. It's a good thing to know." And I'm sure he passed the word along. I thought by being forthright and reasonable with him that I would get a good response. Well, that didn't happen. But here's the larger issue. We actually tried it. I still told the client, I said, "Listen, you're buying an expensive lottery ticket. We're going to go to Concord District Court. It's where it at Judge Boyle." And Judge Boyle said to me, bless his heart, he said, "Attorney Dean, can you show me any statute that gives me authority to do this?" I said, "I can't, but it's plain old wrong, and it should be covered. We can find a way." And he was like, "Yeah, nice try." And so my point is that if you commit a crime, any crime, be it large or small, absent rape, robbery, and a whole bunch of crimes, you can get your record annulled and your gun rights back. But if you just have a really bad day, you can't. And that's just plain not fair. So I respectfully say this bill should be ought to pass. And I can answer questions, and you say, "How can this be? That can't be right." And the answer is, it's not right. It's the way it is. And so this bill, I think, would remedy that.
Thank you. Are there any questions? We're all set. Thank you very much. Paula Mattis.
I'd like to say good afternoon, but I think we are now in evening, so I want to thank
We're troopers.
you all. Yeah, you are. So, I do think this will be very brief. I'm Paula Mattis. I'm the Director of Medical and Forensic Services for the New Hampshire Department of Corrections. With me is Jane Graham. She's our Strategic Communications Administrator. We are representing the Department of Corrections in opposition to HB 1701. I wish there weren't speakers between us, but I'd like to piggyback on what New Hampshire Hospital said with regard to some of the definitional matters pertaining to this bill. We too don't understand what is meant by medical professional or who selects the medical professional. In some of these court proceedings, the courts appoint people to make evaluations. Is that person's medical professional? I don't know by looking at this bill. Another definitional issue is the annulment of, when we speak about annulment, we're talking about getting rid of something completely. But it's unclear to us, are we talking about annulling court paperwork, or are we talking about the attempt to annul medical records, which may be tied to those proceedings? As someone who's worked in behavioral health for a number of years, both at New Hampshire Hospital and now for the Department of Corrections, I can tell you these are very complex processes. There are a lot of things that happen from the point of time whether someone is receiving an involuntary commitment under RSA 135C, or the NGRI process, which is excluded from this bill, and that is very clearly stated. The other issue is that these processes are not pigeonholed. People can be over here, getting this. There can be multiple things happening at once. And all of these require people to be making decisions, specifically with involuntary commitments, with the NGRI process, the court. And with incomplete records, as any of you know, if you don't have all the information, it's really hard to make a decision. And this bill, though as well intended as it appears to be, will result, we believe, in confusion without cleaning up a lot of the language, without understanding the processes under which these decisions are made. It is incredibly important for those evaluating and treating people who may need help in these situations to have all the information at their disposal to make those decisions. Additionally, our fear is that with an absence of records or records that may be spotty as a result of the way this current legislation or proposed legislation is written, it could have a detrimental impact on future evaluations for anybody in our system. So it could result in dangerous persons going free. It could result in people who need mental health treatment not getting it or being released. I would encourage the committee to vote this inexpedient to legislate without much clarification needed around how we're going to manage medical records, healthcare records for the population being considered. And that's the end of my testimony, and we are happy to take questions if there are any.
Representative Jandron?
Thank you, Madam Chair, and thank you for taking my question. I took some notes, which is very unusual for me, but it sounds to me like the hospital, the state hospital, the secure psychiatric unit, and Department of Corrections still want to have access to the medical records for any involuntary commitments. Is that correct?
I can speak for the New Hampshire Department of Corrections, under which the Secure Psychiatric Unit, or SPU, is managed, and the answer is yes. New Hampshire Hospital, of course, representative, is under Department of Health and Human Services, and I believe they've left.
Thank you.
Representative Stone?
Thank you, Madam Chair, and thank you for taking my question. Typically, how long do you retain records under your current policies upon an individual leaving your custody?
For our healthcare records, the Department of Corrections has a 7-year window. I want to be clear. That means that if someone were released from our custody today, we never saw them again at the point of 7 years from today, we would destroy that record. We would shred it. It's confidential healthcare information. We would shred it. But we obviously have people in our custody who have been there for quite a while. Those records are from start to finish. We have people who are in our system 20 years. We have a complete health record for the care we've provided to them.
Follow
up.
So it's very common practice to see an individual that may be sporadic, but over a longer span of time, such as the 20 years, be a repeat visitor.
It is not uncommon, Representative.
Thank you.
Representative Newman?
Thank you, Madam Chair, and thank you for taking my question.
Of course.
Do you believe that this change, something like this to go, would it need a new definition or a special definition of annulment to be able to maybe carve out what you need?
A special definition of annulment. I think that is in statute already, and I'm not an attorney. I want to be very clear about that. So I think I'd want to defer that answer to someone who has more expertise and understanding in that part of the New Hampshire statute.
Thank you.
Thank you for your questions.
Okay. Representative Muse, did someone else? Okay. Representative Muse, followed by Representative Stone.
Thanks. What kind of problems do you think it would create to not have access to records like this for you?
It would be troubling from the perspective of not knowing the kind of history so that we can help people both in the, let me say it like this. A lot of the folks that come to us have long histories of either mental illness arising from genetic predispositions or from trauma, without having all the information so that we can understand what is baseline for them, i.e. what is to be expected on a day-to-day, or what has been helpful to them in the past, what hasn't been helpful to them in the past. That continuity of the record is critical. If you are in the position of doing an evaluation, either for something such as competency, which happens in our state, it makes for a better informed, more comprehensive evaluation if we know this person, if we have all the information. Plus, frankly, from just a human perspective, having people tell their story over and over again is not always helpful. It's very frustrating to people typically. It can trigger them. It can cause some more problems in terms of the immediacy of that. Whereas a good evaluator, a good clinician can look at the records and say, go through it and understand the person and pick up where the last person left off. So that continuity is critical.
Thanks for helping me understand.
I'm afraid that was a bit wordy. Thank you for being patient with me.
That actually is really helpful.
Okay,
Thank you.
It was very helpful. Thank you. Representative Stone?
Thank you, Madam Chair. And once again, thank you for taking my question. Dealing with secured psychiatric, you're dealing with mostly individuals that are found incompetent to stand trial?
That is not accurate.
All right. Could you give us a definition of the actual individuals that you house there?
The secure psychiatric unit currently, and I know many of you are aware this is changing in the future, but currently serves many masters. We are the inpatient psychiatric hospital. We're not a certified hospital, but that level of care for those people who are our residents, people who are sentenced individuals to the state facility. We also serve that function for the county houses of correction throughout the state. We currently do take transfers under current statute from New Hampshire Hospital for people they determine are beyond their level of care. We also take from people as necessary from the developmental services system who may need that level of care. That's a different state statute. There are 5 statutes that make provisions for people to be sent to us. And the last is rare, and it does occur, is the sexually violent predator law, 135E. You can find the references for that. But those are in very general terms, Representative, those are the 5 populations we serve at the Secure Psychiatric Unit.
Thank you very much for the clarification.
Thank you for your question.
Any further questions? We good? Thank you very much for your testimony.
We appreciate your time.
Mm-hmm. Just for clarification, Dr. Korn did leave. Okay. Okay. Ms. Hawkins?
Hello, good evening. My name is Andrew Rice Hawkins. I'm the director of Gun Sense New Hampshire, a project of Grant State Progress. Our organization has weighed in on state and federal firearms policy since 2009. House Bill 1701 seeks to establish a relief from disabilities program for people whose mental health treatment has ended so that they can restore their gun rights. While our organization supports that intent, we cannot support the process outlined in this bill. It is flawed, and it also does not meet the guidelines by the U.S. Department of Justice Bureau of Alcohol, Tobacco, Firearms, and Explosives to fully provide relief. By not meeting those standards, an individual who seeks and finds relief under the process outlined in this bill may still be unable to restore firearms rights at the federal level, and worse, may mistakenly attempt to purchase a firearm thinking they have satisfied the requirements and thus subject themselves to both legal and financial trouble. These are not new concerns. Our organization has testified on versions of this particular bill since at least 2014, and there's a reason why for the last decade this policy has not been passed in Concord, regardless of the makeup of the state legislature or the originating chamber. Instead, we support the process outlined in House Bill 1711, which meets the federal guidelines and adequately restores firearms rights for Granite Staters whose mental health crisis has passed. Here are just a few of the problems with House Bill 1701. It erodes the quality of the Relief from Disabilities program for people whose mental health treatment has ended. It diminishes the state's ability to determine when a person should get relief and does not provide the court with appropriate evidence to consider when making these determinations. Section 4 reads, when a petition for annulment is timely brought, the court shall require the New Hampshire Hospital or Secure Psychiatric Unit to report to the court concerning any other recent commitments of the petitioner and any other information which the court believes may aid in making a determination on the petition. No documentation is specifically required in statute regarding the initial commitment or treatment, including whether it is ongoing. Complicating things, Section 2 states a petition for annulment may be made 5 years from the date of the commitment order, not after it has ended. It also does not require that a mental health provider assess the person's mental health and suitability to possess firearms. It does not specifically require consideration of the person's mental health history or the person's reputation as developed through character witnesses or character evidence. House Bill 1701, Section 5 further reads, the petition shall be granted until upon a showing that there have been no additional commitments since the time of the commitment order that the petitioner is seeking to annul, I'll emphasize shall, or unless the court finds by clear and convincing evidence that such annulment is not in the interests of justice. Discussing only additional commitments gives no regard or conversation around ongoing mental health treatment and suitability. What we should be looking for is when someone has an absolute discharge, as is the standard established in House Bill 1711, which you just heard. Requiring the court to show by clear and convincing evidence, which is a higher standard, that the annulment is not in the interest of justice, puts the burden on the court without ensuring the proper documentation and expert input to ascertain that. If treatment is ongoing, that's one thing, but what if it is ended? In the absence of information here, or it is the absence of information here that is worrisome. The court cannot know what it does not know about the suitability of the petitioner, which is why adequate policies outline what must be considered in a true relief from disability program. This bill would not meet the ATF standards for relief from disability. The ATF form states that the ATF form that a state uses to certify that has established a qualifying mental health relief from firearms disabilities program makes it clear that the disabilities program must satisfy certain minimum criteria. I'm happy to forward a copy to the committee of what that form looks like. It's a 2-page form. Very clearly at the top, it says these minimum standards have to be met. Section 5 of that application states proper record. In determining whether to grant relief, the lawful authority receives evidence concerning and considers A, circumstances regarding the firearms disability imposed by 18 U.S.C. 922 G4. B, the applicant's record, which must include at a minimum the applicant's mental health and criminal history records. Mental health records and criminal history records. And C, the applicant's reputation developed at a minimum through character witness statements, testimony, or other character evidence. These are the minimum standards which other states with relief from disability programs meet in order to not endanger public safety or the safety of the petitioner by inappropriately granting relief too soon. We support having a process, and that's why we support the process outlined in House Bill 1711. We have supported that process for the last 10 years. We're excited that the committee is entertaining a bill that would include that. This process before you actually jeopardizes rights restoration, and we would encourage the committee to put your energy towards a bill that actually provides what you seek to do. I am happy to take any questions. Thank you.
Representative Selig.
Thank you so much. My question is merely functional. I'm a bit too tired to have taken notes on all of what you presented. I was hoping you could email us a copy.
I am more than happy to email a copy. I'll send a copy of the testimony along with that relief from disability programs and all the minimum requirements. And you'll have my contact information. If you have any questions, definitely happy to talk about it.
Thank you.
Thank you.
Thank you very much. So everybody knows it is here. We are on our last card. Attorney Andres, if there's anybody that has not turned in a card, now is the time to do it. Please correct the last name, as I am aware that I did not do a very good job.
Hi, everybody. It's Stephen Endress. I'm from the Merrimack County Attorney's Office. I'm an assistant county attorney. I've been a prosecutor for over 20 years. I'm sure you're all happy to hear from me last on a Friday on a noon bill. I do the involuntary civil commitments for our office under 135C, and I also do a lot of competency evaluations in litigation. I have two real concerns with the language in this as proposed. The first is paragraph 2, which is line 9, where it talks about no petition shall be brought until 5 years from the date of the commitment order. The difficulty with that language is that you can be committed to the state hospital for a period of 5 years. So you can have your hearing, spend 5 years in the state hospital, and then get out after 5 years. And the day you exit the state hospital, you could then file for an annulment because it's 5 years after your commitment. If the state hospital is reporting on any subsequent commitments, there wouldn't be any subsequent commitments because you literally would have been committed 3 days earlier. I would suggest to either change that to a much larger time frame after the date of commitment, or to change that from 5 years after the date of perhaps absolute discharge from the designated receiving facility, which would be the date that the New Hampshire hospital or whatever the designated receiving facility essentially closes your case. The other concern I have is on the second page, those first 3 lines in paragraph C of subsection 6, court records and any medical records relating to the annulled involuntary commitment shall be sealed. The concern I have there is I understand that this bill was essentially copied from the criminal statute. And in the criminal statute, it makes sense to seal court records because at this point, any one of us could walk into, Merrimack County Superior Court and say, I want to see State versus Jane Doe's file, and the clerk's going to hand it to you. And you can sit there and thumb through it and look at all those records. The same is not true for New Hampshire Hospital. Medical records are already statutorily protected. You can't just walk up to New Hampshire Hospital and say, I'd like to see Jane Doe's file. Obviously, they won't give it to you. There's some exceptions to that, but even if you are the caregiver that lives with Jane Doe when she's released, New Hampshire Hospital isn't going to give you her file without her consent, except under certain limited circumstances. My concern with sealing the court records, as people have alluded to prior, is that we use those records to help determine competency, to help determine sanity if people are raising sanity, to help determine dangerousness or mental illness if we're pursuing involuntary civil commitments. And I'd hate to have a situation where the Office of the Forensic Examiner or a doctor we hire in order to do an evaluation says, I can't do a full evaluation because there's a gap in medical records because they had been sealed due to an annulment. I'm happy to answer any questions.
We saved you for last just for that reason. Are there any questions?
I appreciate that.
It has been a very long day. It appears we do not have any questions. Actually, wait, don't leave. I do. You had mentioned, I was looking on page 2 and I thought you had said line 9, but I didn't see anything there about the days you were talking about.
Yeah. So the line 9 is the first page. Paragraph 2, first page, line 9, it talks about 5 years from the date of the commitment order.
Page 1, I'm sorry.
Page
Thank
1.
you.
Yeah. And then
Okay.
page 2 is the sealing of the records that I don't like.
And how long did you say? So where it says until 5 years from the date, what was your recommendation?
I mean, for me, I would probably either do that 10 years from the date of the commitment order or change it to 5 years from the date of absolute discharge from the designated receiving facility, which is where they'd be committed to.
Okay.
And I mean, if you're also interested in crossing out lines 6 and 7, it talks about proceedings initiated pursuant to 135-17A.
Mm-hmm.
There are no proceedings initiated pursuant to 135-17A. 135-17A refers back to 135C, so it's impossible to actually commit a person under 135-17A.
Thank you very much. That was helpful. Still no questions? We're good? All right. Thank you very much. Have a
you.
good weekend.
Thank you.
Is that it? Okay, seeing no further cards, I am closing the hearing on House Bill 1701. And we have we have 5 bills to exec. However, one of them we are going to just open and go into a recess. Representative Prue has an amendment that is not ready for us yet. So we just need to take a couple minutes here and decide, do you guys want to take 10 minutes, get something to drink?
The Dems are going to quickly caucus across the hall for 5 minutes.
Okay, so we are going to meet back in here. Let's call it 7 minutes. Give us 5 minutes to just chat real quick. We'll get back in here and we'll knock these out.
Thank you.
All right, guys, listen up real fast before I open any of these up. I have 2 amendments that we're going to pass out. I did not pass these out earlier just because there were so many papers being flying around. I didn't want them to get lost in the shuffle. The first one is an amendment for the cameras with the bridges bill, and we'll discuss it whenever we get there. And the other amendment is for the invasions of privacy. Again, it's what we discussed in committee with the questioning, so we'll discuss that whenever we get to it. So just so you guys know what both of the amendments are. Before you leave, Representative Roy has an amendment. We gave the amendment to his bill that we heard earlier. We passed that out, but he has another amendment here. We're not hearing this bill right now, but I still want to give the amendment because we have it. But before you leave, we'll give you guys that one just so they don't get lost. Okay. Everyone on the same page with that? Okay. So give us Representative Noel, if you'll pass these down that side. And Representative Crew, if you'll pass these down that. Yeah. The first one coming around is for the bridges. And now this one is the invasions of privacy. 1, 2, 3, 4, 5, 6, 7. What? If you would pass those down. Representative Crew. Thank you. Yes, thank you. Okay. Okay, ladies and gentlemen, I'm going to open, you guys all with me? We ready? I'm going to open the executive session for House Bill 1330, and we are going to go into recess on House Bill 1330. The sponsor has an amendment for that bill and asked that we wait until next week, but we did have it scheduled for executive session, so I just wanted to try to follow procedure as much as possible. So 1330 is in recess. We are going to open the executive session for House Bill 1025, and I will recognize Representative Reed to make a motion.
I motion to ITL.
I'll second that.
Representative Reed, would you like to speak to your motion?
Yes, I would. The House Bill 1025 would make it legal for someone to use derogatory and inflammatory words without any kind of consequences. We found that in the subcommittee, this would be very incendiary, causing potential violence and flare-up of the people being screamed at. So we decided we probably should ITL this. Thank you.
Thank you. Representative Prue, would you like to speak to your second?
No, I think she nailed that quite well. Thank you.
I would agree. I would just say that we did have a subcommittee on this, and the sponsor was not able to make it and didn't indicate if he was not going to make it. And we had the Democrats that were on the subcommittee didn't show up that day either. So Representative Reed and I spoke with Representative Gathright, and we made a recommendation of ITL without an official vote. Would anybody else like to speak on House Bill 1025? Representative Janvrin?
Thank you, Madam Chair. I just want to mention that part of my district is actually Hampton, which includes Hampton Beach. And if we were to pass this bill, it would have a crippling effect on the ability for Hampton Police and State Police and the Rockingham County Sheriff to enforce good order on Hampton Beach, which is at Family Beach. So I'm also supporting the ITL.
Thank you. Anybody else like to speak? All right, at this time, the clerk will call the roll. The motion on the floor is ITL for House Bill 1025.
Vice Chairman Rhodes, Oh, I
So that's okay. So I'm actually going to go last. So start with the next one down.
Representative Pratt,
Yes.
Representative Psychiatric. Yes. Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Newman.
Yes.
The clerk votes yes. Representative Selig,
Yes.
Representative Wheeler.
Aye.
Missing some people, so. Oh, and the chair.
Yes. Oh, Representative, wait, hold on, Representative Sue Newman. But
I apologize. I didn't put
We're
you
getting
in here
there.
in place.
It's okay.
What do I do with that?
do? So she is here for, who is she here?
Well, she's sitting in my seat because I'm over here. So.
Yeah, but who's missing from you guys today? For who? Okay, so when you would call Alessandra Murray, you are going to, where is she?
Oh, here she is.
Yeah, so instead of calling her name, where she at, you're just going to go like this, and then you write Sue Newman, and then just call on her name.
Representative Sue Newman. Thank you. Okay. $17 yes.
The vote is 17 yes, motion passes. Any objection to consent? Okay. I am closing the hearing or the executive session on House Bill 1025, and I am opening the executive session for House Bill 1260. And I recognize myself to make a motion of ought to pass,
Second.
seconded by Representative Murphy. And I also would like to introduce amendment or offer amendment, what am I at? 2024-0419H. And I will just speak to my amendment briefly. If you all remember, we held the hearing on this bill, and it was the invasions of privacy if the person was a minor that the privacy had been invaded. And one of the things that I would like to correct a little bit was Representative Muse had asked me a question when I was presenting the bill, and he'd asked if this essentially was an increased penalty. And I answered yes, because it is. However, what I didn't stress enough with that was the way the bill was written at the time did not offer any kind of, I should say wrong, and that's not really the right word right now, if the person that was being invaded was a child. And the bill originally was looking to make that be, a little bit more egregious. So yes, it does offer an increased penalty. However, children were not recognized in the first place, so now they're going to be. The amendment that we're offering will essentially, if it is a repeat offender, if it's a child. So initially it will be a Class B felony, but if it is a repeat offender for the invasion of privacy for a minor, it will be a Class A felony, which is basically the questions that we had during the hearing. Additionally, I just wanted to mention there were some questions around the sex offender list that had been discussed. I actually did go through with an amendment for that as well. And upon further consideration, we realized it really just was not the bill to put it on. And we thought that that would do better to just be a whole separate bill altogether. And we will explore that at a later time, but not with this particular bill. With that, I would ask or take any questions if there's any on that. Representative Selig?
May I second your amendment?
Oh, it was already seconded by Representative Murphy.
Okay, I
Yeah.
didn't hear that.
That's
I'm
okay.
sorry.
That's okay.
Just want to make sure.
Representative Bolden?
On the topic of the prior vote, are there not 18 people in the room currently? Did the clerk count her own vote?
Can we ask that after we're done talking about this bill? We'll double check it. We are missing, I think, 2 people, but yeah, just so we don't get confused on where we're at. Representative Wheeler, did you have a question? Did you have a statement? No? Okay. Everybody good on the amendment? Okay. So at this time, the clerk will call the roll. This is on the amendment for House Bill 1260.
Representative Pratt,
Aye.
Representative Psychiatric, Representative Prue,
Yay.
Representative Janvrin,
Yes.
Representative Mannion, Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Ray Newman,
Yes.
Representative Sue Newman. The clerk votes yes. Representative Selig,
Yes.
Representative Wheeler,
Yay.
and the chair.
Yes.
That will be 18. Then it passes.
The amendment passes 18-0, and now the motion is ought to pass as amended for House Bill 1260. The clerk will call the roll in 1 second. You seconded it. She seconded. Oh, Representative Murray, will you make a second, please?
Second.
Thank you.
Representative Pratt,
Yes.
Representative Sytek,
We.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Ray Newman,
Yes.
Representative Sue Newman.
Yes.
The clerk votes yes. Representative Selig,
Yes.
Representative Wheeler,
Yay, yay.
be 18.
Can I vote?
Madam Chair,
Yes.
thanks for bearing with me all.
Yeah, we got this. So, while I believe there was a point of order, and I should have addressed that right away, but we were in the middle of another bill, and I didn't want to get confused. So, Representative brought up that she thinks the count was off on our first bill, which was 1025, and the clerk will just let us know where we're at with that.
You are correct.
So the vote for House Bill 1025 is 18-0. And we are 18-0 on the amendment for 1260 and 18-0 on ought to pass as amended.
Consent.
I did on the first one. 1260 will also go on the consent calendar. Anybody opposed to that? Awesome. Okay. I will close the public executive session, Jesus, on House Bill 1260. And I will open the executive session for House Bill 1448 and recognize Representative Stone to make a motion.
Thank you, Madam Chair. I'd like to make a motion on HB 1448 to ITL.
Thank you. Is there a second?
Sure. I'll second that.
Representative Selig had her hand up. It's.
Somebody else wants to go?
I know. Representative Stone, would you like to speak to your motion?
I would. Briefly, I'd like to say that this bill has some good points. Unfortunately, we didn't get an amendment on it. And I know the discussion of the timeframes was also supported by the Department of Safety. And hopefully the sponsor will take care of that for next session.
Thank you. Representative Sella, would you like to speak to your second?
I agree.
Thank you, Representative Selig. Does anybody have any comments on Representative Wheeler?
Thank you, Madam Chair. I would just like to echo what Representative Stone said and say that if the sponsor is going to bring forward a bill and be offered the exact language for the amendment that he needs to fix it, I think it'd be prudent for that sponsor to address that and change it. And otherwise, we're going to have to ITL it, and that's what we'll do.
Thank you, Representative Wheeler. Representative Psychiatric.
We could have interim studied it too, but
He said we could have interim studied it as well. I would just like to say that during the testimony, I was a little bit concerned to think that there's possibly something that is sitting there that would prove somebody's innocence or guilt, and that it may be done away with for various reasons. And I actually would like to have seen an amendment as well. And one of the things that I really would like the members of our entire body to understand is, just with a lot of other committees, we hear a lot of bills, and we do our best to give every single one its due process and do everything we can to either kill it or to pass it. And it really just isn't something that we're able to take on to amend every bill that possibly could need amended. Representative Janvrin.
Thank you, Madam Chair. I agree. It is not the job of this committee to introduce amendments for a prime sponsor that said he would come with one. I would like to mention that procedurally, the prime sponsor of this bill could still come to the House floor with his amendment, amend the bill, overturn our ITL, and pass the bill. And if he were to do so, I would support his effort.
Thank you, Representative Janvrin. Anybody else like to speak on where are we at? 1448? All right. At this time, the clerk will call the roll. The motion is ITL on 1448.
Representative Pratt,
Yes to the ITL.
Representative Psychiatric,
yes.
Representative Prue,
Yes, please.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Muse,
Yes.
Representative Bolden,
Yes.
Representative Bradley,
Yes.
Representative Murphy,
Yes.
Representative Ray Newman,
Yes.
Representative Sue Newman.
Yes.
The clerk votes yes. Representative Selig,
Yes.
Representative Wheeler,
Yay.
and Madam Chair.
Yes.
All right, 18.
Motion passes 18-0. We are closing the executive session on House Bill, what was that? 1448. And I will open the executive session on House Bill 1217. And I recognize myself to make a motion of ought to pass. Seconded by Representative Wheeler. I offer amendment to House Bill 1217. The amendment number is 2024-0233H.
I second your amendment.
There's a second. Representative Janvrin seconds the amendment. If I may briefly, I'll just speak to the amendment. Again, during the public hearing, it seemed like that we had pretty much support from the committee on the bill. Basically, what we're trying to say is that the covered bridges are pretty much historical markers. They are used for great tourist attractions. So many things all the way around. When these bridges are destroyed or damaged, if there's any kind of recklessness involved, there's a great amount of commerce that is lost to the town, and there's nothing that the town can do to even try to recoup any of the lost damages there. What this amendment will do, that Representative Janvin had brought up, was actually just put a sign in front of the bridge within 100 feet to let the pedestrians, or I'm sorry, to let the drivers know that they very well could be being recorded. The one thing I would like to address as far as privacy, I know that comes up a lot. As far as a public road, I really can't think of anything that's more public than a public highway. And the other thing that this amendment does is, because so many of the roads are actually state-owned leading to these covered bridges, this is actually going to put that cost onto the state, and they will have to be the ones to put up the sign. Representative Janiver, would you like to speak to that?
Yes, as a young man, I served in the New Hampshire Conservation Corps in Cornish, New Hampshire, and Cornish is known for its Cornish-Windsor Bridge. And I remember that particular summer it was struck by a truck. They never found out who it was. It took them 7 years to raise the funding to fix it. And there was an argument, is Vermont responsible or is New Hampshire? So to avoid that, I think that it's good to have this bill. But the amendment, the reason for the amendment is I was here when the House, the Senate, and the people of the state passed Amendment 2B, which is the right of privacy. And if you go into a business here in New Hampshire and you're under video surveillance, they have to give you notice. So I think that this amendment accomplishes giving notice. And somebody asked me about the 100-foot. Why would you say 100 feet? Here's why. If I want to go and take a picture of a historic bridge, I don't want a picture of that sign. 100 feet away gives me room to get that picture without getting the sign in it. So that I fully support the amendment.
That was actually a great definition. I'm glad that you gave us all that insight. I didn't even think of that. Would anybody else like to speak? Representative Wheeler, do you have something you'd like to share with the rest of the class?
You can't, Madam Chair. Well, that is not what I was going to ask, Madam Chair. But I mean, if you're going to put me on the hot seat, I do just want to say that these bridges are such an important piece to New England's history. And when people think of New England, they think of these hidden bridges, these covered bridges, that picture of, the orange leaves with the nice bridge over it. And the idea that people would posit that they have the privacy to vandalize these bridges is absurd. So I liked what you said. No one has the privacy to be on a public road and vandalize it. And especially when it comes to our covered bridges, which are integral to the economy of our state and the tourism of it. I think if we're going to have cameras, and thank God we do, then we should use them to protect those bridges. So that's what I was.
Thank you, Representative Wheeler. You may need to say that on the House floor. Would anybody? Representative Newman.
I have nothing to add, and I apologize to the committee.
Does anybody else have anything that they would like to add? No. At this time, the clerk will call the roll. The motion is ought to pass for amendment 2024-0233H.
Representative Pratt,
Yes.
Representative Psychiatric,
Yes.
Representative Prue,
Yes.
Representative Janvrin,
Yes.
Representative Mannion,
Yes.
Representative Reed,
Yes.
Representative Stone,
Yes.
Representative Tenzar,
Yes.
Representative Muse,
Yes.
Representative Bolden, Representative Bradley, Representative Murphy, Representative Ray Newman, Representative Sue Newman. The clerk votes yes. Representative Selig, Representative Wheeler, Madam Chairwoman.
The chair votes yes.
And the vote is 18 for the amendment.
The motion now on the committee is ought to pass as amended. Do we have, I'm sorry, guys, help me out. Do I have to do a whole nother motion again? Yes. Okay, I make a motion to pass as amended.
The bill as amended.
I'll second it.
Seconded by Representative Janvrin. Any further discussion? No. The clerk will call the roll. We are voting ought to pass as amended, House Bill 1217.
Representative Pratt.
Yes.
Representative Psychiatric.
Which is Polish, yes.
Representative Prue.
Yes.
Representative Janvrin.
Yeah, which is German.
Representative Mannion.
Yes.
Representative Reed.
Yes.
Representative Stone.
Yes.
Representative Tenzar.
Yes.
Representative Muse.
Yes.
Representative Bolden.
Yes.
Representative Bradley.
Yes.
Representative Murphy.
Yes.
Representative Ray Newman.
Yes.
Representative Sue Newman.
Yes.
Clerk votes yes. Representative Selig?
Yes.
Representative Wheeler?
Yay.
Madam Chairwoman?
The chair votes yes.
18-0.
Motion passes 18-0. With that, I will close the executive session for House Bill 1217. 18-0. Is it, we all okay with the consent calendar? I will close the executive session for House Bill 1217.
And Madam Chair, I'm just wondering if we did consent on the previous bill. We
Yeah,
did
all,
that?
all of these bills are on the consent calendar unless anybody has a issue with that. Okay. With that, our business for the day is done. I would like to just take a minute and thank Representative Newell. She stepped up today. It was not, yeah. It was not an easy day at all. Brad back there held it together with our amendments. And thank you guys all very much. We just pounded out another, I don't know how many bills on the consent calendar, a little bit unheard of. So with that, have a great weekend, everybody. We'll see you next week.